They are not completing the objection.
All right, please.
Lord, serial number 64.
Yes.
Lord, serial number 64, may I make a mention?
Ah.
We have filed an IA for urgent hearing, my lord. Serial number 64, there is an urgency. It's the case of an e-commerce company to whom the it's a case of an e-commerce company to whom the postal department has denied services. We are suffering lot of
What do you
every day.
Matter is listed today.
It can be taken at 2:30 or 4 o'clock, my lord, today. Serial number
Matter is
64.
listed today.
Yes, my lord.
It will come up. Yes.
Serial number 64, my lord.
Yes. Yes.
Petitioner, my lord. Petitioner is the guarantor of the chit, my lord.
Huh?
The guarantor of the chit, respond number 3 is the chit company. Is the guarantor. Of the dispute is remitted the 3,50,000. Chit amount is 3 lakhs, 2 lakhs, my lord. Thereafter, after disposal of the dispute filed by the respond number 3, respondent official came to the petitioner fathers and collected the 2 lakhs, my lord. As per annexure statement, I produced page number 19, my lord. Page number 18. They have collected 2 lakhs from the
award is passed in the year 2020.
21 is paid 2020.
2017.
17. 20 is
2017 award is passed.
2020, 21.
Thereafter, you have filed an appeal.
Appeal also dismissed.
Appeal is also dismissed. Yes. What do you want now?
2020, 21 is collected 2 lakhs from the petitioner, my lord.
Appeal is also dismissed in the year 2023.
Last year, my lord. 23, I filed immediately filed an appeal.
Yaudre?
Petition. It's filed.
Annexure A is the order of the appellate authority, isn't it?
Appellate authority.
27/12/2023.
23. Immediately I filed an petition, my lord.
Immediately you filed petition.
Petition. Writ petition here.
February 2024. Why is it coming up as fresh matter now?
Fresh matter is Bandela Sami Avatin.
Ade Nivu file Mabut Arama Kutkondizira, you work Bartha, fresh matter.
Execution petition file Madida.
Learned AGA takes notice for response number 1 and 2. Issue notice to response number 3 to 7. Learned counsel for petitioner is directly to serve copy of the petition along with annexures on the learned AGA.
Dispensation of
yes.
R4 to 7 million. Notice. Notice dispense R4 to 7.
Yenike?
Is not a necessary party.
Who are they? They are the borrowers. You are the guarantor.
Is the guarantor.
Mata? How can you say they are not necessary parties?
Yes. Additional borrower.
Yes.
Pray for time, my last 1 week. Senior is out of station. 1 week time.
Yenike?
Idu year ಮಾಡಿ.
ಅಲ್ಲಮ್ಮ ಅರ್ಜೆನ್ಸಿ ಅಂತ ಎಲ್ಲ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾರೆ ಮ್ಯಾಟರ್ ಬಂದಾಗ ಯು ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ Consider representation for allotment of houses under Rajiv Gandhi Awas Yojana. Why are you asking for adjournment?
My senior is not feeling well now.
Learned Learned Counsel Sri B.N. Suresh Babu is requested to take notice for respond number 1. Learned Counsel Sri Karthikeyan, who was present in the court, B.S. Karthikeyan, who was present in the court, takes notice for response number
2, 3,
2, 3, 5,
6 and 7.
2, 3, and 5 to 8. Notice to respond number 4 is not necessary for the time being. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned counsels representing the respondents. Yes.
This is a case where I am the contractor of this to the second respondent has given a work for me to,
Residential Education Institute Society.
yes, my lordship.
Ah.
That they have given a contract for me to build a hostel for boys hostel and girls hostel in the Raichur districts. We have already completed the project and we have handed over these buildings to the concerned respondent number 2. We have also submitted all the bills, but they have not released the amount. They kindly requested to issue writ of mandamus to.
Earlier also you had filed writ petition. Annexures K and L, another.
Next year K or this one, my lordship, that related citation.
Huh?
Citation. Similar case has been decided in the earlier. This is a citation, my lordship, that earlier case has been decided as.
Learned AG takes notice for respondent number 1. Learned Counsel Sri. Karnataka Residential Society. ನನ್ನೆಲ್ಲ ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲಿ ಯಾರ್ರೀ ಅದು?
I will give the name.
We'll give the name.
ಯಾರ್ರೀ? ಕೋರ್ಟ್ ಆಫೀಸರ್.
Christ.
ಹಾ.
ಜೊತೆ
ನೆನ್ನೆದ ಕಾಲ್ ಲಿಸ್ಟ್ ನೋಡ್ರಿ.
Srinivasa C.
Learned
Srinivasa
Counsel Sri Srinivasa C is requested to take notice for respondent number 2. Learned Counsel for petitioner is directed to serve copies of the petition along with annexures and the learned counsel for the respondents. Yes.
Here for the petitioner. Lord, in this case, the petitioner is a retired assistant general manager, my lord, in HMT. My lord, his resignation was accepted and my lord, he was relieved on 31st January 2025.
Ah.
Now, my lord, the management, my lord, is due.
Public premises.
Yes, my lord.
Public premises.
Please, my lord, I have been allotted with the residential quarters.
Ah.
My lord, under the.
He is retired.
I am retired, my lord, and relieved with effect from 31st January 2025.
Ah.
Now, my lord, there is about sum of rupees 57,000 lakhs is due from the management towards EL encashment, unpaid salary, then provident fund amount and all.
Ah.
Meanwhile, my lord, there is one office note which I have produced, my lord, which enables the, please turn to page 41, annexure F. my lord. I have submitted a representation to the respondent saying that, Lord, please settle my terminal benefits. Till then, I may be permitted to occupy the quarters.
Writ petition maintainable?
No, because now, my lord, annexure D is the communication sent to me.
ಹೌದು. Under the provisions of the Public Premises Act.
Now, proceedings are yet to be started, my lord, under the act.
Ah.
Now, my lord, in the meanwhile, I am threatened to be evicted. Or, my lord, I have been directed to pay the penal rent as
Yes.
per annexure D.
Yes.
My lord, now, my lord, therefore, I have sought for a mandamus.
Ah.
I am not calling in question the notice.
Hmm.
My lord, there is a provision under the.
Therefore, having regard to the prayer made, how this writ petition is maintainable is the question.
Yes, my lord.
The respondent is a company.
Company.
Yes.
My lord, there is a provision for the, which has been, my lord, formulated by the company, permitting the retired employees to stay in the quarters, my lord, till the terminal benefits are
Correct,
paid.
sir.
Yes.
It's a company.
Yes, my lord.
Ah.
That is, my lord, HMT
Ah.
machine
Ah.
tool.
Any dispute matters between the employer and the employee in respect of a company, how you can file a writ petition?
My lord, it is an authority under Article 12.
Huh?
My lord, this is an authority. This is a
Yes.
public sector undertaking.
Yes.
So, my lord, writ is maintainable. And, my lord, this also deals with the service
To
conditions of.
notice to the respondents, keeping open the question of maintainability of the writ petition.
Now, my lord, my
Yes. We will see.
only interim prayer is that, my lord, I am forced to be evicted.
Yes.
In fact, my lord, in one similar case, can I just, I'm sorry, my lord, for persuading your
No,
lordship.
no, sir. Yes.
Lord, can I take notice?
Sir.
Alla, one day one submission.
Issue notice to the respondents returnable by 12th of February. Yes.
ಅಲ್ಲಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇದ್ರೆ, if I am permitted, my lord, I will serve. Mr. Rayappa appears for the HMT.
The petitioner is also permitted to serve a copy of the petition along with annexures on learned counsel Sri
Rayappa.
Rayappa.
Yes,
Yes.
great.
For the petitioner. Impugned order, my lord, the bid of the respondents which was rejected on the technical ground was challenged under section 16 of the KTTPR. An appeal was not maintainable. Without assigning any reasons, my lord, the appellate authority has allowed the appeal and directed the technical committee to verify and open the technical bids. Technical bid, my lord, of respondent 3 to 5 were rejected on the ground that, my lord, they gave conditional bank guarantees. They preferred an appeal under section 16. Appeal is allowed without hearing me, without arranging me as a party.
Who are you?
I am the one of the successful bidders, my lord.
Successful bidder, sir.
The impugned order, my lords, would find at page 21, my lord. I'll start from page 22, my lord. Second paragraph, my lord, after the column. ಮೇಲ್ಕಂಡ ಕಾಮಗಾರಿಯನ್ನು ಪಾಲಿಕೆ ಸಾಮಾನ್ಯ ನಿಧಿ ಅಡಿಯಲ್ಲಿ ದಿನಾಂಕ 15/6/24 ಆಯುಕ್ತರು ಮಾಡಿರುವ ಅನುಮೋದನೆ ಟೆಂಡರ್ ಪ್ರಕಟಣೆ ಸೋ ಕರೆದು ದಿನಾಂಕ 4/6/24 ಟೆಂಡರ್ ತೆರೆಯಲಾಗಿತ್ತು. ಈ ಕೆಳಗಂಡ ಬಿಡ್ದಾರರ ತಾತ್ಕಾಲಿಕ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸಿ ವಿವರ ಕೆಳಗೊಂಡಿದೆ. ಎಸ್.ವಿ. ಪ್ರಕಾಶ್ ರಿಜೆಕ್ಟೆಡ್ ಕಂಡೀಷನಲ್, ರಾಮಪ್ಪ ರಿಜೆಕ್ಟೆಡ್ ಕಂಡೀಷನಲ್, ಕೊಟ್ಟೆಗಾಪ ಅಕ್ಸೆಪ್ಟೆಡ್ ಅಂಡ್ ದಿಸ್ ಎಸ್ ಹರೀಶ್ ಆಲ್ಸೋ ಕಂಡೀಷನಲ್. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಸೇವಾ ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮೇಲ್ಕಂಡ 4 ಜನ ಬಿಡ್ದಾರರು ಭಾಗವಹಿಸಿರುತ್ತಾರೆ. ಟೆಂಡರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ 3 ಜನ ಬಿಡ್ದಾರರು ಎಸ್.ವಿ. ಪ್ರಕಾಶ್, ಫಕೀರಪ್ಪ, ರಾಮಪ್ಪ, ಮಂಡಿವಾರ್, ಹರೀಶಸ್ ಅವರು ತಾಂತ್ರಿಕವಾಗಿ ಅರ್ಹವಾಗಿದೆಲ್ಲ ಹಾಗೂ ಶ್ರೀ ಕೋಟೆಗೆಲೆ ಮುನಿಶಪ್ಪ ರಂಗನಾಥ್ ಅವರು ತಾಂತ್ರಿಕವಾಗಿ ಅರ್ಹವಾಗಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ದಿನಾಂಕ 26/9/24 ಮತ್ತು 27
ಪರಿಶೀಲಿಸುವಂತೆ ಆಯುಕ್ತರು ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ಪಾಲಿಕೆಯವರಿಗೆ ಸೂಚಿಸಿದೆ. Reconsideration.
No, there is no order of reason, my lord, why the appeal is allowed. My lord, this is appeal under section 16. This appeal in its principality is not maintainable until an order under section 13 is passed.
Takes notice for respondent number 1. Who appears for the Shivamogga City Corporation?
Shri A.V. Gangadharappa.
The A.V. Gangadharappa is requested to take notice for respondent number 2. ಏನ್ರಿ ಎರಡು ಒಂದೇ ಹೆಸರಿದೆ, petitioner ಮತ್ತು respondent number 3.
ನಾವು CAT station ಇವರು CAT forum, our proprietary concern, ನಾವು private limited company.
Both of you participated.
That's a separate entity itself. They just borrowed our name. We are a private limited company. They call it, they are as a proprietor concern.
Issue notice to response number 3 to 5. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Yes.
Meanwhile, not to finalize the tender, my lord. Lord, this is an appeal, my lords, under section 3. My lords may see section 16.
Yes,
My lord.
it has only been remanded, sir.
Lord, section 16,
There will
appeal
be
itself is not
consideration.
maintainable.
Yes,
Again, a technical bid, appeal itself is not maintainable, my lord.
all right. Yes,
Could I request for a date, my lords, my lord, some date? My lord, if the tender is finalized, my lord, then this petition becomes fine.
opportunity will be given to you, sir. It has been remanded.
Without hearing.
You can't say, no, no, you cannot do
No,
it.
no,
ಅಂತ
no, they
ಹೇಳಕ್
can remand it after hearing.
Yes,
R3 has been declared as L1 in spite of having no requisite qualification.
huh?
In the tender scrutining authority, they scrutinized the papers and they said that the R3 is not eligible. Kindly see annexure, page number 113, 111.
111.
111 is the report, the tender scrutining authority. 113 is the relevant Jaglur Taluk Mala. Srimati Padmavati, there are 3 participants and I am concerned with Shri Vijay Kumar E. Manya Ayuktara Agatya Kramakagi Saliside. They have no requisite 3 years prerequisite qualification.
You know?
Experience illa anta 2024-26ನೇ ಸಾಲಿನ ಟೆಂಡರ್ ನಿಯಮದ ಪ್ರಕಾರ 3 ವರ್ಷದ ಪಡಿತರ ಆಹಾರ ಧಾನ್ಯ ಸಾಗಾಣಿಕೆ ಅನುಭವ ಇರಬೇಕಾಗಿರುತ್ತದೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
113.
ಯಾರ್ದು?
Jaglur, Vijay Kumar.
ಜಗಳೂರು.
Also.
ಹಾ,
Sri Vijay Kumar.
ಹಾ,
This is the tender scrutining authority report. Requisite qualification is that 3 years experience must be there. And it has been categorically stated that there is no 3 years experience.
ಇರುವುದಿಲ್ಲ. ಹಾ,
In spite of that,
ಹಾ,
he has been declared as a L1. Now, And I made a representation to that effect also. Annexure A is my representation. Without considering my representation, he has been declared as L1.
But there itself, you see in the case of Srimati Padmavati Tiraskrita,
House Swami.
page number 113.
ಹೌದು
ಇವ್ರದ್ದು ತಿರಸ್ಕೃತ ಆಗಿಲ್ಲ, ಮಾನ್ಯ ಆಯುಕ್ತರ ಅಗತ್ಯ ಕ್ರಮಕ್ಕಾಗಿ ಸಲ್ಲಿಸಿದೆ.
They must reply me. She didn't reply me. Commissioner has not responded to me. That's why I gave a
Tenant,
representation as annexure A.
AG takes notice for response number 1 and 2. Issue notice to response number 3. The ಏನಾಗಿದೆ ಈಗ, ವಾಟ್ ಸ್ಟೇಜ್ ಇದೆ?
ಅಲ್ಲ ಈಗ ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. Tender has not been awarded to. He has been declared as L1.
ಎಲ್ಲಿ, ಯಾವ್ದ್ರಲ್ಲಿ?
ಜಗಳೂರು ತಾಲೂಕಿಗೆ.
Which document, sir?
My lord, kindly say annexure E, my lord.
Page number?
115, next page. ಅದರಲ್ಲಿ ಜಗಳೂರು ತಾಲೂಕಲ್ಲಿ page number 117. ದಾವಣಗೆರೆ ಜಗಳೂರು. There were two
Annexure E.
annexure E's.
ಹಾ,
ಕಲಂದರ್ ಮತ್ತೆ ಈ ರಾಮಕೃಷ್ಣ ರಾವ್.
Annexure E ನಾ?
ಹೌದು ಸ್ವಾಮಿ.
Page 115.
115 is annexure E.
ಹಾ,
The relevant portion is at 117.
ಹಾ,
Serial number 18, ದಾವಣಗೆರೆ ಜಗಳೂರು. ಅದರಲ್ಲಿ ಇಬ್ರು ಇದ್ರು ಸ್ವಾಮಿ, ಕಲಂದರ್ ಅಂಡ್ ಈ ರಾಮಕೃಷ್ಣ ರಾವ್.
ಹಾ.
In fact, he should not be considered. ರಾಮಕೃಷ್ಣ ರಾವ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಂಗಿರ್ಲಿಲ್ಲ. He has been now considered, has been declared as L1. That paper I don't have.
ಎಲ್ರಿ ಮಾಡಿದ್ದಾರೆ? Annexure E is have enlisted all the eligible
Could not be considered as L1. Now it has been, yesterday he has been declared as L1, my lord. I couldn't get the document. Yesterday has been declared as L1. In fact, he couldn't be considered for L1 only. He should have.
next para, having regard to the observation of the tender processing authority at annexure D, that the third respondent does not have the experience of having supplied food grains for the past 3 years in terms of the tender condition, comma, if the third respondent is declared as L1, comma, the tender shall be subject to the final outcome of the street petition. Yes.
Copies be served on.
Huh?
Copies be served on me. Copies are
Ah,
not.
please
I
serve
will serve
copies.
it.
Yes.
ಅಲ್ಲ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿ. Them not enter into.
ಮಾಡ್ಲಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
Fourth respondent.
Respondent, ಈ ಕಡೆ ಬನ್ನಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ I appear for the petitioner.
Huh?
I appear for the petitioner.
ಹಾ,
The fourth respondent may not had initiated a proceedings. A claim petition under MSMED Act. Now that was called in question not by this petitioner before this honorable court. Now page 19 is the order not of this honorable court. And on two grounds. One is that the charge sheet has been filed against the respondent number 4 for having made claim based on fabricated documents. And not MSMED may not consider as no jurisdiction.
what was initiated?
Not a claim petition was filed.
For?
Not saying that the respondent number 4 has supplied certain goods to the petitioner company. Not meanwhile, the petitioner company may not had filed an FIR, not with the jurisdictional police. The jurisdictional police
FIR?
on the ground that the respondent number 4, in collusion with my earlier employees, had submitted bills, may not making false claim. It was investigated, charge sheet has been filed not against the respondent number 4 and others, including my employees. Not based on that ground, I approach this honorable court, not seeking quashing of the not claim petition. Dishonorable Court was pleased to, my lord, page 19, 19, my lord. After hearing all the parties, my lord, was pleased to remit the matter, my lord, to the MSMED Council. Not page 32, para 13, my lord, are the questions framed not by Dishonorable Court. May I not read the questions?
Yes.
For the aforesaid reasons and analysis, without expressing any view on the merits and demerits of the claim being made by the parties, this court is of the considered view that the matter be remitted to the council for first adjudicate on the following issues before proceeding further. Whether in view of the allegations made by the petitioner of fraud, fabrication, and collusion, can the council proceed further in the matter in the light of the judgment of the apex court in so and so? Whether or not the respondents qualify themselves to be suppliers within the meaning of section 2N of the Act and to seek remedies as provided under the Act. But this order was made available not to the council not at page 34. Not the not now, not your kindly have a look at the order passed by the council, not which is at which starts from page 37. Not the council at page 39, not last two paragraphs would record the order passed by Dishonorable Court. Letter from the Office of Advocate General, not last two paragraph of page 39. Advocate General, High Court Building, Bangalore, dated so and so, has been received in the office on so and so regarding disposal of WP. The above case has been disposed of by the Honorable High Court of Karnataka with the order dated so and so, directing MSMED Bangalore to take up the matter for hearing and adjudicate on the aforesaid issues. Hence, the case is placed before the council for further action. But there is absolutely no further action. The council, not without even considering the issues not framed by this Honorable Court, would refer the case not to the arbitration. Order. The council conducted conciliation proceedings with regard to claim of the petitioner
Notice
company.
dated 10/9/2024 has been sent to both the
Notice
parties.
ಕಳಿಸಿದ್ದಾರೆ. During MSMED, then I'll read para 9 also. During MSMED hearing held on so and so, case called petitioner present, respondent present, both parties request time for conciliation, which may not in my humble submission. My colleague was there. We did not, nobody's not sought time for conciliation, but it even recorded. Hence, next date of hearing is so and so. During MSMED proceedings held on so and so, case called petitioner absent, respondent present. That is, not the petitioner herein not was present. Sufficient time given for conciliation, but conciliation failed. Hence, matter referred to arbitration center for arbitration. Not the issue was whether not the MSMED proceedings would itself not take place. But that is not questions framed not by this Honorable Court at page 32. The council would record that there is an order of this Honorable Court without deciding not on the questions raised not by this Honorable Court, would refer the matter to arbitration. Now, tomorrow is the proceedings, not arbitration date fixed. But in fact, or when my colleague appeared before the council, on page 33, your lordship will find not a specific direction. The council shall take up the matter, adjudicate on the aforesaid issues before proceeding further. I produced the complete order sheet.
Learned AG takes notice for
1 and 2.
1 to 3.
number
1 to 3.
1 and 2.
Please, I'm sorry.
ಅವ್ರೇನಕ್ ಬೇಕ್ರಿ
Response
ರೆಸ್ಪಾಂಡ್
number 3 ಬೇಡ ಯಾಕೆ? ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
notice to respond number 4. Notice to respond number 3 is not necessary
Please.
for the time being. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures from the learned AGA. Stop. Next para. Learned counsel for the petitioner draws the attention of this court to paragraph number 13 of the order dated 1st of August 2024 in WP number 49974 of 2017 and connected matters, and submits that having regard to the objection raised by the petitioner regarding the status claimed by the fourth respondent as supplier within the meaning of section 2 bracket N of the MSMED Act, 2006, this court remitted the matter back to the second respondent counsel to first consider the issue as to whether, in view of the allegations made by the petitioner regarding fraud, fabrication and collusion, whether the council can proceed further in the matter in the light of the judgment of the apex court in the case of Withdrawal and others versus Durga Trading Corporation. Question mark. Learned counsel submits that despite such a direction, the council has simply referred the matter for arbitration, without even giving a finding on the issue
Please.
which was sought to be considered and decided in terms of the directions issued by this court. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 5/12/2024 at annexure
Annexure E.
E till the next date of hearing, and all further proceedings thereto till the next date of hearing.
Please.
Yes.
This 8, 9 and 10, they're all connected. 7, 8, 9, 10,
Same,
Ella same. Respondent number 4 is different. Please.
Same order.
Same one.
Yes.
Hearing for respond.
My lord, kindly pass over, man. See, coming. Kindly pass over, my lord.
Pass over.
Appearing for the petitioner, Your Honor.
Yes.
In this particular case, the petitioner is a home buyer who has entered into an agreement of sale with the respondent number 4.
Ozone Urbana.
Yes, Your Honor. And respondent number
Which are
5 is the
that other
landlord.
writ petitions where interim orders are passed?
Your Honor, I've referred to it in paragraph 17, page 11.
Interim orders have been passed in respect of this.
This,
Which are that those writ petitions? You don't know? Nodri, check madri. Same order.
Your Honor, similar petitions are there.
42 is the similar matter.
Similar
42 na?
petitions are there.
ಅದ್ರಲ್ಲಿ interim order ಇದೆಯಾ?
ಅಲ್ಲ ಇಂಟ್ರಿ ಮಾಡರ್ಸ್ ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಇದೆ.
ಅದೇನೆ ನಿಮ್ದ್ರಲ್ಲಿ ಇದೆಯಾ?
ನಮ್ದು ಎಲ್ಲದಲ್ಲಿದೆ. ಇಲ್ಲ 42 ಇವಾಗ ಬಂದಿದೆ. ನ್ಯೂ ಮ್ಯಾಟರ್.
ನ್ಯೂ ಮ್ಯಾಟ್ರ್.
ನ್ಯೂ ಮ್ಯಾಟರ್.
ಬೇರೆ ಯಾವ್ದು ಮ್ಯಾಟ್ರ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು? ಇದೆ ಬಿಡಿ, ಇವ್ರ ಹತ್ರ ಇದೆ ಬಿಡಿ. ಎಸ್. Learned AGA takes notice for response number 1 to 3.
I'll take notice for Union of India, madam.
Union of India party ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ವಾ? Only RBI, no?
No, this is a RERA matter, so.
RERA.
Oh, sorry, madam. I thought it's the Ozone Urbana has got another batch.
Yes,
Ozone
this-
Urbana in respect of this Orders passed by RERA.
Rare no, sorry.
Your Honor, in similar
Notice
matters,
to response number 4 and 5. Notice to response number 6 is not necessary. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Same orders, interim orders. Yes.
Petitioner, this is a written challenging the order passed under section 64A by the third respondent, confirmed by the second respondent, which is based on the FIR filed by the fourth respondent. Kindly refer to annexure P at page 49.
FIR.
Yes. No, the annexure P is the impugned order passed by the third respondent.
Annexure P.
At page 49. On the top of it, it is based on the FIR register. It is clearly mentioned. ಐನೂರು ವಲಯದ ಅರಣ್ಯ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 66/2018 ದಿನಾಂಕ 23/5/2018. So this is based on the FIR. Now kindly refer to the FIR, which is available at page 40.
So why are you wanting to go to the FIR?
No,
What is
no,
your contention?
because this is a wrong prosecution. That
What is
man
your
is dead
contention?
at the time.
Huh?
When the FIR was filed, the man was dead more than a year earlier.
FIR BD, sir, what is this order? It's under section 64.
Section 64.
Asking you to evict.
Page number 50.
What is your contention?
No. The FIR registered itself is is void, totally void. Because FIR was
We are
registered.
not concerned with the FIR, sir. If it's FIR, please go to the court having jurisdiction. We are concerned with the order passed under section 64A.
Yes, but
What is your
that
contention?
order is passed against a legal heir. He has
Yes.
not brought in as a legal heir.
Huh?
He has not been brought in as a legal heir.
Yaro?
That one Shashidhara, the accused late Narsimappa had 3 children, 2 children
Then
and wife.
Shashidhara. You are the, he is the petitioner.
I am the petitioner.
Huh?
They have issued notice to me. I
Ah.
have submitted all the documents.
Ah.
And in spite of that, they are holding that I have encroached the land. My property, survey number 67.
Huh?
I have produced all the documents.
Ah.
And 67 is a revenue land.
Huh?
And even in the notification, it is clearly mentioned
Huh?
that forest is only 66.
Angeli, you
And
see,
that I will
you
show the
please say
forest notification.
that lands have been granted under the provisions of the land revenue, land
Land
grant
Revenue
rules,
Act in 1960.
and your name is standing in the RTC till date.
Yes.
Sena? ಅದನ್ನ ಹೇಳೋ ಬದಲು FIR is
FIR is on a dead person they have filed.
Yes.
Father made an application in the Court of 53. It was not given to page number 50 of the order.
Page number?
50, annexure P.
ಏನಾರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರೇನ್ರಿ that land was granted?
Grant was granted to my predecessor in 1962-63.
Who?
My predecessor,
Predecessor ಅಂದ್ರೆ ಯಾರು?
that one, Devi.
Document.
In.
And you have
I have
purchased
produced
it
all
from
those
him, is it?
documents. I will refer
You
to.
have purchased it from him
Yes, I have purchased in
purchased-
1990 from him. My father purchased it.
under registered sale deed.
Yes,
Huh?
yes. And that is produced at annexure C.
And your name is standing in the RTC.
Yes.
Same order. No. He has purchased it under registered sale deed, sir, from the previous owner. Yes, same order. ಯಾವ್ದ್ರಿ ಅದು? Disposed of, setting aside the order. He will have to issue notice to you, consider all the documents that will be furnished, thereafter decide the matter. Yes.
Maybe tagged along with that and
Yeah,
there are other 3 connected matters.
recreation club. Yes, disposed of.
My lords, we have sought, my lords, we have sought for further directions.
Ah,
Lords, in spite of regular directions, what this honorable court, my lords, has been given.
ah.
My lords, the police are still misusing, my lords. Hence, we have sought for further direction.
ಏನ್ further direction?
My lords, in page number, my lords.
9 of the petition. my lords.
ಕೊಡ್ರಿ ಅದು.
In the connected similar matters also, we have sought for directions. This court has issued notice, my lords, and post. The matter has to be heard.
Huh?
In similar connected matters, this court has already issued notice, my lords, to the respondents. To hear on, my lords, the issuance of further directions. At page number 9, my lords, I have sought for further directions. My lords, in spite of the directions issued by this honorable court, my lords, they regularly, my lords, misuse and interfere.
You know?
In spite of the directions.
Where is the earlier directions that you have obtained?
My lords, it
Page 17.
page 17, annexure C. Despite we following all the directions, my lords, issued by this honorable court. My lords, again they interfere, my lords, without issuing any notice, my lords, in a high-handed manner. That is why, my lords, we sought for further directions.
Next one ಅದನ್ನ.
Allala.
Huh?
Allala. And in the more connected matter, there is notice has been issued and is pending consideration. This may be tagged along with, my lords. Those,
What is there to be considered, sir, in this matter?
my lords, these further directions at page number 9, my lords, what I have
What
requested.
is there to be further considered? If you have already been, if they've already been directed, we'll have to ask them why they are interfering and dispose of the matter.
My lords,
Why is it kept pending?
my lords, this is a fresh matter, my lords, I have filed again.
The other matters I'm saying, if they are of the
it was-
similar nature,
Please, my lords.
where is the need for keeping them pending?
My lords, I have given a memo, my lords, it's in the B group. That is why, my lords, may I request, my lords, this matter also may be tagged along, my lords, and a date may be given. So that, my lords, it can be disposed of, my lords, together.
ಯಾವ್ದದು?
WP number, my lords, 34076 of 2024, my lords.
List this matter along with WP number
34076 of 2024.
and
My lords, along with that, my lords, all other matters have been connected.
on 5th of February,
My lords, may I request on 7th, my lords,
7th.
please.
All right.
Grateful.
Lords, I appeared for the petition in this matter, my lords.
Hmm.
I have sought for transfer of investigation to either CCB or CID police station, my lords. I have sought for transfer of investigation to either CCB or CID for further investigation. Lords, the petition before this honorable court be
Tenant AGA takes notice for all
1
the
to 9.
respondents.
1 to 9.
1 to 9.
1 to 9.
CID ನು ನಿಮ್ದೆ ಕಣ್ರಿ 10,
ಇಲ್ಲ 11 ಒಂದು ನಿಮಿಷ
11. ಅದು ಅಷ್ಟೇ. All the respondents. CBI ಎಲ್ಲ ಅದು.
CCB or CID, my lords. I have asked for that.
No. None of the respondents are CBI.
No, none of the respondents.
All are state only.
Sorry.
All the statements.
Learned counsel for the petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Yes.
Date may be fixed.
Yes.
My lords, I had challenged the auction notice at annexure A. It was on 13 to 18. I have to ascertain whether auction has been conducted or not. Kindly have it on Monday. If auction is,
Last time also you requested and you
Yes, my
taken
lord, yes.
adjournment.
but I have not got the information. I'll get today. I'll file it memo on Monday. If auction is done, I'll file a withdrawal memo.
Auction is done
I know, I have to ask it.
at the request of learned counsel for petitioner, finally release this matter on
Monday.
4th of February.
Great.
And for the petitioner in this matter, my lord, serial number 17. Yes, my lord.
Yes.
This regarding the defreezing of bank account, my lord. The petitioner bank account has been freezed without giving any such notice, my lord.
At
And
whose
also
instance?
there is no, FIR
Punjab
is
National
also,
Bank.
yes, my lord, Punjab National Bank. And the direction of the respondent number 2 police, they are saying there's a direction from that police only we freeze the bank account. Without giving any such notice, my lord, they are not giving any information also.
Learned AGA takes notice for response number 1 to 3. Issue notice to respond number 4.
My lord, on submission, I may be permitted to serve the copy the advocate one who representing the respondent number 4, my lord.
ರೀ ಬಿಹಾರ್ ಅಂತ ತೋರಿಸಿದಿರಾ, ಯಾರ್ರೀ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು ಇಲ್ಲಿ ಅವ್ರನ್ನ?
No, my lord, there is some
ಪಂಜಾಬ್
panel,
ನ್ಯಾಷನಲ್ ಬ್ಯಾಂಕ್ is of Bihar.
panel advocates are there, my lord.
ಈ ಪ್ಯಾನಲ್, how can it be their panel in Bihar?
No, I may be, my lord.
Notice to respond number 4. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA.
Yes, ma'am. My lord,
Emergent
one more
notice to
step.
respond number 4, returnable by 11th of February.
My lord, one submission, my lord.
In the meanwhile, learned AGA is directed to secure instructions and make submission. Please. Yes.
My lord, one submission, my lord.
Yes.
In the meantime, I may be permitted to use my account, my lord. There is no fraudulent transaction.
That kind of a direction cannot be given without hearing the other side.
Please,
Yes.
my lord. Please.
For the petitioner, my lord. My lord, the final electoral voter roll got published on 6th January 2025, my lord. And we are seeking re-verification of the voter list because there was no transparent method of as of today, my lord, it is not mandatory to link Aadhaar with the voter ID. The only foolproof method which is available for us today is just a door-to-door verification, authentic and transparent verification, my lord. And my lord,
What is this?
My lord, duplicate voter IDs is wide prevalent, my lord. Duplicate voter IDs, mate fake voter
What is
IDs.
the prayer in the writ petition? Issue writ of mandamus or any other appropriate writ
For conducting authentic
respond
and
1 and
transparent.
2 for conducting authentic and transparent door-to-door verification of the voter IDs. In respect of what?
Final voter list, my lord.
ಯಾವ್ದ್ರ ಬಗ್ಗೆ?
Duplicate voter list is wide prevalent, my lord.
Public interest litigation.
Public interest litigation ಇದನ್ನ last December ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. Supreme Court has directed that ಇದು whole ಇದು ಬರೋದಿಲ್ಲ.
Is seeking to expose a public cause. Full stop. The present writ petition is not maintainable.
My lord, this is just an association. We are bothered with only our ward, my lord. Our ward, which is ward number 13, my lord.
Petition is accordingly dismissed, reserving liberty to the petitioner to file a public interest litigation if it so chooses. Yes.
May I please, my lord?
I'm being led by
Yeah.
Mr. Jatin Sehgal appearing online.
Hi, my lord, I
Yes.
apologize to appear online, my lord. I was in difficulty not able to travel from Delhi in this matter, my lord. Sorry,
Yes.
my lord. My lord, this is a writ petition, my lord. I have filed, my lord. My lord, if my lord may have page number 30 for a minute of the paper book. My lord, I am a senior employee in a company working Moserbear, my lord. I receive an email on 27/7/2024, which is annexure A.
Senior.
My lord, I am a senior employee working in a company called Moser Bear in Bangalore. I receive an email, my lord.
Petition is filed by a company.
Yes, my lord. So the companies, my lord, all the employees of the companies have received these emails. If my lord, if I can just request my learned friend, my colleague to hand over a seal cover, I cannot file this. My lord, these documents could have not been filed, my lord. My lord, may see this is the email circulated within my company, my lord, for all employees. Somebody, my lord, morphed pictures and circulated, my lord, to all my employees in my organization. My lord, may just have a look at the seal cover, my lord. My learned friend will hand over, my lord. I was not able to file it. My lord, this is the content of the email, my lord, which is circulated of all my senior employees, my lord. This email, my lord, is by a company called, by somebody made in a company called Proton. Now, my lord, Proton is based in Switzerland. My lord, there are all threat emails which comes in India, my lord, with regard to the bomb blast. Everything comes from this email ID, my lord. Now, my lord, this, if my lord may just have for a minute from page number 104, which is annexure R. For a minute, my lord. My lord, annexure R onward, my lord. my lord, these are various, on various times in this country, my lord, when this email was used, my lord, threat emails to everyone, my lord, has been come from this. And there is a direction to ban this email because they are not ready to provide information. I filed an FIR with the Bangalore police station. The police, my lord, is unable to execute because the company is saying that we will not give any data till the time it comes from the ministry, not from the police authority. My lord, they say that Proton, a legal notice was sent to Proton, my lord. Proton writes back, my lord, saying that we will not be giving any data to any authority unless it will come from the ministry. And my lord, this is, my lord, a dangerous, my lord, a situation, my lord, where, my lord, may see from page 104 onward to 136. It's every day, my lord. This mail ID is used, my lord, and Delhi High Court has passed an order to ban this email or to make a regulated guideline, my lord. No, my lord, I am not able to, my employees are under threat, my lord. These kind of emails have been circulated by using this Proton email ID, my lord. Neither the police can today verify who is it because the company is not giving this, saying that you have to come through the MEA. My lord, I have no other option. My lord, Proton. Proton, I have written a letter, my lord. Proton says, my lord, may have my
Respondent 7.
R7, my lord. My lord, may have my legal notice which I have sent to the Proton email, which is R7, and the reply to that. They say that we have disabled the account, but we will only give you the data when you come through the government channel. No, my lord, my lord, it's every day, my lord, these employees are not able to come. This is a problem, my lord. And it is not to me, my lord, it is public at large, my lord, may seen the articles and the orders passed by with different high courts, my lord, in this aspect, my lord. I will tell my lord, my colleague to, my lord, share one order, my lord, in a habeas corpus petition in Delhi, my lord. Similar situation arose, my lord. The court said it is a banned email, but it is still not banned. We have a treaty. India has a treaty with Switzerland to share the data. My lord, may see this judgment, my lord. It's a habeas corpus petition, para 18 of this judgment and 19. In addition, the IU has brought to the notice to this court that the email address proton.me, Proton email provided, para number 18, 18.
Your Lordship, internal para number 12, within that there's a quoted portion, para number 18 on the page number 3 at the bottom.
Page number 3, my lord, bottom. In addition, the IO has also brought to the notice of this court that the email address service Proton.me, Proton email provided by the Proton AG Switzerland being used by MSS is banned in India. The said platform was allegedly being used for various unlawful activities, due to which it is stated to have been banned by the government. On being queried by Mrs. S, has informed the court that she learned about the said email address service through Google platform. This aspect would also need to be investigated as to how the said email address still been made available to the user in India. The IU is also informed that the Ministry MHA and Electronic Information Department of DOT of the availability in India of the said email address Proton.me, so that the said asset can be looked into. This happens, my lord. This is a similar situation, my lord, where these emails are used. And my lord, there is a, my lord, may just see the treaty. First, my reply to the my legal notice, which is page 31, annexure B, 28/9/2024. The moment I received.
AG takes notice for respondent number 1.
1, 3, and 7.
Learned Senior Central Government Standing Council.
Council for R2, 4, and 5. Respondent number 2
Takes notice for respondent number 2 to
2, 4, and 5.
2, 4, and 5. AGA for 1 and 3. 1, 3, 6. What is the use of issuing notice? It will not be served on respondent number 7.
My lord, it has to be served.
It will not be served anyway. It will not be served.
We'll undertake to serve via email because we have the concerned legal officer's email address, if I could be given that liberty. The problem arises, Your Lordship, in the context of the investigation launched by the police. The police has written to the service provider in Switzerland. Switzerland has replied saying, we will not give you any information till it comes through our domestic legal channels. That status report, Your Lordship, will find at page 74. And at 75, Dinaka 11/11/24 on the Proton AG Ravarinda mail Mulaka Sadri Avaru Guptaite Mattu Bhadrate Karanakalagi Swiss police Ravara Mulaka Barua Vinantigalannu Matra series Swikarisutide. The issue is we want investigation to conclude, the accused to be unearthed, but without there being assistance from the central government, the Swiss authorities are not going to yield any information to us.
My lord, and this email ID this email is banned, my lord, in the country, and still, my lord, there is no
Not
guideline.
that.
My lord.
We are now on the question as to how we are going to serve respondent number 7.
Lordship,
Lord, we will serve
them via
through email, my lord.
I'll undertake to serve them via email. I have the email address of their legal officer. If Your Lordship will give me that liberty.
And my lord, we can also serve through the MEA, my lord, Ministry of External Affairs, my lord. There is, my lord, we do it all the time, my lord. When the person is residing abroad, it goes from the Ministry of External Affairs, my lord.
Because the issue is they may ban a user, but the user can make a fresh email address.
The petitioner is permitted to serve respondent number 7 through Ministry of
External Affairs.
Ministry of
External Affairs.
Yes,
and via email, if I could request.
You are not stated about the email here, and
My
we
lord,
have
they-
no rules.
My lord, can I
You have not come up with the rules.
That's
still.
true, Your Lordship. We don't have the rules.
My lords, we have page number 31 for a moment. My lords, this is where we issued them the legal notice and Proton. Respondent number 7 is also.
Learned counsel for petitioners is directed to serve copies of the writ petition along with annexures on the learned AGA and learned senior central government standing counsel. Next para. You have gone through the petition?
Your Lordship, at the outset, what their request is, has to come through the state government, from the police, from the
No, it
prosecution
appears
side,
that
it
there
has
are
to
many
come
such
through them.
complaints.
We
So-
cannot directly do it till they give it. Either it has to be a court of criminal jurisdiction, either a magistrate has to issue a letter rogatory or a MLAT under the existing treaty, or it has to be the IO who's basically dealing with the case. We directly cannot do it, and your Lordship also in your Lordship's extraordinary jurisdiction would not be in a position to do it. It should be a court
Right.
or a IO.
You
should
file
do it.
an affidavit or a statement,
Please,
whatever
please
you
do.
want to do. Release this matter on 6th of February.
My lord, can I request for 7th, my lord? I will come down personally,
You
my
want
lord.
it later?
Whatever they
7th.
say, 7th is also fine.
7th, my lord.
7th,
Yes, my
7th
lord.
of February.
7th, yes.
If I could also request the central government to make it stand clear on the viability and regularization of Proton.
Let's see.
Your Lordship, that may not happen in a short duration.
But I वापस put it. You please take it back.
Very good.
वापस put it. Yes.
Serial number 20 and 21, my lords, I have filed memo for withdrawal.
For the respondent number 2, my lord.
The same matter, my lords, which my lords closed yesterday, Safai Karmacharis, which these persons have agreed for 2 lakhs.
ನೆನ್ನೆದು ಯಾವ್ದು?
ನಿನ್ನೆ 3 ಕ್ಲೋಸ್ ಆಯ್ತು, ಇವತ್ತು 2.
ಯಾವ್ದು ನಂಬರ್ ಹೇಳಿ?
My lords, I'll give it to the court officer.
Same order ನೆನ್ನೆ. Yes. Withdrawal.
2021, my lords, both.
Yes. 2021 both. Yes.
Much.
Huh? 13. ನೆನ್ನೆದಾ? Yes.
I withdraw the petition.
I
withdraw the petition because the
You have filed a memo.
memo already filed.
What is it? Learned counsel for petitioner has filed a memo dated 28/1/2025 stating that the petitioner does not wish to pursue the matter and therefore the writ petition may be dismissed as withdrawn. Full stop. Next para, the memo is taken on record subject to all justice. Accordingly, the writ petition stands dismissed as withdrawn.
This is a defendant's petition against an application for rejection of plaint, which was rejected by the trial court. Well, this is a suit for specific performance of an agreement of 1975, an unregistered document, which has never seen the light of day for 46 years.
1975.
For 46 years, never seen the light of day. Suddenly comes up in 2021, and a suit for specific performance of an agreement of 1975 is filed. Now, the plaint averments, my lord, the relevant paragraph at 4. May I bring my lord's attention to that page, paragraph 4. Lord will see the plaint is at page number 22. And the relevant paragraph which I'd like to bring the court's attention is at page 24.
Yes.
My lord will see paragraph 4 of the plaint. Since the date of the said sale agreement, the purchaser, Govindappa, son of Puttappa, the father of the plaintiffs, enjoyed the suit property in his own right. And the father of the plaintiff, Govindappa, during his lifetime, approached the executants, C. Neelakantan, that is the defendants, and requested and demanded him to come and execute the registered sale deed pertaining to the suit scheduled property as agreed by him. But the said C. Neelakantan postponed the same with one or ulterior motives on one pretext or the other. However, the father of the plaintiff enjoyed the suit property without disturbance from anybody. In the meanwhile, the executants also died. My lord, clear ulterior motive alleged that he was not willing to execute the sale deed. Neelakantan died in 2010.
And the application has been rejected.
As kindly see paragraph 6 of the order of the learned trial court judge at page number 20, page 20.
Yes.
Here, paragraph 16 of the order. Here it is important to note that no limitation is fixed in the suit agreement. So, from the date of agreement of sale, whether the father of the plaintiff demanded, and in turn the executant kept on postponing or not, and the plaintiffs have demanded the defendants to execute sale deed or not, is completely a matter of evidence for which trial is compulsory. Therefore, the plaint cannot be rejected in the threshold. Paragraph 4 very clearly says that they made the demand and with ulterior motive that was refused. And Neelakantan died in the year 2010. So a suit in the year 2021, my lord will see the Limitation Act article.
Yes. No, I have dealt with a
Yes.
similar matter and I have. Yes, what do you say?
My lord, even including the.
When you have stated in paragraph number 4, that your father during his lifetime sought execution of the sale deed.
Yes, my lord.
But they denied.
Not denied. It
then?
is only postponing the execution of the sale deed since they both, the plaintiff and different, plaintiff father and different father were residing in the same village.
I have allowed a similar application.
My humble submission.
Here, the sale deed was executed in the year 1960. Yours is 75.
75.
That is the only
Agreement
difference.
to sell, my lord. Agreement to sell.
It is required to be allowed and the plaintiff is required to be rejected. Please get a copy of that CRP. Delay agreement of the year 1960. 2 weeks ago, I have passed an order.
It is in the year 1975, my lord.
Learned Counsel Sri Gajendra S. You have taken notice.
Yes, yes.
Yes,
In fact, the
I appeal.
matter was argued and the court was of the opinion that the plaint should be rejected. And
A copy tavamundi. Get a copy. Please furnish a copy of that to both the learned counsels. We will have the matter next week.
Please.
Release this matter on 5th of February. Yes. Yes.
Lord, serial number 24, my lord, I'm for the respondent in this matter.
That suit itself was disposed of.
Yes, my lord.
You got a copy?
Yes, my lord, I have the copy of the judgment. my lord.
Please give. The suit invoice number 849 of 2023.
Sir.
Petitioner by me, ma'am.
From which the present civil division petition arises, has been disposed of on 18/1/2025.
Yes, my lord. But even there is a
the-
direction of the Sanba court,
Huh?
the judgment was passed, my lord. The Sanba court has granted an time to deposit the amount. Without considering the order passed by the Sanba court, the trial court hasn't passed, then partially declared the suit, my lord.
That's all right.
My lord, some observations as required, my lord. The Sanba court has granted time to deposit the amount. The suit filed by the respondent for summary proceedings, my lord. In that matter, we have filed the application to seek and defend the case. That application was allowed, subject to condition to deposit 33 lakhs. In that matter, my lord, they are claiming that in this suit, they are claimed that 33 lakh amount was lent to this petitioner on the promise made by this petitioner to accept him to as a lead role in upcoming movie. He has lent a 33 lakhs loan to this petitioner. Then, my lord, one more check case has been put.
What is the prayer in the CRP?
CRP ಅಲ್ಲಿ 33 lakhs condition na waive ಮಾಡಿ ನನಗೆ
Regarding the application.
Yes, my lord.
Now the suit itself has been disposed of.
Disposed, my lord. There is an order passed by the Sanba court.
In order.
To direct the
where
deposit
which-
the amount.
Which order?
The order dated 18/7/2024, my lord. The same was extended till the date of passing the judgment by the trial court, my lord. 18/7/2024, my lord. Time has been granted to deposit the amount, extended by extending the time.
Learned counsel for respondent is granted 10 days to place on record the credit and debit details of all the money received by the respondent, which was made use of to make payment of rupees 66 lakhs in total to the petitioner. The time granted vide order dated 18/6.
And the trial court is extended till 8/8/2024. That same is as extended.
Been
my lord.
18/7,
Yes, my lord. 18/7 first order ಆಗಿದ್ದು. Next to thereafter the same was extended, my lord.
If I'm permitted, my lord.
On
kindly-
17/12,
Irri, let me see, he is saying
My
something.
My apologies.
The time for deposit as directed in the order dated 18/6 by the trial court
is extended.
is extended by a period of 1 week, subject to the orders to be passed.
Yes, my lord. That order was passed.
You will have a good cause of action to prefer an appeal.
Prepare an appeal, my lord. But violation of this order of this on the court. by
Adhe
the
re,
trial court.
adunu you'll have to state there, what can we do in this CRP?
Some observations may be made, my lord.
ಏನ್ ಹೇಳ್ದೆ? And therefore, the prayer made in the civil division petition has become infectious. Full stop. Learned counsel for the respondent
Yes, sir. Copy ಕೊಟ್ಟಿದ್ದೀನಿ.
has furnished a copy of the judgment passed in OS number 849 of
Certified copies are
2023,
not yet ready, my lord, in this matter.
dated 18th of January 2025. Full stop. Next para. However, learned counsel for the petitioner submits that by order dated 18/7/2024, this court had extended the period to deposit the amount as directed by the trial court by order dated 18/6/2024, by a period of 1 week, subject to the orders to be passed on 22/7/2024. Thereafter, the time for deposit was being extended from time to time. Full stop. Despite such directions, the trial court has proceeded to pass the judgment. Full stop. Next para. If there is any violation of the orders passed by this court, either at the hands of the trial court or at the hands of the respondent, liberty is reserved to the petitioner to take appropriate action in a manner known to law. Next para. Consequently, the civil division petition stands disposed of.
But in fact, my lord, this honorable court, by the order dated 17/12/2024, had given liberty for the trial court to proceed with the suit in accordance with law, my lord. He's suppressing this. I'm grateful.
Yes, my. My lords, defendant's writ petition, my lord, filed application order 7 Rule 11. So to reject the plaint, the plaintiff filed a suit for specific performance. My lord, the facts of the case, my lord, the plaintiff is my husband, the elder brother, is the karta of the family. They obtained a consent deed. On the basis of consent deed, they filed a suit for specific performance. My lord, that admittedly obtained consent deed, consent ಒಪ್ಪಂದದ ಕರಾರು ಪತ್ರ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, 2 ಐಟಮ್ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿನ ಅವರಿಗೆ ನಾನು ಬರ್ಕೊಡ್ಬೇಕಂತೆ. ನನಗೆ ಅವರು 10 ಲಕ್ಷ ಕೊಟ್ಟು. Kindly see that page number 47, my lord. On fiduciary, after death of my husband, they asked them taken please.
Where is the plaint?
Plaint. Page number 19, Swami. 19. Annexure B. Defendant
Chandrasekharaya.
Yes, my lord.
Is the plaintiff?
Yes, my lord. Defendant number 2 is this one. Defendant 2 and 3, my lord, are not parties to the consent deed. Kindly see that para number 3, my lord. The facts, they only stated that. The plaintiff said that he is the elder son, Karta.
One nimsha. Chandrasekharaya. He is the eldest son.
Yes, ma'am.
Who is this Renukama?
Renukama, youngest son of Umesh in the genealogical tree there. He died in the year 2014.
Renukama.
Also. Wife of Umesh.
Wife of Umesh.
Yes, he died, my lord. My husband.
The other two are their children.
Yes, my lord. My lord, the item para number 4 of the plaint. Item number 1 regarding explanation. Para number 6, item number 2. My lord, next to para number 7, my lord, he have only stated. The plaintiff submit that on 10/1/2008, his mother, Swarnama, was died, having behind of her estate, right, title and interest to her children. As such, the plaintiff, being the eldest son of the family, the few properties which is still in her name and is a name as such, item number 1 and 2, both properties are joint family properties. He used to let out the portion of premises for rents distribution to all the family members. This is a fact, my lord. The item number 1 and 2 are the joint family properties. So thereafter, my lord, consent deed, kindly see that, my lord, page number 47.
No. Let us see what the allegation in the plaint, sir.
Yes, my lord.
We can't look into any other document.
Yes, my lord.
Yes.
Next, he used to let out the portion of premises for rents and distribution to all the family members equally from the joint family properties. As until today, there is no any such dispute between themselves, but the plaintiff had extra care and affection towards his lost younger brother, Umesh, after sudden demise around 8 years back, and defendants have no other source of income and shelter as such. Under these circumstances, defendant were in shelter of outhouse from 1996 till July 2021, situated in item number 1 of the scheduled property, the copy of the rent agreement. My lord, next one. It is submitted that pursuant to the same, the defendant has offered to relinquish
they write title interest on the item number 1 and item number 2 of the scheduled property in favor of plaintiff, agreed to execute a registered release deed before sub-register in this regard 1/3/2019. The defendant had offered to execute the consent agreement by receiving advance amount 3 lakh in accordingly with mutual terms and conditions agreed in consent agreement 1/3/2019, and as per the oral discussion and decision of relinquished their right, title and interest to the plaintiff, the copy of the consent agreement so on. My lord, next, my lord, para number 13. It is submitted that even though defendant has got no absolute right, title and interest in respect of scheduled property, under the guise of the aforesaid claims to have got absolute ownership over the scheduled property, it is pertinent to note that in order to defeat in interest of the plaintiff in respect of scheduled property acquired from his earning and saving in accordance with law, and the defendants have only option to release their right in favor of the plaintiff as per the transfer of property law, even though he is ready to perform is a part of obligation, and it is pertinent to note that defendant used to quarrel with plaintiff brother Totadaria, who is staying in another portion of the item number 1 of the scheduled property. In this regard, he had given police complaint before jurisdiction of police against this defendant, and subsequently the plaintiff had also given another police complaint against the defendant for trespassing in the first floor front house by breaking main door lock on item number 1 of the scheduled property. The copy of the police complaint shown. My lord, cause of action, para number 16, kindly look into that. Cause of action of the suit. Para number 16. The cause of action arose for the suit on the last week of July 2021 and 16/9/2021 were unlawfully trespassed in portion of item number 1 of the scheduled property in the absence of plaintiff. This is cause of action. My lord, the property item number 1 and 2 is not exclusively belongs to me. Admittedly, the property belongs to my mother-in-law. So mother-in-law property. So according to the plaint averments, I enter into consent deed in favor of plaintiff. So agreeing to receive the 10 lakh to execute a release deed in respect of item number 1.
You have filed an application under Order 7, Rule 11.
Yes, my lord.
What is your contention?
Contention, my lord, there is no title has been passed to enforce the contract. No title on my in respect
Joint
of
family property,
Joint
even
family.
according to you.
Yes, my lord.
And he says you have taken money
Yes, my lord.
to release your rights
Yes, my
in respect of the share that you have in item number 1 and 2.
Yes, my lord.
He is asking direct them to execute release date.
Yes,
Yes.
defendant number 2 and 3 are not party to the consent deed.
Irbodu.
Kindly see that my consent deed.
How is it that your application should be allowed? On what ground?
My lord,
It's a matter to be considered after evidence is led.
no, my lord, this is a fiduciary relationship. Kindly see that, my lord.
To notice to the respondent.
My lord,
Yes.
section 15, my lord. Section 15 of CPC, specific relief act. My lord, stay, my lord.
Yes.
Allah, section 15, kindly look into that.
No. Yes.
Allah, to enforce the contract, a specific relief act, my lord.
Yes. Next matter, please.
My lord, till then, otherwise,
No, sir.
on fiduciary, I am a single parent and
The suit will proceed. Nothing is going to happen. Yes.
Number 26, my lords. Order 9, Rule 13, application filed by the respondent in as allowed, my lords. Application filed under Order 9, Rule 13, setting aside ex parte decree filed by the respondent has been allowed. That order has been challenged before this, in this petition, my lords. My lords, suit is decreed on 23/2020, my lord.
The CRP maintainable.
My lords, CRP is maintainable, my lords. Maintainable, my lords. As per
How is the
150
CRP maintainable?
115 of CPC, my lords. Kindly, CRP is maintainable. For a minute, my lords. Kindly see 1150, section 115, my lords.
Issue notice to the respondent, keeping open the question of maintainability of the civil division petition.
My lords, I sought for interim prayer, my lords. My lords, kindly hear me for a minute, my lords.
Yes.
My lords, kindly hear me for a minute, my lords.
Yes.
Number 27.
Therefore, petition, my lordship. Short accommodation. A week's time is granted at the request of learned counsel for petitioner for complaints of office taken.
Please.
Appealing for petitioner lordship.
Lordship, appearing for the petitioner, Lordship. Through VC, I am appearing for the petitioner.
Office
This case,
objection.
Lordship,
That I request your lordship to overrule the office objection, your lordship.
Annexure D.
That
bearing of-
certified copy has to be produced, your lordship. That online copy which I have received,
certified
same is a
copy of Annexure D. What is this? Annexure D?
annexure D challenging the impugned work order, your lordship.
Work order.
Yes, lordship, which is undated work order, your lordship.
Ah.
Lordship, I would like to draw attention of this honorable court where the respondent number as doesn't follow did not follow the rules and transparency, lordship. There is serious, lordship, where technical committee report has scrutinized all the tender documents specifically, lordship, and the respondent number 2 has found that is ineligible for transportation of food grains, your lordship, which is at page number 45, your lordship. My request. Page number 45, lordship. Serial number 4, Bangalore Purva Taluku. In bid Sanke, serial number 3, lordship. V. Srinivas Reddy, Vinayaka Transport, Anararu. The detailed committee report as passed in the page number 51, your lordship. In 50, last third one, V. Srinivas Reddy, Vinayaka Transport.
50?
50, lordship, page number 50. Srinivas Reddy, Vinayaka Transport, your lordship. In page number 51, your lordship, at the last for ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿಯವರ ತಾಂತ್ರಿಕ ಬಿಡ್ ಅನ್ನು ತಿರಸ್ಕರಿಸಲು ಜಿಲ್ಲಾ ತಾಂತ್ರಿಕ ಬಿಡ್ ಪರಿಶೀಲನಾ ಸಮಿತಿ ತೀರ್ಮಾನಿಸಿತು. ಆದ್ದರಿಂದ ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ವಿನಾಯಕ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ರವರು ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕಿನ ತಾಂತ್ರಿಕ ಬಿಡ್ ನಲ್ಲಿ ಅರ್ಹತೆ ಹೊಂದಿರುವುದಿಲ್ಲ. This is a technical committee report, your lordship. Whereas the respondent number 1 in annexure D, page number 54, your lordship. I would like to draw attention, your lordship, in page number 55, serial number 3, your lordship. Serial number 2, Bangalore Uttara Valaya, that is Bangalore North Zone. Srinivas Reddy, Nigadi Prasa Ellondara, your lordship. And they issued a work order, your lordship.
Nothing is stated regarding the finding of the committee.
Lordship, the actually page number 22, your lordship, the minimum eligibility criteria they have given is.
In this order, nothing is stated about the recommendation of the committee.
Illa Swami, adu illa.
Nothing is stated, Lordship.
Nothing is stated. Illa. In page number 22, your lordship, they have given minimum eligibility criteria. May I permit to read? Page number 22.
1 minute, 1 minute. ಕಾರ್ಯಾದೇಶವನ್ನು ನೀಡಲು ಆದೇಶಿಸಿದೆ.
Yes, lordship.
ಜನವರಿ 2024.
Yes, sure. On 1810, the technical committee report has been issued, your lordship. Pass agide. And Dinanka 1/25, that January 25, and they didn't give date also. And they issued a work order, your lordship. On which date? Yaudu anta ಏನು ಹೇಳಿಲ್ಲ. If you take page number, your lordship, the eligibility criteria.
AGA takes notice for respondent number 1. Issue emergent notice to respondent number 2. Returnable by 12th of February 2025. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner has pointed out to the decision taken by the committee to consider the technical bid on 18/10/2024 at annexure C, wherein it is clearly held that
Respondent number 2.
the second respondent, Shri V. Srinivas Reddy, bracketly Vinayaka Transports, is ineligible and his technical bid is rejected. Full stop. Despite the same, the first respondent commissioner has declared respondent number 2 as the successful bidder and has issued work order at annexure D. Full stop. Next para. The work order issued in favor of respondent number 2 will be subject to the outcome of this writ petition and any further orders that could be passed by this court on the next date of hearing. Please, next para. Learned AGA is directed to secure instructions in this regard and make submissions on the next date of hearing. Yes.
Stay.
Yes.
Till then not to precipitate.
Work order is already issued.
Yes, Lordship, but where is?
We will see. If necessary, we will pass orders on the next week after the appearance of the respondent. Yes. Huh? A week's time is granted for complaints of office objection. ಅದು ಇದರಲ್ಲಿ previous matter ಅಲ್ಲಿ office objection is overruled. Huh? Yes.
No, I pay for the petition in this case.
Yes.
Tender matter, no, I will complain the office subject during the course of the day.
Huh?
I will complain the office subjection during the course of the day. The matter may be called on the Friday. There's an urgency in the matter, tender.
Friday.
Friday.
If office objections are complied, list this matter on 31st of January for preliminary hearing. Yes.
31.
Govindacharya takes week's time.
A week's time is granted for complaints of office objections.
Non-compliant for second time.
For 33, my lord.
Huh?
33.
Matter is called out. There is no representation for the petitioner.
My lords, I'm from here for 33, my lords.
No, 32. In this case, petitioner. ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? Why you not complied with the office objections?
Next day, one take.
You take interim orders and you don't want to comply with the office objections. Finally, a week's time is granted. All office objections are overruled. Yes. Interim order granted earlier stands extended till the next date of hearing. Yes.
33. Nagendra Nayaka.
My lords, I'm appearing for the petitioner in this case. We have complied with the office objections, my lords. This is the office objection was with respect to annexure A of providing certified copy. Have produced dispensation for
Dates and events to be
that is also
stated
done.
in the chronological order.
That is also done. My lords.
When?
Yesterday, my lords.
Yesterday.
Yes, my lords.
Certified copy of annexure A.
That we have produced. We have sought for dispensation. I am, my lords.
What is annexure A?
Annexure A is the order of the police, including the petitioner in the B rowdy sheeter list, my lords.
Huh?
Annexure A is the order of Sahayaka Police Upayukta.
If you are challenging this, you have to furnish certified copy. That cannot be dispensed with.
Yes.
Please furnish certified copy.
Yes, my lords.
We can grant you time.
Yes, my lords.
But you can't seek dispensation.
Oh, yes, my lords. Meanwhile, stay, my lords. This is
Stay
covered
what?
by the judgment, my lords.
His name is enlisted in the
B rowdy sheeter list is a contractor, my lords. The cases which he has done is acquitted and B report has been filed. In 3 cases, as per the annexure A, my lords, there are 3 cases which are listed.
takes notice for all the respondents.
Yes, ma'am.
Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Stop. Next para. Learned AGA is directed to secure instructions and make submissions. In the meanwhile, office objections will be complied with. Yes. Release this matter on 7th of February. Yes.
This matter, my lord, the office objection is to serve the copy to the panel council for National Highways Authority.
ASG.
Has served.
ASG. Union of India as a party?
No, my lord, National Highway is the party. I served it to panel council, my lord, that is Shobhit N. Shetty is the panel council.
Learned counsel Shri Shobhit N. Shetty is requested to Bandra.
Please.
Yes.
Just now they served copy to, I'll get the
Today I
instruction, I'll make
served.
my submission.
Learned counsel Shri Shobhit Shetty.
Shobhit N. Shetty.
N. Shetty undertakes to appear for the respondent. Full stop. Learned counsel submits that he has received copy of the petition along with annexures today.
Just now.
Full stop. The learned counsel would therefore seek for some time to secure instructions and make submission. Yes. Release this matter on
Next week, any.
Short date.
5th of February. All right.
Complaint for third time. Shishikant Prasad.
My lord,
Paid
the petitioners had
interim order.
earlier
Paid.
approached this honorable court in the previous petition, which is 35.1. The very same section 14 order was challenged in that. An interim order was passed, which was not complied by them.
Paid your.
Later, now they approach with the fresh petition, which is 35. The same section 14 is challenged in this as well by two different advocates.
Paid the.
In the
interim order.
present petition, they've complied not within time, but later they've complied in the first petition.
%25% of the outstanding amount.
Please.
Huh? What is the outstanding amount?
Was after deducting the amount that is paid as on 22/1, it is 17.92 lakhs. They've complied now in the first petition, my lords.
They have complied.
Yes, not within time, later they've complied. Lords, the other petition 35.1 was first filed by the petitioners. In that also section 14 order was challenged. An interim order was passed. They have not complied that. Instead, they file a fresh petition, which is 35. In that, an interim order was passed for 25% of the outstanding.
The next writ petition is for what?
In both, they've challenged section 14 order. Physical possession order of the
Same.
matter. Same.
Henry.
I don't know.
Huh? What are the other?
In both the matters, have not been served the copies, even though I've made submissions on the last date.
Three 2023, Annexure C. 2023, Annexure B. Same.
Same petition, my lords.
Huh?
Same petition, criminal miss 251/23, order dated 3/8/23.
Namo Maruti Chits.
Petitioners are also same.
How can you go on filing petitions after petitions? And you say you are not filed another petition on the same cause of action?
I've filed.
Huh?
34,004. 35 is mine. I don't know for first petition.
Both are filed by two different.
Advocate ಬೇರೆ. Parties are same. Huh? You have stated, except filing this writ petition, petitioner has not, Allah. The petitioner has not filed any other appeal or initiated any other proceedings before this court or any other court for the same subject matter. Huh?
In the first petition, the interim order was not complied. Therefore, they filed
That
the
is why they have
they
filed the
filed
second
another
one.
petition.
Huh?
Yes. Interim order was granted on 25/7/24 in the first petition.
How much have they deposited now?
Now they've deposited 25%.
Esto?
Comes around.
You have filed the acknowledgement?
Yes, statement of accounts are filed.
Already acknowledgement,
Statement
statement of account.
ಹೌದು.
Illi?
I was given this. Yes, no. 5,16,000. In that, I paid 5,16,000. Once I paid 4,50,000 and 66,000.
They've paid 5,16,000. After deducting that, the outstanding as on 22nd January is 17.92 lakhs. They approached the bank for OTS as well. That also they have not complied.
Ian, how can you do like this? Huh? There is already a petition pending.
Yes.
You have filed one more writ petition. Huh? ಏನ್ ಮಾಡೋದು?
Both can be disposed of in view of section 17. They can approach DRT. if they- The first petition, they have not complied. Second, they have complied. Both can be disposed of with liberty. The first one may be dismissed because they've not complied the order.
But the amount is small.
That's the reason they were offered an OTS as well. However, that also they have not complied.
Yes, my lord, let them file an affidavit before this honorable court. Within 1 or 2 months, they're going to close the entire dues. In fact, that my lord undertaking, my lord, this matter can be.
Writ petition number 19511 of 2024 is required to be dismissed in view of the non-compliance of the directions issued by this court. Stop. Accordingly, writ petition number so and so stands dismissed. ಈ ಇನ್ನೊಂದರಲ್ಲಿ learned counsel for petitioner has filed a memo along with statement of accounts showing the deposits made by the petitioner in compliance of the directions issued by this court, but not within the time fixed by this court. Full stop. Nevertheless, the petitioner has deposited, next para, rupees 5,16,000. And even according to the respondent, learned counsel for the respondents, the balance outstanding may be around rupees
18 lakhs as on 22nd January. 17.92 lakhs as on 22nd January.
So including this.
After deducting this.
After
deducting this.
About 18 lakhs.
As on 22nd January.
18 lakhs.
17.92 lakhs.
17.92
lakhs.
92 lakhs.
As on 22nd January.
As on 22/1/2025. Full stop. Next para. The petitioners are required to file an affidavit of undertaking showing the payment schedule to clear the entire outstanding loan amount within a period of 3 months from today. Full stop. Release this matter on 6th of February. Till the next date of hearing, the interim order granted earlier stands extended.
Lords, the advocate may be petitioner, serve me a copy of the petition.
Put a copy for it.
Orders. Bill number 36, unique Krishnan.
Yes.
My lord, I filed an application, I am the defendant in the original suit filed by the respondent. I filed an application under Order 7, Rule 11A and D to reject the plaint on the ground that it is barred by law. My lord, my application has been rejected, hence I'm before this honorable court, my lord. My lord, the impugned order, my lord,
You know, what is the application you filed?
But I filed an application under Order 7, Rule 11,
Ah.
A and D,
Ah.
to reject the plaint on the ground that it's barred by law, my lord.
Hmm.
My lord, the very
Suit
same
for?
parties, my lord, had earlier filed a suit for partition. The defendant's number,
Where is the plaint?
my lord, the plaint, my lord, would get it. Notes.
Page 109.
109.
H.
Nobody knows. I would take, my lord, straight away to paragraph number 3, my lord, at page 111.
Yes.
The plaintiff submits that initially the plaintiff had filed a suit for partition and separate portion of his 1/3 share in all the joint family properties in OS 892/2008 before the Honorable Civil Judge, Senior Division and JMFC Devanalli against his mother Thangayamma and brother Nagaraj on 10/11/2008. The said suit, item number 4 is survey number 105/10 measuring 36 guntas at Jakkuru village, Elanka, Hubli, Bangalore. That is the suit schedule property, my lord, which is more fully described scheduled here under, my lord. Then, my lord, kindly come to paragraph 5, my lord. The very next page, 112. The plaintiff submitted thereafter during pendency of the suit. The plaintiff brother R. Nagaraj along with his son Anand approached both plaintiff and his mother for settlement. Based on mutual discussion and understanding, plaintiff along with his mother and brother agreed to partition the suit schedule properties and withdraw the said suit in OS 892/2008. According to the plaintiff and the defendants in the said case, filed compromise petition under Order 23, Rule 1 of CPC on 22/4/2009, and hence the matter was referred to Lok Adat and the final decree was drawn as per the compromise petition. The certified copy is produced. Now, my lord, after this compromise was effected between the parties, my lord, I as the 8th defendant would purchase the property from one of the allottees, that is Nagaraj, who was given the particular property.
No, please read paragraph 6.
6(1). The plaintiff submitted while filing the said compromise petition, the suit schedule property was acquired by the BDA for formation of Arkavati layout. Hence, the same could not be partitioned by meets and bounds. However, on the date of entering into the said compromise, there was a prospective purchaser who was intending to purchase scheduled property in as is various basis. As such, it was decided between the parties to said suit that plaintiff herein and late Nagaraj should share the award amount equally if the BDA passes award or sale consultation amount equally, if the land is denotified and sold to private parties. Further, it also agreed that the late Nagaraj shall additionally pay cost of construction of shed measuring 125 put up by plaintiff in the scheduled property from award of the sale consultation. This itself makes it crystal clear that the scheduled property is a joint family property of the plaintiff, different number 1 to 8. Then, my lord, it is notified and it is denotified also. Now there is no acquisition. It was then notified. Now, my lord, I would buy this property from this particular Nagaraj by virtue of a sale deed. Then, my lord, after many years, there seemed to be some dispute between the parties when I am not a party at all. And, my lord, this suit is filed seeking to declare my sale deed as not binding upon it. My lord, may kindly see the prayer in the suit, my lord. The prayer, my lord, is this. At page number 120.
No, in that compromise petition.
Yes.
To whom this property fell?
It fell to R Nagaraj. That is my vendor.
Where is that compromise decree?
Compromise petition, my lord, is annexure D, my lord.
Page?
My lord would get at page 54. There are many properties in that, of course, only one is part of that, my lord. I will, can I take my lord to page 56 is the operative part as far as this property is concerned. In terms of compromise, item number 4, this property. The suit scheduled property measuring 36 guntas of land in survey number 105/10, situated at Jakkur, Yelanka, so and so, Yelanka, Hubli, Bangalore, North Taluk. The said property has been acquired by the BDA. In view of the said acquisition, the plaintiff and second defendants have mutually agreed to share the award amount equally. In the meantime, plaintiff and second defendants agreed to alienate the said property to one of the prospective buyers.
Said it is fallen to the share of only Nagaraj, not so.
No, my lord, once again, my lord, as such, the second defendants agreed to compensate the amount equal to the total amount of compensation.
Correct.
My lord, my submission is this, my lord. Let us assume for a moment he has got right on this. I'll concede. Let us say he has got. But then, my lord, what happens is he would file the suit for declaration.
Yes.
In parallelly, since there was some observation between the suits filed inter se between them, they have now filed another petition to recall that compromise decree before the Devanalli court. So
Whatever it is, you are not concerned with that.
I'm concerned.
You have purchased the property with open eyes.
My lord,
Although it very clearly says, it falls to the share of 2%.
but can I make a submission?
You have purchased the property.
My submission is I will make a submission, my lord, may kindly see.
Yes.
Now, my lord, he also admits in his plaint that he has now filed a petition before the Devanalli court to recall the compromise, including this property, etc. My lord, I am not a party there. Now, my lord, this particular suit. Now, my lord, I take my lord to the judgment of the Honorable Supreme Court straight on the point. What?
Yes.
Can I just take, my lord?
Sure.
My lord, Order 23, Rule 3A
Yes.
would read thus, my lord. In fact, my lord, the Honorable Supreme Court, my lord, for Order 23, Rule 3A is, no suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful.
Was
So,
not?
lawful. Now, I will take my lord to the judgment, my lord. Similar.
Where is the need for you to seek such a prayer?
That's so happened, my lord.
You were also a sharer, even in terms of the compromise petition.
Yes, please, my lord.
Then
It so happened, my lords, in one of the suits. Earlier, my lords, it was pleaded, my lords, the suit scheduled property was a joint family property. Subsequently, what has happened, my lords, they withdrew that admission in the subsequent amendment, saying that, my lords, now initially, my lords.
He read out the compromise, terms
Yes,
of the
please.
compromise petition
Please,
now.
lords. Now it so happened.
And accordingly, the decree was drawn.
Accordingly, the decree was
Yes.
drawn, my lords. All that has happened, my lords. Subsequently, my lords, there was a suit filed.
What suit?
My lords, it was seeking for, my lords, a cancellation of a sale agreement, which was said to have been executed in favor of one Khadi board by the defendant as well as, my lords, the father of the
Not we, Navala.
Nivala.
I was nowhere involved.
The other defendant.
TV bro.
Yes, please, my lords. That suit, my lords, was filed for seeking cancellation and also, my lords, to declare it is barred by law. My lords, in that suit, my lords, what has happened, my lords? Initially, they had agreed, my lords, this property is a joint family property and all that. Subsequently, by way of amendment, they sought, my lords, to say that this suit scheduled property is the exclusive property of one Mr. Nagaraj, who is the husband of defendant number 2. Lords, in that circumstances, my lords, since they denied my rights, my lords, which was granted under the compromise, lords, I had filed, my lords, an application for reopening the suit to adjudicate my rights and, my lords, to have an exclusive right to the extent of my share. In the meantime, my lords, even before the judgment came to be passed in that suit, wherein, my lords,
What happened to that suit?
Lords, that suit came to be decreed, holding that, my lords, it is a joint family property of the plaintiff and defendants.
In favor of the Khadi board.
No, my lords. In favor of the plaintiffs therein, who are the defendants, my lords,
My vendor. My vendor it decreed in his favor.
It was decreed in their favor. May my lords draw your attention to that decree, and which was observed in the in the order itself. Kindly see, my lords, page number
Note, so
27 onwards of the order.
Point.
29 onwards.
What is this?
No, my lord, can I just read this?
Order.
Yes, please. Page number 47, in page number 47 of the petition. Internal page 29 of the order. Let's may I read, my lords? It is pertinent to note that it is also discussed that if any land left out by the BDA upon the defendant obtaining NOC from the BDA for the extent, the defendant had the right to it and the plaintiff shall not claim any portion upon that. Now, it is pertinent to note that this fact is relevant fact in issue, as the land was not acquired and compensation was not allotted as awarded and was not passed, and the rights of the parties to be adjudicated. These facts are available for adjudication, and this court cannot decide it without full-fledged trial, and both the parties has to produce oral and documentary evidence. While perusing the judgment notes, that is the judgment notes where the Honorable Court has held, passed in voice number 2279 of 2014, the issue number 1 raised stated in paragraph number 10 is as follows: whether the plaintiff proves that the scheduled property is an ancestral property of themselves and defendant number 1 and 2, and they are the joint owners of the scheduled property. It is pertinent to note that the suit filed by Anand, son of Nagaraj, and Raja, son of Nagaraj, as against Ramrajappa, son of Pujari Ramaya, Kantamma and others, for the above stated issue, the court has observed in page number 24, paragraph number 23, as follows. It is to be noted here that earlier the plaintiff in the present suit have contended that the suit scheduled property is the absolute property of Nagaraj. But thereafter, they have got amended the suit plaint, and they have pleaded that they came to know about the compromise decree in voice number so recently during the month of 2021. Hence, the plaintiff thereby admitted the fact that the suit scheduled property is a joint family property of themselves and defendant number 1 and 2. Though the plaintiffs have got amended is in accordance with the compromise decree in voice number so, the proposed amendment cannot be considered as time barred. The fact which are on record in voice number so is pleaded by the plaintiff by way of proposed amendment. Page number 26, line 23. Under these facts and circumstances, I am of the opinion that it can be come to the conclusion that the suit scheduled property is an ancestral property of the plaintiffs and defendant number 1 and 2, and it came to be it can come to the conclusion that the plaintiffs have proved that the defendant number 1 and 2 are the joint owners of the scheduled property. The plaintiffs have proved issue number 1, hence answer so and so. Let's page number 39, line 4 reads as follows. It is already discussed and held above that the plaintiffs and defendant number 1 and 2 are the joint owners of the scheduled property. The court in voice number so and so observed that both the plaintiffs and defendants in that case are joint owners of the property. Both counsels submitted that this judgment is challenged before the Honorable so and so. It is pertinent to note that in the above case, they say it is a joint family property and ancestral property, and in the present suit, they say it is a self-acquired property. These facts cannot be decided at this stage without going into the evidence and documentary evidence of the parties. That's coming to the bar minutes. The Honorable Court has also dealt with the provisions of 23 Rule 3A. The main contention of the defendant in the suit is barred under so and so. Before going to discuss about this court opines it is better to glance at the provision. 23 Rule 3A reads follows. I will skip that minutes. It says, no suit shall lie to set aside a decree. To understand and to discuss more, it is better to glance a prayer in the present plaint. It has been extracted up to page number 33. As per the prayer, the plaintiff has not sought for any prayer to set aside the decree. The plaintiff has sought a different prayer, and the parties also different from the earlier cases. The counsel for defendant number 1 submits that the present
Declare that the purported sale dated so and so registered is null and void. Grant perpetual injunction.
Yes, please, Lords.
Consequently, direct the office of the to send copy of the judgment
There is no, my lords, prayer.
ಎಲ್ರು ಕೇಳಿದ್ದಾರೆ.
ನಾನು ಹೇಳ್ತೀನಿ sir, ಅದಕ್ಕೋಸ್ಕರ I was just saying. Lord, my submission would be this. My lord, may
Yes.
kindly see the judgment of the Honorable Supreme Court. My lord, may kindly see the judgment of Honorable Supreme Court.
Yes.
Straight, identical circumstances. At para 9, I'll come straight away to para 9. my lord. Similar identical situation, a compromise. In view of the above, my lord gets, my lord, para 9. In view of the above, the Honorable Supreme Court would call out all the circumstances, my lord, would say, in view of the above decisions of this court, the trial court was absolutely justified in rejecting the plaint on the ground the suit of the relief sought challenging the compromise decree would not be maintainable. Now, so far as submission on behalf of the plaintiff, that in the suit, the plaintiff has not specifically prayed for setting aside the compromise decree, and what is prayed for is declare the compromise decree is not binding on him, and that for other relief sought.
ಎಲ್ಲಿದ್ದಾರೆ? Even that prayer is not there.
ಅಲ್ಲ, ನಾನು ಬರ್ತೀನಿ ಸ್ವಾಮಿ, ನಾನು ಹೋದ್ರು
What is the use of reading
My
this
lord,
kind of a
kindly,
judgment?
para 11 ಬಂದ್ಬಿಡಿ. Para 11.
He is not even sought for such a declaration.
Para 11.
Yes.
Para 11. If we consider the reliefs of declaration of title, recovery of possession, cancellation or revocation of gift deed, declaration for DGP and deed of assignment so and so, said relief can be granted only if the compromise decree dated so and so passed in OS is set aside. Therefore, by asking for such multiple relief, the plaintiff by clever drafting wants to get his suit maintainable, which otherwise did not be maintainable, questioning the compromise decree.
Sir, there is nothing about the compromise decree now.
My lord,
Who told you that they are seeking to consider that decree as null and void? ಏನು ಇಲ್ವಲ್ಲ?
No, he has filed a petition for that. That is what I have been telling you. He has now filed a petition to set aside the decree. Kindly see page 124.
Then you raise.
I can't go, my lord. I am not a party in that suit.
That is not the subject matter of this suit.
My lord, the subject
You
matter.
can't say in that petition he has claimed.
My submission is, my lord, my submission is only this. My submission would be this, my lord, that if that compromise decree is set aside, my lord, my sale deed would be set aside.
Sir, that suit may be dismissed. Who knows?
No, that's a
We are
different.
not
My
concerned.
lord, he will have to go and
We are
raise
not
all the
concerned
issues
about the
there.
prayer made in some other suit.
Can I file another set of judgments of the coordinate court?
No.
My lord, I will rely upon these, my lord.
No, sir. ಬರ್ಕೊಳ್ಳಿ. The petitioner, who is defendant number 9 in the suit, filed at the hands of respondent number 1 herein, is aggrieved of the rejection of his application filed under Order 7, Rule 11, A and D of the Code of Civil Procedure. Full stop. Next para. The prayer in the suit in OS number 4401 of 2024 is as follows. Extract ಮಾಡ್ಕೊಂಬಿಡಿ. In page number 50 ಅಲ್ಲಿ extract ಮಾಡಿದ್ದಾರೆ. Same thing you can extract. A to A ಅಂತ mark ಮಾಡಿರ್ತೀನಿ. (50-51). Next para. It is the contention of defendant number 9 where is your application?
My lord, IA number 3, my lord.
It's page 145. Page 145 minutes, annexure K.
Yes. that in a prior suit filed in OS number 892 of 2008 before the senior civil judge and JMFC at Devanhalli, a compromise petition was filed between the parties who are family members that the suit schedule property, being one of the items of the schedule in OS number 892 of 2008 was notified for acquisition by BDA, and if BDA were to denotify the acquisition, then the suit schedule property will fall to the share of Sri R. Nagarajappa, the father of dependents number 5 and 8 herein. And that Sri Ramanjanappa, the plaintiff herein, will not claim any right over the said item of the suit schedule property. Full stop. It is contended that thereafter the suit schedule property was denotified and Sri Nagarajappa became the absolute owner of the suit schedule property. Stop. The ninth respondent's vendor, Sri Yarre?
Kantamma, wife and son. Wife and son of Nagaraj.
Who purchased the property?
Eighth defendant. Eighth defendant under petitioner here.
You have purchased from Nagaraj?
Yes, I purchased.
Ninth defendant. Ninth defendant.
Ninth defendant. I purchased directly from him. I produced it at page number.
Ninth defendant. Ninth defendant.
Page 61, annexure E, my lord.
ಏನು ಹೇಳ್ದಮ್ಮ? Suit schedule property, full stop. Lokesh TL and N Dinesh.
N Dinesh.
Both of them purchased the
Both of
property.
them purchased
Together.
But L Dinesh is not the petitioner. I made him a formal respondent.
So he is also a party to the suit.
Yes, he is also party.
But application was filed only by
us.
Huh? Thereafter,
I made him 10th respondent here.
Defendants number 9 and 10.
Yes, madam.
Purchased the property under a registered sale deed dated 18/3/2023 from the wife, children and grandchildren
of
Sri Nagaraj.
Yes.
Full stop. It was therefore contended that the plaintiffs, being party to the compromise petition, entered in OS number 892 of 2008, cannot now be permitted to raise a plea that the suit schedule property is a joint family property. Full stop. Next para. During the course of these proceedings, this court had a look at the compromise petition, which has been produced at annexure D. Page number?
54. Operative part 56 and
Annexure B.
D, B.
B. And found that item number 4 of the suit schedule property in OS number 892 of 2008, which is the subject matter of the present suit, which measures 36 guntas in survey number 105/10, situated at Jakkur, Yalanka Hobli, Bangalore North Taluk. Was mutually agreed to be shared between the plaintiff and the second defendant. Namely, Sri Ramanjinappa and Sri R. Nagaraj, contrary to what is sought to be made out by the ninth respondent. Full stop.
My lord,
It
can I
was
make a
also-
submission, one submission, my
It
lord?
was also agreed that in the meantime, plaintiff and second defendant have agreed to alienate the said property to a prospective buyer, and they have agreed to share the consideration amount equally. Full stop. Next para. Contrary to what is sought to be made out by the ninth respondent, no such prayer is made in the suit seeking the setting aside of the compromise decree. Full stop. On the other hand, now it is sought to be submitted at the hands of the learned counsel for respond number 9, that the very same plaintiffs have also filed OS number.
OS ಅಲ್ಲ, same, ಅದರಲ್ಲಿ they have filed an application to recall that.
4401
ಯಾವ್ದ್ರಲ್ಲಿ?
2020.
ದೇವನಹಳ್ಳಿ.
OS number milots 22.
I produced 124 one, page 124 really, annexure J.
2279 of 2020.
79 ಅಲ್ಲ sir, 892.
ಯಾವುದು? ಅಲ್ಲ, ಅದು ದೇವನಹಳ್ಳಿ. 2279 of 2014 minutes.
ಯಾವ ಪೇಜ್ ನಂಬರ್ ರೀ? 22.
That is, Milots is referring to Milots which.
No, he submitted, there is one more suit you have filed. ಯಾವ್ದದು?
ಅದೇ ಇದೆ ಈ suit.
Present suit.
Present suit. ಇದೇ suit. First suit is 892 at ದೇವನಹಳ್ಳಿ.
In which suit, sir, he is asking for setting aside of the
4401 ಇದು
4401 of 2024.
Present suit. Milots.
present suit.
Present suit.
ಹೌದು.
There is no such prayer.
ಅಲ್ಲ, he only.
I don't know, you were submitting that they have filed one more suit and there they are asking for that.
ಅದೇ ನಾನು ಹೇಳ್ತಾರೆ 124. I'll make a submission.
One?
At page 124. They have filed an application in the decreed suit, compromise decreed suit to recall that decree. 124, I produced that, Malak. And he also admits that in his plaint.
When have they filed?
This was filed recently, Malak.
Before,
It was filed very, very recently, probably this year, last year, Malak.
It was filed Milots prior to Milots. The suit in OS number 2279 came to be disposed.
That 24, must be in 24.
They denied my rights Milots. I have sought for reopening the compromise and to proceed with the matter.
ಏನಾಯ್ತು?
Milots, the applications are still pending.
That is filed recently, Malak.
ಏನ್ ಹೇಳಿದೆ? I have also filed an application in OS number 892 of 2008, seeking to recall the compromise decree dated 22/4/2009, reopen the suit and proceed with the original proceedings, or to pass such other orders as the court may deem fit. Full stop. Next para. Reliance is sought to be placed on a judgment of the Honorable Supreme Court in the case of Sri Surya Developers and Promoters versus N. Shailesh Prasad and others. Full stop. Next para. Having heard the learned counsels.
I am also placing one more judgment of coordinate.
Not necessary.
I'll just place, my lord, I'll record.
ಈ facts ಅಲ್ಲಿ ಬರದೇ ಇಲ್ಲ.
ಬರುತ್ತೆ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ.
Not necessary. Having heard the learned counsels for the petitioners as well as the contesting respondent number 1, and on perusing the petition papers, this court finds that the contention sought to be raised by the 9th respondent in the application filed under Order 7 Rule 11 are not in any way substantiated by the material already placed on record. Full stop. The decision in the case of Sri Surya Developers, which is sought to be relied upon by the learned counsel for petitioner, deals with a situation where deals with the situation having regard to the provisions contained in Order 23 Rule 3A of the Code of Civil Procedure, and bars a subsequent suit being filed for annulling a compromise decree entered in a previous suit. Full stop. The trial court has rightly considered the contentions
My lord may say on para 11 also.
Raised by the 9th defendant, it has culled out the prayer made in the suit and has rightly come to conclusion that no such prayer has been made in this plaint, in this suit, seeking the annulment of the compromise decree in OS number 892 of 2008. Full stop. The trial court has thereafter come to a conclusion that while perusing the plaint averments and documents filed by the plaintiff along with the plaint and submissions made by both the parties, the cause of action and limitation, and whether the suit is barred by law or mixed questions involving law and fact, and at this juncture the court cannot discuss nor go into the other documents produced by defendant number 9. Stop. Next para. This court does not find any infirmity in the impugned order. Full stop. Accordingly, the CRP stands dismissed.
My lord, the observation made by this court, my lord.
Any observation made by this court touching upon the merits of the matter shall not prejudice the case of any of the parties before the trial court.
My lord, early disposal, my lord, because I am the subsequent purchaser, my lord, at least at least on 6
No,
months.
no,
my
no,
lord.
no. Yes.
That's my name is not shown in the cost title, not census.
Huh?
My name is not shown in the cost title. Just
Anish Jose Anthony.
No, my lords. Sunil P. Prasad.
Additional local.
That has not been shown.
Office is directed to show the name of learned counsel Sri
Sunil P. Prasad.
for
For the
respondent
respondent.
number 1.
Please.
Yes.
Great.
I represent the petition.
In this matter.
Yes.
It's in this matter. I had
Lordship,
filed an
well-
application for vacating the stay. Matter had come on 27. Lordships had posted today to finally dispose of.
Yes.
Lords, I have a preliminary objection of maintenance of this writ petition. So,
I'll address lordship's notes on all questions. Please. But
Let
third
him say,
respond,
what is that
please.
preliminary objection? Yes.
Kindly see the prayer, my lords,
Yes.
at page.
And thus directing respondent number 2 to enforce its direction issued under the communication dated 3/1/2022 to respondent number 3 at annexure H.
Lords, the petitioners are the non-members of the society who sought for enrollment as members. The committee, my lords, which had completed its term, had passed a resolution based on the general body's direction that the term is extended because of COVID, and they will proceed to conduct the election. The managing committee wrote to the authorities that we are ready for conducting the election. Please appoint a returning officer. At that point of time, certain non-members make a representation before the second respondent, asking him to direct us to enroll them. The first thing is, my lords, there is no such right in a non-member invoking the jurisdiction of second respondent, nor second respondent has any jurisdiction to direct enrollment of non-members. We wrote to him saying that there is a resolution by the general body and we are only holding temporarily, we can't enroll them. We are proceeding to hold election, please appoint somebody. That was accepted and left at that point of time. Lords, these non-members file
Elections were subsequently held.
No.
Huh?
They file an application before this honorable court, and this honorable court has made an interim order. Kindly see the interim order. The order reads like this. Application IA is filed, being supported by an affidavit seeks interdiction of holding of elections on the ground that there is no ready voters list, which is a precondition in view of the catina of decisions. Holding of elections without updating the electoral rules is nothing but a fascist democracy. In view of the above, the application is favored and response society is directed not to notify. How can there be a direction to the society not to hold the election at the hands of non-members, lords of the society? Now, therefore, lords.
It's not our relief. If
All right.
my learned senior
Yes,
counsel,
yes,
that is not the relief at all
Yes.
about elections.
yes.
This third respondent society before your third respondent is an association of Balijiga communities They were registered fundamentally for betterment of the members of the said community as well as for philanthropic purposes. The petitioners before your lordships are all members belonging to the Balijay community, but I am told, subject to corrections, the Balijay community in the state of Karnataka is about 7 to 8 lakhs, roughly, not exact numbers. And the petitioners among themselves formed this club with a very few members. And
When was it formed?
it was formed in the year, I'll just bring it, registration.
1920.
1920, it's a very old.
1920. 1920.
Yes.
Kaivara Tataya, that is his followers. Very celebrated community, no doubt about it. Now petitioners are all or wanted to enroll themselves as members. Obviously, that community, this society represents the community.
Yes.
That was rejected solely on the ground that the managing committee's term has come to an end by the managing committee. At that point of time, we went before the registrar of societies and saying that, look at this, we have no other remedy, we have come before before the authority. Then the authority directs them, look at this, you have been registered before the registrar of society. You have bylaws are registered. This bylaws provide for membership to be enrolled. If you do not enroll any new members and hold elections, obviously with a close community of members, that would be something which would be undemocratic, goes against the spirit of the registration of the society. That is how the direction has been issued by the registrar of society. But today, what is called into question before your lordships is nothing to do with election, etc. But in all responsibility, I must submit before your lordships. All that we are saying
This is the enrolling of
members. They are Balijika community. They represent Balijika community. They say they represent before the state that we belong to.
Yes.
All members who belong to Balijika community are, all that we are saying is, under the bylaws, if we are entitled to be registered, please register. No, we do not kindly see the attitude of the governing council. But may I request lordships to first permit me to read the relevant bylaw at page 18. At page 18, bylaw, anta start. At page 18 on the left-hand side, lordships. ಸದಸ್ಯತ್ವ ಈ ಸಂಘದ ಧ್ಯೇಯೋದ್ದೇಶಗಳನ್ನು ನಿಯಮ ನಿಬಂಧನೆಗಳನ್ನು ಪರಿಪೂರ್ಣವಾಗಿ ಅನುಸರಿಸಲು ಬಲಿಜ ಜನಾಂಗದ ಎಲ್ಲ ಪುರುಷರು ಮಹಿಳೆಯರು ಈ ಸಂಘದ ಸದಸ್ಯರಾಗಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಈ ಸಂಘದ ಸದಸ್ಯರಾಗಲು ಬಯಸುವವರಿಗೆ ವಯಸ್ಸು 18 ವರ್ಷ ಪೂರ್ಣವಾಗಿರಬೇಕು. ಇವರ ಸದಸ್ಯತ್ವವನ್ನು ಅಂಗೀಕರಿಸುವ
Sorry to interrupt, my lord. It's unnecessary to go into this. Lords, we are not denying them the membership.
You are only saying,
We are only
at
saying
this
let
point of
the
time, when
let
the term
the
is over,
let new
we
committee
don't
come and
have
consider.
Let me complete.
That's exactly what was
that's nothing
stated in our
No, I
objections.
don't. But this is a definite. But they want to form a club among themselves. Keep getting elected. That can't be not. This election which they propose to contest election.
The question that is sought to be posed is,
Please.
At this juncture,
Please.
when the term of the office of the managing committee is already over,
No, at that note,
they have no right
no, the bylaw doesn't prohibit
to
them.
receive such an application.
No, the bylaw doesn't prohibit. That's all the time.
The bylaw will not provide for this kind of a situation.
Please.
The right for consideration of an application would lie only with an elected body in.
I'll just point out that aspect.
Therefore, that is what they are saying. At this point of time, when our term is over, we don't have that right to consider your application. Let us hold the election. Let the new managing committee come into force. Thereafter, we will consider your
Today,
application. That is all that they are saying.
I understand. I understand. All that they are saying now is, but there is a group of voters with who has been enrolled by ourselves, our driver, our cleaner, our house kitchen.
No.
That is how this society has been.
Whoever is an eligible member
Person, therefore,
has a right to vote, and the voters list would be accordingly prepared.
No, today the difficult
From amongst the existing
because
members.
our applications were much earlier.
Your application is still to be considered.
Well, our applications were much earlier. Well, I'll just point out the eligibility
Yes.
and then go to lordships.
It's not about your eligibility, sir.
Then lordships,
What they are saying is,
lordships may then
you
kindly
don't have the right to consider your application.
No,
at
that,
this
that
point
would
of
be the question. That would be kindly see page 19.
Yes.
on the right hand side. ಅಧ್ಯಕ್ಷರು, ಉಪಾಧ್ಯಕ್ಷರು, ಗೌರವ ಕಾರ್ಯದರ್ಶಿ, ಸಹ ಕಾರ್ಯದರ್ಶಿ, ಖಜಾಂಚಿ ಮತ್ತು ವ್ಯಕ್ತಿ ಸದಸ್ಯರು ಇವರುಗಳನ್ನು ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯಲ್ಲಿ 3 ವರ್ಷಗಳಿಗೊಮ್ಮೆ ಚುನಾಯಿಸುವುದು. ಹೀಗೆ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯಲ್ಲಿ ಚುನಾಯಿಸಲ್ಪಟ್ಟ ಅಧಿಕಾರ ವರ್ಗದವರು ಮತ್ತು ವ್ಯಕ್ತಿ ಸದಸ್ಯರು ಮುಂದೆ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯಲ್ಲಿ ಮತ್ತೆ ಚುನಾವಣೆ ಸಭೆ ನಡೆಯುವವರೆಗೆ ಅಧಿಕಾರದಲ್ಲಿರುತ್ತಕ್ಕದ್ದು. Which would, according to
What they are also saying.
all that I am saying is not, but all that I am bringing to Lordship's notice is unless they show an express prohibition.
They are not saying you are not eligible. They are saying we don't have the right to consider your application now.
Unless they
Let
show.
there be an elected body in place.
Yes.
They will consider it.
What is very critical and crucial, according to me, would be the updating of voters list for the purposes of a democratically elected governing body, for which, my lord, all members, all persons who are eligible to be enrolled members until the cutoff date must be provided an opportunity. Now, for them to come before your lordships or to tell us that we have completed our tenure, we can't enroll, there is no express prohibition under the bylaws, is my respectful submission. Lordships may kindly see, in fact, my lord, when their term came to an end, there was this period of COVID. And the term was extended by 6 months. The term was extended by 6 months. It is at that point of time we have given application. And even now, my lord, all that I am bringing to lordships notice, even now, if the registrar is before your lordships, the society is before your lordships, if they are to fix a date for elections, and before that, my lords, give a window period of 15 days, 20 days, 1 month for the purposes of enrolling members. But that would only
That will be contrary to the bylaws.
No, bylaws doesn't prohibit. No, all the time just
Look at bylaws where they would provide for who can become member, how they can become member.
that is not at page 18 only.
Yes. And how voters list has
So
to be prepared.
ಅದರಲ್ಲಿ ಏನು
ಅದೆಲ್ಲ ಇದ್ರೆ
if there is a prohibition, no, I am straight away out. Not 18 page 18 ಅಲ್ಲೇ ಕೆಳಗಡೆ ಬರುತ್ತೆ.
Yes.
Page 18 left hand side. These are the conditions. ಈ ಸಂಘಕ್ಕೆ ಸೇರಲು ಇಚ್ಛೆಯಿರುವ ಪ್ರತಿಯೊಬ್ಬರು ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಯಾವುದಾದರೂ ಸದಸ್ಯ ವರ್ಗಕ್ಕೆ ಸೇರಿರಬೇಕು. ಮಹಾಪೋಷಕರು so and so, so and so. There is no prohibition, Lord, that this has to be
No, voters list has to be prepared.
ಇದರಲ್ಲಿ
There is anything.
there is nothing.
Otherwise, you'll have to fall back on the general principle.
That's all. There is nothing. There is no prohibition. There is no prohibition.
Yes.
No voters list is there. Voters list.
What about elections?
This is all not that term which I pointed out. So they continue to be in office till the next election takes place. In between COVID intervened, their term is extended. It is at that point of time we filed. Not, of course, now time has lapsed because of the stay order, etc. But we filed application when they were in office. And that has been rejected. No, we can't continue because our term, but COVID. All that I am saying is, Lord, even now, lordships may direct facilitate elections. Let them, Lord, fix a window period. I don't know, Lord, what is the prejudice cost to them. Obviously, Lord, to come up before your lordships under Article 226 to say, I will not enroll these members is obviously to create your own lobby for the purpose of the election. Would lordships not exercise those jurisdiction in their favor in these circumstances?
This kind of a contention will go against the rulings of the Supreme Court.
But that is
ಏನಾಗುತ್ತೆ,
please,
for the purpose of holding elections, if they decide to enroll certain members.
No, that I agree.
What is the consequence?
ಅದಕ್ಕೆ cut off. Please, I understand.
That would not be permissible.
ಅದೇನಾಗುತ್ತೆ lordships, I fully understand. But if there is a just before the ensuing election, if members were to be elected for the purpose of creating,
ಯಾರ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಕೋತಾರೆ, ಆಮೇಲೆ then others will be in.
Of course, not here. It is a reverse situation. Elections are yet to be declared. But all that I'll put it across before your lordships. Elections are yet to be declared. If election schedule of the events have come, the decisions of the Honorable Supreme Court deal in situations where, contrary to the bylaw, contrary to the statute, a membership drive was taken, or in a case where administrators sought to enlist members during that interregnum. Here, there is no provision for the administrator. This is an elected body, which would function in. For instance, it is just not enrollment of members. All decisions under the bylaws which they are empowered to, they have been taking in the last few years.
So nothing touching upon these aspects in the bylaws?
Your lordship, no, it is there, my lord.
Let them show it, my lord, then
Page,
If there is something,
No.
let us see.
page 18.
Otherwise, we'll have to fall back upon the general
No,
principles.
page 18 itself.
That is only regarding eligibility.
No, for the committee to consider.
Ah.
Now, if a committee's term has come to an end, and if we want to constitute a committee, surely they can't restrain us from constituting.
Which is that?
nobody is restricted.
Let's clause 4 at page 18. ಈ ಸಂಘದ ಸದಸ್ಯರಾಗಲು ಬಯಸುವವರಿಗೆ ವಯಸ್ಸು ಆಗಿರಬೇಕು. ಇವರ ಸದಸ್ಯತ್ವವನ್ನು ಅಂಗೀಕರಿಸುವ ಅಥವಾ ತಿರಸ್ಕರಿಸುವ ಪೂರ್ಣ ಅಧಿಕಾರ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಇದೆ. The ಆಡಳಿತ ಮಂಡಳಿ is not in place. Your lords are familiar with
Where,
it.
where did you read that?
Page 18.
Page 18, my lords.
Left hand side, is it?
Left hand side, the third paragraph. ಈ ಸಂಘದ ಸದಸ್ಯರಾಗಲು ಬಯಸುವವರಿಗೆ ವಯಸ್ಸು 18 ಪೂರ್ಣವಾಗಿರಬೇಕು. ಅವರ ಸದಸ್ಯತ್ವವನ್ನು ಅಂಗೀಕರಿಸುವ ಅಥವಾ ತಿರಸ್ಕರಿಸುವ ಪೂರ್ಣ ಅಧಿಕಾರ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ. The ಆಡಳಿತ ಮಂಡಳಿ should be in place.
All right.
Now you are restraining the ಆಡಳಿತ ಮಂಡಳಿ to be in place.
Yes.
Apart from the general principle which my learned friend concedes, that even an administrator, when he is supposed to conduct an election, can't enroll, nor the term which has come to an end can enroll, which will go against the general principle. Now, more importantly, I wrote to the authorities saying that this is the restraint under which we are placed. So therefore, please, in 2001, my lords, we wrote to them to appoint a returning officer. They don't do that. Now he issues a direction saying that you enroll them merely because some representations have been made. Very same day, he directs. There's more to say that. I don't want to go into that. But I asked myself, what authority does second respondent have to direct this Sangha to admit them, lords, in terms of the order which is sought to be implemented by a writ of mandamus? First thing is there is no locus. Second is respondent number 2 has no authority. On the representation, he issues me a notice. I reply to him saying that we are not denying them. Let the Sangha be constituted, then we'll admit. He is satisfied with that. After 2 years, after restraining me from conducting the election, they make one more representation and want this to be implemented. Surely this is not the way, lords. In a writ proceedings, there could be an enforcement of this kind of a plea as has been played in this.
But
Your lords may record my submission. The moment the new authority comes into a position, they will consider all these applications. Lords, just for my learned friends' information, up till 2018, there were only 4,000 members to this Sangha. They made a drive openly admitting and calling everybody to enroll. That, your lords may kindly see Annexure R2, the photographs we have produced. Periodically, my lords, we have conducted this election inviting public, and over double about 10,000 were admitted, my lords, going over all over the state. So it is not as though they did not seek for enrollment during this period, including, my lords, in 2020. After term came to an end, we said the new committee will take forward this drive of enrollment. Lords, this is something which, lords, somebody who's not concerned with this but wants to have a say, wants to, through these persons who have now moved this court for mandamus, to have a say before the election takes place, which is not permissible.
Yes. May I?
Kindly see, my lord, just one more information. Kindly see page Annexure R3. Page 39 of my statement of objection. This merely encloses the applications made by all these persons, numbering about 39 or so. To this, there is further direction to enroll these people, to which I have replied, which I have produced, my lords, in my statement of objection, enclosing the resolution of the general body, saying that you shall hold the election and have a day-to-day administration if need be. But by a restraint order of this honorable court, I am stopped from conducting the election. That's what I wanted to be vacated. Your lordships would vacate it, permit us to conduct the election. Once the election is conducted, very next day, the next opportunity, all these applications will be considered. Your lordship may record my submission to that. The question of denying them the membership doesn't arise. There's no material place to say that I had rejected. I had only said I can't enroll at this point of time.
Yes.
If need be, my lords, I will place before the court the judgment of the Supreme Court in respect of administrators, my lords, where court has pointed out the principles on which on the eve of election you can't enroll. That's the basic principle, my lords, in all these judgments. It may not be necessary, my lords, for the present, because I have questioned the very maintainability of this writ petition at the hands of non-members of this society, wanting enforcement of a direction issued by an incompetent authority.
Yes. I want to answer this in this manner. Lord, surely raises one question of law. Today, what is called into question before your lordships, irrespective of what the registrar's intervention happens, is the action of the society in refusing to admit us as members. Now, the question, Lord, which would directly be something, Lord, which my lords may have to adjudicate is whether the action of the society in refusing membership to a person, if he is otherwise held to be a member, would be justified. Whether it is justified, reasonable, and in accordance with law. Now, the reason assigned by them for rejecting my application is that our term has come to an end. Lordships may have to simply take this reason to see whether it is in accordance with the bylaws. But my respectful submission to lordships would be that the bylaws do not prohibit enrollment of a member unless the calendar of events is issued. Lordships may kindly note that. Therefore, straight away that endorsement of the decision is contrary to the bylaw. Now, lordships may also kindly look this in this manner as to my right. But it is in Zoroastrian Cooperative Society's case. Something similar happened. Of course, not there. They were refused on the twin questions. Lordships are aware not of the twin questions. One was whether a non-Zoroastrian could be the but there, yes. there is an important discussion.
Yes.
There, their lordships hold that though right to form an association is a fundamental right under Article 19(1)(c), may not include right to become a member, but yet the person who wants to become a member has a statutory or a right emanating from the bylaw. And if it is refused on arbitrary and flimsy grounds without a justification, the court can certainly intervene and restore his membership. But look at my situation today. Look at my situation, and not only my situation of large number of persons like us. Today, they claim that they belong to a particular community, they represent that particular community by registering the society. But we can't become members of that society. And the only ground they say is...
They are not refusing, sir. They are only saying we don't have the right to do it now. Once the managing committee is put in place, your application will be...
Ultimately, the control of...
They have not rejected
but this is it is a very smart way of telling that we'll continue to control the society.
That is what generally the requirement is also. Otherwise, they can be the allegations against them that for the purpose of ensuring that you are elected, you have enrolled members at the eve of the election. That is also possible.
That the only exception what the Honorable Supreme Court took was when the term has come to those cooperative societies and the lordships are aware. When the term comes to an end, the body automatically ceases to become the part of the management,
administrator takes over or whatever it is.
Yes.
But here it is not so. But I do not want to unnecessarily take lordship's time. But the only distinction between those set of judgments or the statutory setting is that there, my lord, the body automatically ceases to be in control of the management. Here it does not. In fact, on the contrary, the clear indication is that you will continue to be part of the management until the next election takes place. Therefore, there is no bar. But I'll just cite this judgment for the Zoroastrian Cooperative Societies, Court of 2005, Part 5 basis. No, I'm sorry, we could not get an extra copy. I'll just cite this note and I'll give a photocopy.
Yes, you can read.
Please.
Yes.
But there, their lordships were considering this question. I'll just read this note and just pass on. Mr. So-and-so learned Soli J. Sarobjis learned senior counsel appearing for the appellants contended that under Article 19(1)(c) of the Constitution, Parsis has a fundamental right of forming an association. And that fundamental right cannot be infringed by thrusting upon the association members whom it does not want to admit or against the terms of its bylaws. This is the argument. Saying that we cannot ask, entrust us, and thrust upon us. He submitted that the content of the right of association guaranteed by Article 19(1)(c) of the Constitution has been misunderstood by the High Court and the authorities under the Act, etc. This was the contention, that saying that under Article 19(1)(c), you cannot thrust any member by giving a direction. Bombay High Court had given a direction to admit them as members. But while answering that contention, this is how their lordships, lords, this is how their lordships decide the issue. This would be, lords, at paragraph 2017. Para 27 and 28. I'll just read. Under the Contract Act 1872, a person sui juris has the freedom to enter into a contract. The bylaws of a cooperative society setting out the terms of membership to it is a contract entered into by a person when he seeks to become a member of the society. Even the formation of the society is based on contract. Then there is some other discussion, I'll just skip that. Lordships may permit me to read this sentence. It is therefore a fallacy to consider that in the context of cooperative societies, the surrendering of an absolute right by a citizen who becomes a member of the society could be challenged by the said member by taking up the position that the restriction he had placed on himself by entering into the compact is in violation of his fundamental right of freedom of movement, trade, or right to settle in any part of the country. He exercises his right of association when he becomes a member of the society by entering into a contract with others, regulating his conduct and vis-a-vis the society. Entering into an association with others for forming a cooperative society and subscribing to its bylaws are matters of contract or voluntarily undertaken by a society. Though it is not a fundamental right, it is a right, sometimes it is a statutory right or a right emanating from the bylaw. That's how their lordships hold it. Therefore, it cannot be said that I am a non-member, so I do not have any semblance of a right at all. But every society which is registered under the Societies Registration Act today have a public duty. It's not that it is a private organization, they come together. So every action of theirs must be tested with the annual law of fairness under Article 14. And if it is found that it is illegal, the jurisdiction of 226 can be used. But I would lastly submit this, my lord, no prejudice whatsoever will be caused to the society or nobody else. On the contrary, my lords, it would ensure that a large number of people will be enrolled and a democratically set up governing body will be elected. No prejudice, at least this is 49. And these are about 49 persons had filed an application. That's all, not that it is a huge number. 59 members had filed application. Of course, petitioners are little less, but the representation is about 49. So that's maintained.
The petitioners.
Just one small submission. Kindly take this judgment of the Supreme Court AR 2000-2378. In para 7, my lords. Para 7. Please turn the page over about 15 lines from top, my lords. We may add that a cooperative society is expected to function. My lord has that. About 18 lines from top. We may add that a cooperative society is expected to function in a democratic manner through an elected committee of management, and that the committee of management is empowered to enroll new members. Enrollment of new members would involve alteration of the composition of society itself, and such a power should be exercised by an elected committee rather than by an administrator or a committee appointed by the registrar while the committee of management is under supersession. This court has taken the view it did, bearing in mind that these aspects, though not spelled out in the course of the judgment, even where the language of Section 30A of the Act empowers a special officer to exercise and perform all powers and functions of committee of management of a cooperative society. This court, having expressed that view, we do not think there's any need to explore the difference in the meaning of the expression. Now, all that we are saying is, please allow the new committee to decide.
This judgment is based on that point itself, that administrator was appointed. Administrator does not have the power. That's how the lordship say at paragraph 8.
But in the context of term having come to knowledge,
The petitioners are before this court seeking a writ of mandamus, to direct the district registrar of societies to enforce its direction issued in its communication dated 3/1/2022 at annexure H. Full stop. A direction is also sought to the third respondent, Karnataka Pradesha Balija Sangha.
which is not a state, my lords, for issuance of any data. I'm not a state.
To act in consonance with the such direction issued by the district registrar of societies. And accordingly enroll the petitioners as members of the third respondent Sangha, along with all those who had filed their application and in respect of whom directions were issued by the district registrar. Full stop. Next para. The petitioners who claim to be
who are eligible according to us, who belong to Balijiga community.
Claim to belong to the Balijiga community seek membership of the third respondent Sangha. Full stop. Their grievance is that they were told that their application for membership cannot be considered at this point of time, since the term of the managing committee governing the third respondent Sangha has come to an end. Full stop. The petitioners, along with many other such applicants, approached the second respondent district registrar and sought for appropriate directions to the Sangha to enroll them as members. And accordingly, a direction was issued by the district registrar in his communication dated 3/1/2022 at Annexure H. Full stop. Despite such directions being given by the district registrar, the petitioners and other applicants have not been enrolled as members of the third respondent Sangha. Full stop. Next para. Learned Senior Counsel Shri Madhusudan Nayak, appearing for the third respondent Sangha, contends this writ petition is not maintainable, having regard to the admitted fact that the petitioners are non-members of the third respondent Sangha and they cannot seek directions at the hands of this court, primarily to the third respondent Sangha, which is not a state in terms of Article 12 of the Constitution of India, and that the term of the managing committee has already come to an end during Yav month?
31st of September 2000.
As on 31st of September 2021. Full stop. Learned Senior Counsel submits that at that point of time, when the term of the managing committee came to an end, COVID-19 was prevalent, and therefore, even in terms of the general directions issued by the state government.
No, that's not the submission.
No.
It got extended by 6 months.
It's a fact. It is a fact. The existing managing committee were permitted to hold elections immediately after the restrictions were removed. Full stop. In the meanwhile,
the Sangha has requested for appointment of.
The Sangha also gave a written communication as found
in R1.
In Annexure R1, which is filed along with the statement of objections. Full stop. The communication was made on 30/12/2021, seeking the deputation of an officer to act as a returning officer and to conduct the elections to the Sangha. Full stop. It was at that point of time, the petitioners, along with a few others, made such applications, and they were informed that since the term of the managing committee had come to an end, they will not have the right to consider the applications. Full stop. The petitioners were therefore informed that their applications will be considered by the managing committee that will be formed after elections are held. Full stop. Learned Senior Counsel would further point out to an interim order passed by this court on 25/2/2022, while allowing the application filed by the petitioners in IA number 1 of 2022. That since no ready voters list is available with the third respondent Sangha, and since such voters list is a precondition in view of catena of decisions of the apex court, the elections cannot be held without updating the electoral rolls of the third respondent Sangha. Full stop. Learned Senior Counsel would therefore submit that at the instance of non-members, such directions have been issued by this court, preventing the third respondent Sangha from holding elections, although they had given a representation to the concerned authority during the month of December 2021 to appoint a person as returning officer to hold elections to the third respondent Sangha. Full stop. The Learned Senior Counsel would further submit that the preparation of the voters list will again be in terms of the bylaws, or if there is no specific provision contained in the bylaws, in terms of the general principles that whoever were the members at the point of time when elections are to be held, are only eligible to find their names in the voters list, and a person who is a non-member, by merely filing an application cannot seek such directions at the hands of this court that they should firstly be enrolled and thereafter election should be held. Full stop. Attention of this court is also drawn to a decision of the Honorable Supreme Court in the case of the Joint Registrar of Cooperative Societies, Kerala versus T.A. Puttappan, AR 2000 SC 2378, where it was held that a cooperative society is expected to function in a democratic manner through an elected committee of management, and that committee of management is empowered to enroll new members. Full stop. Enrollment of new members would involve alteration of the composition of the society itself, and such a power should be exercised by an elected committee rather than by an administrator or a committee appointed by the registrar while the committee of management is under suspension, supersession. Full stop. It was further held that even where the language of the provision of section 30A of the Karnataka Act empowered a special officer to exercise and perform all the powers and functions of the committee of management, the apex court has expressed its view that what is to be borne in mind is the difference in the meaning of the expressions. Inverted comma have power to exercise all or any of the functions of the committee, close inverted comma, in the act, and open inverted comma, exercise all or any of the functions of the committee, close inverted comma, in the Karnataka Act, as they are not different and are in substance one and the same, and difference in the language will assume no importance. Full stop. What is of significance is that when the committee of management of the society commits any default or is negligent in the performance of the duties imposed under the acts, rules, and the bylaws, comma, which is prejudicial to the interest of the society, comma, the same is superseded and an administrator or a committee is imposed thereon. Full stop. The duty of such a committee or an administrator is to set right the default, comma, if any, and to enable the society to carry on its functions as enjoined by law. Full stop. Thus, the role of an administrator or a committee appointed by the registrar, while the committee of management is under supersession, comma, is, comma, as pointed out by the apex court, comma, only to bring on an even keel a ship which was in doldrums. Full stop. If that is the objective and is borne in mind, comma, the interpretation of these provisions will not be difficult. Full stop. The learned senior counsel would submit that the decision rendered by the apex court would apply to the facts and circumstances of this case, having regard to the admitted fact that the term of the managing committee has come to an end, and it is to only take care of the day-to-day affairs of the society that it is permitted to continue till elections are held and a new managing committee is put in place. Full stop. Under such situation, comma, no fault can be found in the decision of the members of the managing committee that the applications filed by the petitioners will be considered by the new managing committee, which is elected and put in place in accordance with law. Full stop. The learned counsel, senior counsel would also add that the petitioners cannot contend that their applications have been rejected while considering their eligibility or suitability of being enrolled as a member of the third respondent society. Full stop. All that was told to the petitioners is that at this point of time, when the term of the managing committee, existing managing committee has come to an end, comma, they will not be empowered to consider the application. Full stop. Next para. We'll continue at 2:30.
Afternoon, my
My lord,
absence.
one submission, my lord. One submission, my lord. My lord, the court officer, sir.
2:30
Court officer, sir. Yes, sir. Court officer, sir.
2:30 ಒಂದಿದೆ ಬೇರೆ ಮ್ಯಾಟ್ರು.
Court officer, sir.
ಕೇಳಿಸಿದೆ ಹೇಳಿ ಮೇಡಮ್.
Sir.
ಹೇಳಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಒಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕಿತ್ತು ಸರ್ 2 weeks ಗೆ. ಮೂಡೋದು ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲೇ ಬ್ಯಾಂಕ್ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ತಿದಾರಂತೆ.
ಸೈಡ್ ಇಲ್ವಾ ಯಾರು?
ಅದೇ ಸೈಡ್ ಇಲ್ಲ ಸರ್ ಅದ್ರಲ್ಲಿ.
ಆಯ್ತು ಮೇಡಮ್, ಮೆನ್ಷನ್ ಮಾಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಸರ್ವ್ಡ್ ಅಂತ ಇದೆ ಅಷ್ಟೇ ಬಿಟ್ರೆ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಸರ್.
ಆಯ್ತು.
ಏನ್ ಸರ್?
ಆಯ್ತು ಮೇಡಮ್.
ಸರ್ ನಂಬರ್ 43 ಸರ್. ಸರ್ 43 ಏನಾರು ಎಡ್ಜರ್ನ್ ಆಗತ್ತಾ? Court officer, sir.
Court officer.
Serial number 43.
ಅದು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂತ ಇದೆ. ಫೈಲ್ ಕೊಟ್ಟು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಇವಾಗ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಹೌದಾ? ಅದು ಕಾಸ್ಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಅಂತ.
ಹೇಳಮ್ಮ.
ಅಂಕಲ್ ಹೆಂಗಿದ್ದಾರೆ ಅಂಕಲ್ ಆಂಟಿ?
ಹಾ, ಆರಾಮಾಗಿದ್ದಾರಮ್ಮ.
ರೆಕಾರ್ಡ್ Come to complete the persons who are named in annexure. The petition has been, the persons are considered as party respondents in release this matter for preliminary hearing or the persons are considered as party respondents.
Court officer.
Matter was listed on 25/1. My application only 27 ko. The persons are included as party respondent to petition release this matter. Petitioner is permitted to implead. Court officer, ಅದು ಆರ್ಡರ್ ನೋಡಿ ಸರ್.
ಇಲ್ಲ ಸರ್, ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ. ಇವಾಗ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಅದು.
Court officer.
ಡೈರೆಕ್ಷನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ. Adjournments other side to be present.
Court officer.
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಿದೆ.
Serial number 43.
ಹಾ,
adjourn ಬೇಕಲ್ಲ ಸರ್?
43. ಅದರ್ ಸೈಡ್ ಇರ್ಬೇಕು ಸರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಗೆ.
ಅದರ್ ಸೈಡ್ ಇರ್ತಾರೆ. ಅಲ್ಲ, 230 ಮ್ಯಾಟ್ರ್ ಒಂದಿದೆ ಅಲ್ಲ, ಅದು ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಅಂತ.
ಏನ್ ಕೇಳಿಸ್ತಿಲ್ಲ ಸರ್, ನೀವು ಸರಿ ಹೇಳ್ಬೇಕು ಸ್ವಲ್ಪ ಮೈಕ್.
ಅಲ್ಲ, 230 ಮ್ಯಾಟ್ರ್ ಒಂದಿದೆ ಅಲ್ಲ.
ಹೌದು.
ಅದು ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಸರ್?
ಯಾರು ಗೊತ್ತು ಸರ್.
ಆಯ್ತು ಸರ್.
ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ ಪುಟ್ ಅಪ್ ಸೈಟೇಷನ್ ಸರ್.
ಯಾವ್ದು ಸರ್? ಇವಾಗ ಕೊಟ್ರಲ್ಲ.
ಕೊಟ್ಟಿರ್ತೀನಿ.
ಜೆರಾಕ್ಸ್ಟ್ರಿಯಿಂದ
ಜೆರಾಕ್ಸ್ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಪುಟ್ಟಪ್ಪ ಅಂತ ಏನಾದ್ರು ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ.
ಇಲ್ಲ,
ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ. ಹಾ, CC
AR 2000 SCC 2378.
Party's name Puttappan.
Party's name
State of Kerala.
Postal Societies Kerala appellant. TA Puttappan.
Saturday. Sir, ಅಲ್ಲಿ ನಾನು ಸ್ಕೂಟಿನಿ ಅಂತ ಬರುತ್ತೆ, ಚೇಂಜ್ ಮಾಡ್ಬೇಕು. Saturday date.
Like that. ಒಂದು ಮೆಮೋಲಿ ಒಂದು 3-4 ಮ್ಯಾಟ್ರ್ ಮಿಸ್ ಆಗ ಸಪ್ರೇಟ್ ಆಗಿ ಕೊಡ್ತೀನಿ.
ಒಂದು ಸಪ್ರೇಟ್ ಒಂದು ಮೆಮೊ ಕೊಡಿ.
ಅದೊಂದು 3 ಮಿಸ್ ಆಗಿದೆ. ನಾನು ತರಿಸ್ಕೊಂಡೆ ಎಲ್ಲ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆಫೀಸರ್ಸ್ ಅದ್ರಲ್ಲಿ ಇತ್ತು ಮೆಮೋಲಿ. ಟೆಂಡರ್ ಮ್ಯಾಟರ್ಸ್.
ಟೆಂಡರ್ ಏನು?
ನಾನು ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸಸ್
ಪೇಮೆಂಟ್ ರೀಫಂಡಾ ಇಲ್ಲ ಏನು
ಸರ್? ಇಲ್ಲ, ಬೇಸಿಕಲಿ ನಾನು ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸಸ್ ವೆಲ್ಫೇರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ they have called for the tender actually, food procurement. Food procurement. ನಮ್ಮ ಹಾಸ್ಟೆಲ್ಸ್ ಇದೆಯಲ್ಲ, BCM ಹಾಸ್ಟೆಲ್ಸ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ, ಅದೆಲ್ಲ ಫುಡ್ ಸಪ್ಲೈಗೆ ಟೆಂಡರ್ ಕರೆದಿದ್ವಿ. ಅದೇನಾಯ್ತು, ತಾಲೂಕು ಟು ಡಿಸ್ಟಿಕ್ ಲೆವೆಲ್ ಇತ್ತು, ಪಾಲಿಸಿ ಡಿಸಿಷನ್ ಮಾಡಿ ನಾವು ಟೆಂಡರ್ ಕರೆದ್ವಿ ನಮ್ಮ ಇಲಾಖೆ. ಆಲ್ಮೋಸ್ಟ್ ಒಂದು 60 ರೆಡ್ ಪಿಟಿಷನ್ಸ್ ಹಾಕ್ಬಿಟ್ರು ಪ್ರೀವಿಯಸ್ ಟೆಂಡರ್ದಾರೆಲ್ಲ. ಗುಲ್ಬರ್ಗ, ಧಾರವಾಡ ಮತ್ತು ಬ್ಯಾಂಗ್ಳೂರು. ಫಸ್ಟ್ ಗುಲ್ಬರ್ಗಾದಲ್ಲಿ ಸೂರಜ್ ಗೋವಿಂದ್ ಸರ್ 13 ರೆಡ್ ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೋದು. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಧಾರವಾಡ ಮಾಡೋದು, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಇಲ್ಲಿ ಬೆಂಗಳೂರಿಗೆ. ಅದೆಲ್ಲ ಇತ್ತು. ಒಂದು 3-4 ಬೈ ಓವರ್ಸೆಟ್ ಲಿಸ್ಟ್ ಆಗಿ.
ಅಷ್ಟು ನಂಬರ್ ಕೊಡಿ,
ಅದನ್ನ ಯಾವ್ದಾದ್ರು ಒಟ್ಟಿಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಒಟ್ಟಿಗೆ ಒಂದೇ ಮಾಡ್ಬಿಡಿ. ನಾನು ಅಷ್ಟೊಂದು
ಒಂದೇ ಸಲ ಹಾಕ್ಸ್ಕೊಂಡು
ಕವರ್ಡ್ ಬೈ ಅಂತ. ಬಟ್ ಇದೇನಾದ್ರು ಅಪ್ಲೋಡ್ ಆದ್ಮೇಲೆ ಕೊಡ್ಲಾ?
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಕೊಡಿ, ಏನ್ ತೊಂದ್ರೆ
ನಾನು ಇದು ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆದ್ಮೇಲೆ ಅದ್ರ ಜೊತೆ ಕೊಟ್ಬಿಡ.
ನೀವು ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳ್ತೀನಿ ಆರ್ಡರ್, ಯಾಕಂದ್ರೆ ಜೋಳ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ.
ಏನಂದ್ರೆ ಅದು ಇದಿಲ್ದಲ್ಲೇ ನಮ್ಮ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಬರೀ ಡಿಸ್ಪೋಸ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ವರ್ಕ್ ಆರ್ಡರ್ ನಮ್ದು ಇದು ಜಜ್ಮೆಂಟ್ ಇಲ್ದಲ್ಲೇ ನಾವು ಟೆಂಡರ್ ಪ್ರೋಸೆಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ವಿತಿನ್ 4 weeks ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಇದೆ ಅಲ್ವಾ 22685?
ಹೌದು ಸರ್, ಕನೆಕ್ಟೆಡ್ ವಿತ್ 2432
ಮಾಡ್ತಾ ಇದಾರೆ.
23003
ಮಾಡ್ತಿದ್ದಾರೆ ಸರ್, ಮಾಡ್ತಿದ್ದಾರೆ ಆಗುತ್ತೆ.
ಆಯ್ತು ಸರ್, ನಾನು ಮೆಮೊ ಒಂದು ಕೊಟ್ಬಿಡ್ತೀನಿ ಸರ್ ಶಮಂತ್ ಕೆಲವು.
ಚೆನ್ನಾಗಿತ್ತು. Rejection of Plaint. Performance. ಇನ್ನೊಂದು petition. ಗೊತ್ತಾನೆ? ಇದು ಅಷ್ಟೇ ನಾನು ಪಿ ಪಿ ಹೆಗಡೆ 2 ಸಲ ಬಂದಿದೆ ಹೇಳಿದ್ನಿ ಅದನ್ನು ಮತ್ತೆ ಪ್ರಿಲಿಮಿನರಿ ಮತ್ತೆ ತಿರ್ಗಿ ಅವ್ರು ಮೆಮೋ ಮಾಡ್ಬೇಕು.
Court officer. Court officer. Court officer.
ಏನ್ ಮೇಡಮ್?
ಸರ್ ಇದು ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ 230 ಲಿಸ್ಟ್ ತಗೊಳ್ತಾರೆ?
ಕಂಟಿನ್ಯೂ ಆಗಿ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲಿವರೆಗೆ ಆಗಿದೆ ಸರ್? 37.
Serial number 37, Anand.
For contra, learned senior counsel Shri Prabhulinga Navadgi, appearing for the petitioners, contended that contrary to the position that an administrator is appointed to the society or that a committee has been installed at the instance of the registrar of societies, the managing committee of the third respondent Sangha continues till elections are held and a new managing committee is put in place. Full stop. The learned senior counsel would therefore submit that the judgment sought to be relied upon by the learned senior counsel in the case of the joint registrar of cooperative societies, Kerala, Supra, is in fact helpful to the petitioners. Full stop. It is also submitted that the bylaws do not stipulate any such condition that the managing committee whose term has expired is not eligible to consider such applications. Full stop. It is in that regard, it is submitted that appropriate directions were issued by the district registrar of societies directing the third respondent Sangha to consider the applications and enroll the applicants, if they comply with the requirements of the bylaws. Full stop. However, the incumbent managing committee members do not want the petitioners to be admitted as members for reasons best known to them, and they want to hold the elections without granting membership to the petitioners and many such applicants who are only about 58 in number. Full stop. The learned senior counsel would further submit that the third respondents would admit that there are about 4,000 members in the society, and enrollment of 50 or 60 additional members to the society will not have any bearing on the elections that would be held. Full stop. Reliance is also sought to be made on a decision of the Honorable Supreme Court in the case of Zoroastrian Cooperative Housing Society Limited and another versus District Registrar, Cooperative Societies, Urban and others, AR 2005 SC 2306. Where it was held that any law comma, by which members are introduced in the voluntary association without any option being given to the members to keep them out, comma, or any law which takes away the membership of those who have voluntarily joined it, comma, will be a law violating the right to form an association. Full stop. It is submitted that in catena of such decisions of the Honorable Apex Court, it is clearly held that if a person fulfills all the requirement of the bylaws, comma, he cannot be prevented from becoming a member of the society. Full stop. While drawing the attention of this court to the bylaws of the third respondent Sangha, comma, it was submitted that the bylaw only requires that such a person or applicant should be a person belonging to Balija community, and that he should have completed 18 years of age. Full stop. The other requirement is that he or she should be from any of the taluka district of the state of Karnataka. Full stop. It is submitted that the petitioners fulfill all such requirements, and therefore they cannot be declined membership of the third respondent society. Full stop. Next para. Heard the learned senior counsels for the petitioners, comma, the third respondent Sangha, comma, the learned AGA, and perused the petition papers. Full stop. Having regard to the admitted fact that the term of the managing committee of the third respondent Sangha came to an end on so and so date ಇದೆ ಮೇಲೆ. And in terms of the requirement of law, a requisition has been made by the managing committee to the district registrar of societies to delegate a person as election officer to conduct elections to the managing committee of the society. Full stop. However, due to intervention of COVID-19, the elections could not take place, and therefore the existing managing committee is only required to take care of the day-to-day affairs of the third respondent society. Full stop. That being the position, comma, the situation would be nothing different from the society being managed at the hands of an administrator or any officer appointed by the competent authority. Full stop. The learned senior counsel for the third respondent is therefore right in his submission that the applications of the petitioners were not rejected on the ground that they are not eligible to be admitted as members of the third respondent society. Full stop. They were only informed that since the term of the existing committee, managing committee, has come to an end, comma, it is beyond their powers to consider the application and admit the petitioners to the membership of the society. Full stop. They were only asked to await the elected members of the third respondent society who would form the managing committee to consider the applications filed by the petitioners. Full stop. The petitioners' applications have not been rejected as such. Full stop. Next para. The learned senior counsel for the third respondent is also right in his submission that such a direction could not have been issued by the second respondent, district registrar of societies, to enroll the petitioners as members of the third respondent society. Full stop. Discretion is vested with the society to consider the applications for membership in accordance with the provisions of the bylaws of the society and the provisions of the act and the rules governing the society. Full stop. Next para. In that view of the matter, comma, this court is of the considered opinion that at this stage, it would be impermissible to issue such directions to the third respondent society to act in terms of the directions issued by the second respondent in his communication dated 3/1/2022 at annexure H. Full stop. The application of the petitioners, the applications of the petitioners will be considered by the new managing committee, which will be elected and put in place in accordance with law. Full stop. The petitioners have to wait till the new committee is established. full stop, next para. Accordingly, the writ petition stands dismissed. Yes.
Interim order. Interim order.
Have to
be
writ petition
vacated,
is-
please.
Yes,
And there shall
Pass
be,
over matter.
Lordships, there shall be a direction to the second respondent to appoint an election officer and conduct the elections in the interest of the petitioners.
having
No,
regard
writ
to-
petition, he is seeking for a direction.
Allah, in fact, your
Allah-
senior
Allah-
counsel was asking.
ಆಮೇಲೆ bylaw
He asked them to conduct elections as soon as possible.
elections ನಾವು ಕೇಳಿದ್ವಿ after enrollment of the petitions and other similarly
ಅದು
situated
ಬರೋದಿಲ್ಲ.
members as well. bylaw number 9 ದೊಂದು
Having regard to the admitted fact that the term of the existing committee has come to an end on so and so, comma, it would be incumbent on the second respondent, district registrar of societies, to appoint an officer as election officer and ensure that the elections are held to the managing committee of the third respondent society as expeditiously as possible and at any rate within a period of
45 days is the thing which will.
within a
have to
period
be-
of 3 months
Please,
from the date of receipt of a copy of this order.
much of.
Yes.
bylaw number 9 ದೊಂದು ಪಾಯಿಂಟ್ senior counsel argue ಮಾಡಿದ್ರು.
You know?
Till the new committee constitute, the existing committee will be in office, will hold the office. The bylaw number 9, point number 9. Reference.
ಬಂದಿದೆ. I have not pointed out to the provision, but I have said so.
ಅದರಲ್ಲಿ
They are only
ಅಲ್ಲ
caretaker ಅಷ್ಟೇ.
ಅಲ್ಲ ಆ ತರ ಇಲ್ಲ sir. ಅಧಿಕಾರದಲ್ಲಿ ಇರುತ್ತಾರೆ ಅಂತಾರೆ. They continue to hold the office.
All right.
Passed over matter, serial number 11, V. Mohan.
Much.
Prepare for the petitioner, my lord.
Respond, my lord.
Raise time to file my objection, my lord, statement of objection. I received the copy only 2 days back. I'll file my statement of objection, my lord. It's a week's time maybe.
You know?
It's a tenant writ petition, my lord.
Huh?
It's a tenant writ petition. They had taken the interim order and they stopped all the proceedings under to be taken under section 14 of the Surface Act, my lord, including against the borrower also. In view of the interim order, we cannot proceed anything.
Just 2 days, Monday maybe. I'll come with the
Yeah,
relevant
already approached
citation
the-
also. my lord.
They are already approached the DRT also. Hello, question notice challenge ಮಾಡಿ.
Need some time to file the reply affidavit.
You are tenants.
Yes, my lord. My bona fide registered tenant prior to issuance of 13-2 notice, my lord. Demand notice. I have a citation, my lord. I'll argue on merits, my lord. I'll argue on merit with the Supreme Court citation, my
That
lord.
is what I had told last time, with an understanding that the matter will be considered and disposed of on the next.
No,
date
no,
of
they
it.
served the copy only 2 days back, my lord.
Yes,
First,
sir.
a copy, they're vacating the interim order, stay.
PD, forget it. I have directed that it will be heard and disposed of on next date of hearing.
Maybe Monday, my lord. Just 2 days.
It's not proper.
My lord, may I submit one thing? My lord, there are some other matters also which are pending against the respondent bank. And one writ petition we have also filed before the Supreme Court that what they have done,
The
they have
respondent,
issued.
borrower.
My lord, I am for respondent number 2. Respondent number 2.
Who is the borrower, my lord?
Borrower.
Yes.
G. Bhaktavasalam, borrower, my lord. Yes, my lord. So one of the issue is that, my lord, what they have done, they have issued multiple demand notices. First demand notice was issued in 2019. After that, they issued 2 more demand notices in
not the petitioner
2023.
here.
That is,
If you have filed any other
I am not the
petition,
petitioner,
you please make submissions in that writ petition, not in this written.
my lord. So that's what I am requesting, that I will place those
Although
all
it
things
was,
on record.
directed that the matter will be heard and disposed of on the next date of hearing, comma, learned counsel for petitioner seeks for a short accommodation while submitting that IA for vacating has been filed at the hands of the
Respond
respondent
number
bank
1, bank.
today
ಇಲ್ಲ ಸ್ವಾಮಿ ಆಲ್ರೆಡಿ ನಾವು ಫೈಲ್ ಮಾಡಿದಾವಲ್ಲ 25th October.
has been filed and a copy of the application is served on the learned counsel for petitioner today.
ಇಲ್ಲ ಅಲ್ಲಿ postal ನಾನು ಅವತ್ತೇ ಕೊಡಕ್ ಹೋದೆ ಅವ್ರು
Yesterday, my lord. Yesterday only I received.
Yesterday.
Yes.
Full stop. Next para.
postal ಕಳ್ಸಿದ್ರು.
Release this matter on 4th of February.
Interim order, my lord.
My lord,
Order granted earlier stands extended till next date of hearing.
Much
For
obliged.
4th of February for preliminary hearing.
Yes, my lord.
Yes.
Much obliged.
230 PM matter,
Grateful.
serial number 80. Karuna S.
The matter where we had sought for extension of time to conduct elections.
Ah.
Last date of hearing, it was argued and we had taken time that the matter is being heard before learned single judge.
Hmm.
My lords, yesterday the matter.
What matter is being heard there?
My lords, two talukas which were created when matter was being heard even earlier, my lords. There's another writ petition in which there was a direction to give representation to those two talukas. My lords also passed an order to conduct elections. Now, in the meanwhile, the state passed an order under section 12(6) that you should amend your bylaw and make them as directors because new talukas as per their bylaws only, my lords, which says every taluka should be given a representation. So we give this 12(5) order. So in the meanwhile, some other societies, there is a stay order obtained on the 12(5) amendment where the representation was given to these two talukas. In view of that, my lords, other proceedings were stalled. So we brought it to the notice of my lords and we filed an application. Of course, as submitted, we filed in the month of December. My lords, it was only listed in, we filed it in October, it was listed in December and matter was posted for this month. Yesterday, the matter was heard, my lords. Of course, previous days also it was heard. And the petitioners also argued and respondents for the state also we argued and the reply was also submitted. For want of some clarification from the state side, my lords, I was not, I'll finish. I was not present, so we sought for some more time. Now, they have filed an affidavit. They're filing some affidavit today, my lords.
Can I pass on this, my lord? Yes. By way of synopsis, I filed the objection. Some dates and events I wanted to brought to a lot.
Now, the only thing my lords would be considering here is whether the elections could be held, including these two talukas, or without these two talukas with the earlier list. Whatever my lords will direct, we will abide by that. The only thing is, my lords, those two talukas, there was also an order to consider them. So there are two orders of this honorable court. One to conduct election, one to consider them as members. So that has been done. Now, some other societies of some other talukas, they have gone and obtained stay. Chelur and Manchanalli people are not here. They will not be represented. The only thing we are requesting is we'll give them representation and we'll issue calendar of events. But there is a stay, my lords, on that bylaw now, which we recommended. That is the reason we have come before my lords.
Can I
stay on?
Stay on recommendation to include Manchanalli and Chelur as directors. On that,
not a recommendation. A direction was issued by the district registrar, directors to add these things in the bylaw of the society. Whether it will be correct or not is subject matter. Such time not the proposal which we have sent for amendment, where these two talukas are added in our bylaw, proposed bylaw, that was declined. Now a further direction was issued, add these two talukas in your bylaw, that was the direction issued, in addition to other things. That we have called in question. May I kindly look at certain dates and events. If the government is justified, I leave it to your lordship. May I kindly go to page 2 for a moment. For your lordship. At the 6/11/2023, my lord, this was a general body meeting we convened for the purpose of conducting the amendment of bylaw of the cooperative society, adding to these two talukas representations in the members of managing committee. My lord, your lordship may kindly see total maximum strength of the managing committee is 21. If we wanted to add 2, invariably we have to remove 2. General body meeting was convened in which these two talukas are added, and one women's society as well as nominee of the Apex Bank was eliminated. Government nominee was retained. Elimination of 2 posts are filled up and provided in favor of these two societies which are recently introduced. Not recently, 2019, the talukas have been introduced separately made by the government. Those representation have been provided to those talukas. This proposal we have sent it to the registrar on 7/11/2023, item number 2 million. Then on 22/2024, joint registrar declined this amendment, saying so many other reasons other than what is provided under the law. That is the subject matter and the repetition where interim order is there.
You wanted to add the two
Yes.
talukas.
Yes,
By removing,
what happened was,
they've removed Apex Bank, who is a permanent member.
but the general
They
body
remove
has a
Apex Bank.
supreme power. who
No,
has
they
to-
cannot. It is in violation of section 28. They
That's-
cannot do that.
My lord, your lordships may kindly see. Under the cooperative society, sir, general body is the supreme. Maximum strength of the managing committee is 21. If we want to provide two representations, these two talukas, two existing members has to be removed. The matter was deliberated, out of which Apex Bank nominee is eliminated, one women's society is eliminated. Women's society, neither the women's society nor the Apex Bank is not before the court. They are not before the court. Government holding the brief for them. Under the law, it says, who are the nominees? Government nominee must be there. We have provided, we are not disturbed with that. And other joint register, one of the ex officio member, he was also there. All these representation we have provided. That bylaw was, that amendment was not accepted by the registrar on the ground that you have eliminated the Apex Bank, and instead of one women's society, you add this society. He wanted to impose condition on our, and he wanted to amend the bylaw in that way. That is the subject matter. May kindly me add two dates. Your lordship's order is 3/7/2024.
See, now admittedly, there is a challenge raised
Well, one minute.
in the other writ petition.
Certainly, my lord, I will.
That is not the subject matter before this court.
No, no,
We are
absolutely.
only concerned
Correct.
about implementations of the direction.
Your lordship's order.
Now, the learned AAG is saying, subsequent to this order, there have been developments and writ petitions have
Not
been filed.
subsequent to, earlier to your lordship's order. Earlier to 20, your lordship's
Petition.
order is,
Writ
your
petitions have
lordship's
now been
order-
filed.
1 minute, my lord, 2 days may kindly be.
Ah.
Your lordship's order is 3/7/2024.
Ah,
Amendment was rejected by the joint registrar on February 2024. That means 5 months earlier to your lordship's order, rejection order was there.
yes.
After your lordship passes an order, where the state was directed to implement the order by conducting the election within 3 months, then my lord, one more order was passed in the month of August 2024. This is ultimate object, my lord, I could able to demonstrate. They don't want to see that election should be happen to the DCC Bank is concerned. One way or the other. If your lordship's order is there, and that this fact was not brought to the notice of your lordships, they are the custodian of the record. Order is passed by the joint registrar, they kept quiet. After your lordship's order, where election authority directed to complete the election in terms of your lordship's order, joint registrar passes an order directing them to impose his own conditions in amending the bylaw is concerned. That is the reason I indicated these 2 dates are very important. That's the reason I prepared it and pass on to your lordship today. A contempt application was filed in which notice have been ordered. They were called upon to file the affidavit. What steps they have taken to complete the election process. That affidavit is not even filed also. Now that matter is listed on 5th of February. It is not that these talukas have no representation earlier. Representation was there. They were represented within the territorial limits of the very DCC Bank. Now taluka have been independently made. All right, a writ petition was filed by those 2 talukas before the court. This court said considered by the general body. General body meeting was convened. We conducted it, decided, and we provided representation to these 2 societies, eliminating unnecessary representations for the purpose of making balance, maintain the balance of maximum number of managing committee members are concerned. We cannot go beyond 21. Within 21, the adjustment has to be done. General body has done that. How you are, my lord, well, a statement of object of the act says, my lord, it is a autonomous, family member participation, democratical process.
ಈಗ ಆಯ್ತು, that petition is going to be disposed of?
No, it is.
My lord's matter was heard yesterday. I'm passing on the daily order of the
Vacated interim order. Matter was heard. Lordships what dictated the order saying that interim order is not vacated. But they made a request that application we keep it pending on a condition that they cannot seek time before your lordship on the ground that application pending and it is hearing by the other court. Don't make a mention that. That was the condition imposed on them. They are not intended to vacate the interim order.
On the other hand, my lords, the honorable court directed, my lords, the parties, the respondents, my lords, and the impleading applicants to bring it to the notice of, my lords, this honorable court. The subsequent events are the developments. Lords, one of the submission, my lords, made by the learned senior counsel, that even those two revenue taluks which were additionally created, my lords, subsequently were also represented or given representation. It is not so, my lords. From 2019 to 2024, my lords, one term, my lords, of 5 years, even under which, my lords, we were not represented. But we were not given, my lords, any representation. And even now also, my lords, they want to say that since the direction is issued by this honorable court, my lords, in the present writ petition, even without giving the representation to the two revenue taluks, my lords, the election should be held. No, that is all, my lords.
That is not correct.
No,
Last election which have taken place, these two talukas are what not there. Immediately after the election, these two talukas are established by the state. By that time, representatives of those talukas in respect of such societies, they were very much before the DCC bank.
And in fact, my lords, they are not the bank. The bank is not aggrieved with regard to, my lords, all these directions. Lord, the petitioners hearing, my lords, are not the bank.
May kindly look at the situation, my lord.
They claim to be the
Bank
members
is
of
under
the DCC bank.
Bank is under the hands of an administrator. Administrator is no other than the deputy registrar. He is not inclined to challenge. We are the members of the society. We have a grievance. There are 1,870 members are there. We are the primary members. We participated in the general body. We have resolved this has to be amendment. Proposed amendment or declined by the registrar or even without hearing to us.
More, my lords, important aspect that was not brought to the notice of this honorable court, my lords, earlier is that, my lords, one writ petition 19414 of 2023, which was filed and disposed of, my lords, prior to the order passed by this honorable court in the present writ petition. But that they don't, my lords, bring it to the notice of this honorable court. That is, my lords, on 21st of September 2023, that order was passed, directing, my lords, the bank to convene special general body meeting and to consider all these aspects.
Correct.
There is a specific direction that has not been brought to the notice of.
We convened the general body meeting. We convened the general body meeting. Based on that, bylaw was amended. Proposed amendments were sent to the registrar. Registrar declined it. It is not that we are making any bargain for that.
Barkole. Order on IR number 1 of 2024. This application has been filed by the
district election officer, my lords.
district election officer who was required to conduct the elections to the Kolar and Chikbalapur District Cooperative Central Bank Limited,
Please, ma'am.
seeking extension of time for conducting the elections, in terms of the directions issued by the secretary. Full stop. Next para. These writ petitions were disposed of by order dated 3rd of July 2024.
My lords had given us liberty, my lords. Page 18 of the order.
Seek extension only. Not anymore.
D, my lords.
with specific direction to the State Cooperative Election Authority, Regional Commissioner, Bangalore Division, and Apex Cooperative Societies Election Officer to continue the process of election from the stage when it was halted, in view of the issuance of the Model Code of Conduct and the government order dated 21/3/2024. Stop.
Then 14 notification was issued on 10/7/2024 in further evaluative order, where election dates were fixed on 28/9/2024.
The district election officer was directed to ensure that the process of election shall be continued from the stage when which it was halted, and ensure that the elections are held as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a copy of the order. Full stop. Next para. However, learned AAG also points out that at direction number D, this court had granted liberty that in case of any difficulty to the district election officer to hold the elections within the stipulated time, liberty is also reserved to the district election officer to move necessary application for extension of time. Full stop. Next para. Learned AAG submits that
Para 9, 8 and 9 onwards.
after the disposal of this writ petition, election notification was issued on 10/7/2024 under Rule 14(1) of the Karnataka Cooperative Societies Act. Full stop. Further, the said notification came to be withdrawn on the same day for the reason that prior approval of the election authority was not taken. Full stop. It is also stated that
15/7/2020.
as per the ಯಾವ notification amma 10/7
15/7/2024, election authority
ಅದಲ್ಲ paragraph number 9 ಅಲ್ಲಿ ಇರೋದು.
My lords, 9 is the order of the writ petition, my lord, say on, please. my lord.
Further I state that as per the government notification.
That is actually, date is not.
That is, my lord.
2018, my lords, the 2018, I'll pass on the date when these talukas were formed.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಯಾವುದು?
ಅದೇ formation of the 2 talukas.
That is, my lord, 2019 and 2018.
I'll give the date, my lord.
2018.
It is further stated that in terms of the government notification dated so and so, 2 talukas were newly established, namely Cheluru and Manchenahalli. Full stop.
By that time, election to the board was over. Our term expires in 2023 itself. However, their members were there.
2 writ petitions have been filed in WP number 19414 of 2023 and 19741 of 2023, seeking appropriate directions to have representation to the 2 talukas in the board of directors of the respondent bank. Full stop. It is submitted that the matters have been heard and a decision in that regard is required to be taken in the said writ petitions. Full stop.
Six 2023, we passed the amended bylaw was, proposal was sent to general body.
For contra, learned senior counsel Sri M.R. Rajgopal, appearing for the petitioners, submits that the respondent, the general body of the respondent bank, in fact, passed a resolution on 6/11/2023 ಏನಂತ?
We have amended the bylaw, providing representation to these two talukas.
Amending the bylaws of the bank, giving representation to the two talukas.
Two talukas.
ಅಂದ್ರೇನು? How did you give representation?
ಅವ್ರಿಗೆ ಒಂದೊಂದು ಅವ್ರನ್ನು ಸೇರಿಸಿ 12 members ಮಾಡಬೇಕಾಗಿತ್ತು. 12
My lords will get that order in page 32.
From each taluka, we have provided including these two talukas.
What happens, my lords, is that one nimsha, full stop.
Can I show that amendment, my lord, for a moment?
We have placed it on record by annexure R2. Annexure R2.
May kindly see, my lord, the page number.
ಇದ್ರಲ್ಲೇ ಇದೆಯಾ?
Extension
Page
application.
number, bylaw, my lord, 6/11/23 at page 6.
Page 14 it starts. my
Page
lords.
6 may kindly be seen, in which, my lord, what we have provided is page 14.
My lords will get in page 29A, Adalita Mandali. But
Yes,
page,
page 15, my lord. Item 13, Cheluru Taluku. Then, my lord, the Manchanalli seat, item number 14, page 15, my lord. Cheluru Taluku ಮತ್ತು ಚಿಲಕಲ ನೆರಪು ಹೋಬಳಿಗಳು ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘಗಳ ಚುನಾಯಿಸಲ್ಪಡುವ ನಿರ್ದೇಶಕರು. ಅವರಿಗೊಂದು ಕೊಟ್ವಿ. 14ನೇದು ಮಂಚೇನಹಳ್ಳಿ, ತೊಂಡೆಬಾವಿ ಮತ್ತು ದೀಪಾಳ್ಯ ಹೋಬಳಿಗಳ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘಗಳಿಂದ ಚುನಾಯಿಸಲ್ಪಡುವ ನಿರ್ದೇಶಕರು ವ್ಯವಸಾಯ ಸೇವಾ ಸಹಕಾರ
ಇವಾಗ ನಿಮ್ ಪ್ರಕಾರ now if elections are held,
yes,
representations will also come from the two
absolute
talukas.
file an affidavit to the
And who has filed the writ petition?
writ petition is filed by us, not against this.
ಅಲ್ಲ ಇದಲ್ಲ, those two writ petitions.
So villagers
Huh?
filed a writ petition. They sought for a writ of mandamus. They making the mandate for the society bank to amend the bylaw, providing these representations are concerned. This honorable court directed consider the convene the general body meeting, consider their representation. We convene the general body meeting. We propose to amend the bylaw. Representation have been provided to these two talukas. It was sent to the approval to the registrar. Registrar said no. Therefore, that bylaw was not taken effect. Now, very same bylaw he prepared. In addition to that, you cannot eliminate the apex bank nominee. Therefore, you should add, and he deleted some other primary society. Then he said another primary Mahila woman society to be eliminated. In place of them, things is added. That is now under this, whether under 12, 5 and 6, these powers can be exercised. Sitting over the decision of the general body is the subject matter. We are deliberating in a pending writ petition.
But that is not the subject matter.
That is,
those writ petitions were filed in the year 2023.
No, ಅದಲ್ಲ, ಅದು ಮುಗಿದೋಯ್ತದು. ಅಲ್ಲಿ ಏನಾಯ್ತಂದ್ರೆ 2023 ವಿಲೇಜರ್ಸ್ ಒಂದ್ ರಿಟ್ ಹಾಕಿದ್ರು. ಜನರಲ್ ಬಾಡಿ ಮಾಡಿ ನಮಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ ಅಂತ
those writ petitions
ಕೊಟ್ಟಾಯ್ತು, ಅದು ಕ್ಲೋಸ್ ಆಯ್ತು.
Now which is that writ petition pending?
ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಅಂದ್ರೆ ನಾವು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಕಳಿಸಿ ಬೈಲಾ.
May I submit, my lord?
ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತಂದ್ರೆ society registrar ಅವರು exercising his power under section 12, 5 and 6. ನಾನು ಇಷ್ಟು ಅಮೆಂಡ್ಮೆಂಟ್ ನ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಇದನ್ನ ನಿಮ್ ಬೈಲಾದಲ್ಲಿ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಕಳಿಸಿದ್ರು. That we are challenged.
They are not challenging, my lords, it is not the petition, it is not this, my lords, my lords. My lords, I'll just brief my lords. My lords, the first order of 2020, which was read out to my lords, wherein they amend it after the court order by removing an apex body member and the government nominee, and they send the bylaw for us to approve it. We do not approve it because it's in violation of section 28, that saying that it's an assisted society, it's a bank. You cannot remove apex body. We refuse to accept that bylaw. Further, my lords, on 32, what has happened is because there are only 21 members, we cannot increase the number of members. So we removed one Griha Nirmana Mandali and Women's Bank, and we gave the representation to these two talukas from 12 to 14, and we removed those two people and they are represented otherwise. The Women's Association and the Griha Nirmana Mandali, by way of other societies, have now gone before other court saying that namma hak tagondidare, adrinda ee particular bylaw is not valid. So Manchenalli Chedur avaru kodbedi, namge continue madi anta. That is where we are stuck, my lords. That is the only thing. And the petitioners here
may kindly be seen for a moment.
All right. One more. Only, ಆಯ್ತು. ಏನ್ ಹೇಳಿದೆ?
Section 28 may kindly be seen, my lord.
ಏನ್ ಹೇಳಿದೆ? And accordingly sent a proposal for amendment.
Amendment was done, approval ಕಳಿಸಿದ್ವಿ.
Accordingly, the decision of the general body
Yes.
was placed before the joint registrar of cooperative societies for approval.
Yes.
Full stop. The joint registrar declined to accord approval to the amendment proposed by the general body of the respondent bank
On 20.
on 22/2024. Full stop.
Your lordship's order is 3/7/2024.
as the same was in violation of section 28A23B.
I can show it, my lord, where it is provided. It is not that it is necessary. If
These two
necessary,
notifications are being considered by the learned single judge now.
the law says, if necessary, representation to be provided to assist societies.
Next para. At this stage, two primary corporate, what banks are they?
My lords, one is the Mahila Griha Nirmana Sangha.
Our primary cooperative.
Primary societies.
Primary society.
Two of the member primary cooperative cooperative societies filed writ petition number
2152/2024.
Adu
2271 of 24.
2271 of 2024.
and
21551 of 2024. 2271 and 21521 of
521 of 2024. Being aggrieved of the decision taken in the general body to exclude them from the representation in the board of
Directors in the bank.
It is not refused. It is not refused. We accorded. Bylaw was amended.
Now 38 second order. Aggrieved by the second order. Second order.
1 minute, madam, I can explain to you a lot.
Yes.
Factual, we should be correct.
Yes.
By order dated 22/2024, joint registrar declined our proposed amendment.
Correct.
Then we are 3/7/2024, your lordship passes an order. Then we are joint registrar on 3/8/2024, passed an order, directed us to amend your bylaw as he suggested. That order was 3/8/2024. That was the subject matter in the pending writ petition at the instance of two primary societies.
Last sentence. However, the joint registrar of cooperative societies issued one more order dated
3/8/24, my lords.
3/8/2024.
After issuance of your lordship directions.
ಏನಂತ?
My lords, it's in page 40, wherein we have directed them
Order
to
happy-
page 40, if
Page
my lords
40
get in extension.
Page 44 may kindly be seen.
I will read 3/8/24 order, my lords. ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ 6/12.
44.
Page 40 in our extension.
Page 45 ನೊಳಗೆ.
I will read that order, my lords. My lords, the order dated 6/12, ಆದೇಶ ನಿರ್ದೇಶನ 3/8/24, ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ 6/12/2016 ದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಶ್ರೀ ಸೋನ್ಸೋ ನಿರ್ಬಂಧಕರು ಪ್ರಾಂತ್ಯದ ನಾನು ಕೋಲಾರ ಮತ್ತು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಸಹಕಾರ ಬ್ಯಾಂಕ್ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ 2 ಜಿಲ್ಲೆಯ ತಾಲೂಕುವಾರು ಹಾಗೂ ವಿವಿಧ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸುವುದು ಅವಶ್ಯಕವಾಗಿರುವುದರಿಂದ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಕಲ್ಪಿಸಿರುವ 1 ನಿರ್ದೇಶಕರ ಸ್ಥಾನ ಮತ್ತು ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಕಲ್ಪಿಸಿರುವ 1 ನಿರ್ದೇಶಕರ ಸ್ಥಾನವನ್ನು ತೆಗೆದುಹಾಕಿ ಸದರಿ ಈ 2 ನಿರ್ದೇಶಕರ ಸ್ಥಾನಗಳನ್ನು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲೆಯಲ್ಲಿ ಹೊಸದಾಗಿ ರೂಪಿತಗೊಂಡಿರುವ ಮಂಚೇನಹಳ್ಳಿ ತಾಲೂಕು ಮತ್ತು ಚೇಳೂರು ತಾಲೂಕುಗಳಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸಲು ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯ ಸ್ಥಾನಗಳನ್ನು ಪುನರ್ ರಚಿಸಿಕೊಂಡು ಉಪವಿಧಿ ಸಂಖ್ಯೆ 4I ಮತ್ತು 9A ಅಳವಡಿಸಿಕೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಿರುತ್ತೇನೆ. ಈ ನಿರ್ದೇಶನ ಸ್ವೀಕರಿಸಿದ 30 ದಿನಗಳಾಗಿ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಸ್ಥಾನಗಳನ್ನು ಪುನರ್ ರಚಿಸಿ ಅಳವಡಿಸಿಕೊಳ್ಳಲು ನಿಯಮಾನುಸಾರ ಅಗತ್ಯ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಂಡು ತಿದ್ದುಪಡಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿತು. This has been questioned by the Women's Society.
ಒಂದು ವೇಳೆ ನಿಗದಿಪಡಿಸಿರುವ ಕಾಲಮಿತಿಯೊಳಗೆ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 12(5) ಅನ್ವಯ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶಗಳನ್ನು ಪಾಲನೆ ಮಾಡಿ ಅಳವಡಿಸಿಕೊಂಡು ತಿದ್ದುಪಡಿ ಅನುಮೋದನೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ್ದ ಪಕ್ಷದಲ್ಲಿ 12(6) ಅನ್ವಯ ಮೇಲ್ಕಂಡ ಯಥಾ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಪುನರ್ರಚನೆ ಅವಕಾಶಗಳನ್ನು ಉಪವಿಧಗಳಲ್ಲಿ ಅಳವಡಿಸಿಕೊಂಡಿದೆ ಎಂದು ನೋಂದಣಿ ಮಾಡಿ ಪ್ರಮಾಣ ಪತ್ರ ನಿರ್ಣಾಯಕ ಸಾಕ್ಷ್ಯವಾಗಿ ಮಾಡಲಾಗುವುದೆಂದು ತಿಳಿಯಪಡಿಸಿದೆ. This is the direction issued.
This is
we are challenged at the
state.
instance of
This is
primary-
state. That is where we have filed vacating
So that, my lords,
application.
they can proceed, my lords, ahead with the elections as per, my lords, the earlier one, without giving representation to these
It
two
is
taluks.
we provided, I don't know why they are not repeatedly saying we are not provided. We provided the representation in our amendment.
No, it is not.
Provided not as directors. They have not provided them as directors. That learned senior counsel should clarify. They should have given them as directors from each taluka as per
Whether
their bylaw.
director will
They
be
don't want to
elect-
give like that.
Whether director will be elected in the election. These are all the 2 taluk constituencies to be elected from various talukas, including these 2 talukas.
Totally.
I really,
No,
how
totally.
they are misleading the things, I don't
Totally
know.
10
Who is
taluks were
misleading?
there. Additionally, 2 was created. Now, my lords, only 10 taluks are, my lords, represented by the directors, not these 2 taluks. My lord, let them clarify, my lords. If that is the case, my lords, then we don't have any case.
I
No,
file an affidavit. to
And
directors
ultimately,
of
they
the
don't
2
have
talukas.
locus.
that area comes, but my lords, area is
Every
represented,
constituency consisting of several members of primary society.
not the post.
There are 12 members, 12 constituencies are there. Each society, each constituency having stipulated number of primary societies. Primary societies will elect the respective directors to that particular constituency in the course of an election. This is the nature of the composition. Now elections is scheduled and these 2 talukas having their own representation. Even any primary society member is elected, that representation is as good as provided to the taluka only.
All right. ಏನ್ ಹೇಳಿದ್ರು? 3/8/2024. That in order to give representation to all the talukas and the primary cooperative societies, a post reserved for the director from the house building cooperative society and ಏನಂತಾರೆ ಇದಕ್ಕೆ?
Women, milk producers, women's society.
Milk producers, women's cooperative society were directed to be removed and representation was directed to be given from the two new talukas that were included within the jurisdiction of the respondent bank. Full stop. This order dated 3/8/2024 is now questioned by the two primary cooperative societies which were directed to be removed, namely WP number WP number 21521 of 2024 and
2271 of 24.
2271 of 2024. Full stop. The learned AGA would therefore submit, AAG would therefore submit that if the elections are now permitted to be held, then the grievance of the two primary cooperative societies in the said two writ petitions will go in vain. Full stop. Next para. Having regard
Go
to,
in vain, because my lord, is one.
having regard to
1 minute, my
the
lord.
grievances raised in the two subsequent writ petitions in WP number so and so, comma, and since the two writ petitions are in consideration before the bench having roster, comma, the time fixed for conducting the elections in terms of the order dated
3/7/2024.
3724.
stands extended. ಏನಂತ ಕೇಳಿದಿರಮ್ಮ ನೀವು?
4 ತಿಂಗಳು 4 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದೆ.
ಇನ್ನು ಇಲ್ಲಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಮೂವ್ ಮಾಡಿದೀವಿ, ಅದಕ್ಕೆ ನಮ್ಗೆ 4 ತಿಂಗಳು ಕಾಲಾವಕಾಶ.
4 ತಿಂಗಳು ಬೇಕು ಅಂತ ಕೇಳಿದೆ. 2 ತಿಂಗಳು ಆಗೋಗಿದೆ. ಲಾಸ್ಟ್ ಅಕೇಶನ್ I said, another 2 months still remains. They can do it ಅಂತ I said. And your lordship said in the order, if the amendment is not there, then the efforts will be vain. It cannot be. If that is set as our proposal will be comes into picture. There we have provided representation to the taluk. And one thing your lordship has to notice that these arrangements, these developments have taken place after your lordship direction.
The pendency of earlier proceedings was not brought to my lord's notice while passing the orders.
By another period of 4 months, commencing from today. Full stop. Next para. If a decision is taken in the said two writ petitions, comma, the process of conducting the elections to the fifth respondent bank shall be hastened, and the elections may be held as early as possible. Yes.
Great.
That one observation your lordships may kindly. Your lordship said if writ petitions are not allowed, that is pending, the entire thing would become vain. It may not be because.
That is my
suppose-
submission.
1 minute, why you are bothered?
My
My lord,
submission.
if that resolution or a decision taken by the joint registrar is part of the learned, our decision which is set aside by the joint registrar will revive. Their representation is there. It never goes vain at all at any consequences. May kindly observe that. Tomorrow, my lord, they can place this observation before the other bench. Other bench have already opened.
Now,
This is the thing.
now who is opposing that in that other writ petition? Two
They
writ-
are.
Yaru?
Government.
Now we want to give representation, they have taken stay.
That also intended.
They don't.
Absolutely, there is no conflict at all.
If there is no opposition there, please go make a statement and get the writ
In
petition.
fact, yesterday, my
Our,
lords, the
our
learned,
opposition.
they can say that before the
Eliminating
learned.
the affects not, they have directed us to include. It is not possible, we are saying, only to the text and we will file an affidavit to that effect. So far as inclusion of taluka, we have no objection.
No, but the order very clearly says house building cooperative society and that
One society.
women's
There we have
cooperative
a
society
complaint.
are to be removed.
There we have,
That is why they are aggrieved and they have filed the writ petition.
but not against that.
Yes.
The entire order we have challenged. We are confined so far as directions to the extent of including primary society, another society, and adding the affects bank. To that extent, we have a complaint.
Let us see.
Societies, plots.
All right.
At least that observations may be made. Any any observation
I have
here
only
is.
said
No,
it
no,
will
one
be
minute.
extended by another 4 months. If those writ petitions are decided early,
Yeah.
the election should be held earlier. That is
Any
what I said.
observations could be confined to this application for a moment.
I have not,
Otherwise, your
I am-
lordship said it become vain. Your lordship said, if that amendment is not decided,
no. If the elections are held now, those two writ petitions will become vain. That is what I have said.
no.
In the light of those two writ petitions being pending,
That's what I said.
and if I direct them, no, please go ahead with the election, those two writ petitions will become vain. That is what I have said. Yes,
What I would like to say is, may kindly clarify.
there is no opposition. Please go ensure that the writ petition is
Kindly
disposed of.
clarify, not be painful or prejudicial to anybody's case. Your lordship may kindly say, these observations confined for disposal of this application. That's all I wanted to say. I am suffering since Mela 2003-7-2020.
All right. These observations are made only for the purpose of disposing of this subject. All right.
It would be a reason for them to make one more law before the court.
They have not each and every note that they file writ petition, they obtain this day. They don't want not the election to be held, but they want the election to be held as per not the earlier calendar, not the electoral.
Well,
college, not
they be-
representation.
My lord,
All right.
baby,
Illa, you please go make your submissions there.
baby
Please ensure-
always cries when baby become hungry. They cannot fight fault with the crying is concerned. They should provide feed us correctly. That's what our grievance.
All right. Yes.
Grateful.
Serial number 81.
Lords, this writ petition is with respect to that supply of media forged balls to Hatti Gold Mines, my lords. On the last date of hearing, my lords had indicated them to seek instructions with respect to any impediments in using the supplied material and ascertaining if they have any actual issue, my.
What instructions?
The instructions we have is that according to the letter of intent which is being issued to them, that's the amount of balls which we have to use is 1.4 kgs per ton. Which means, my lords, 1.4 kgs of balls is required to mill out 1 ton of ore which we get from our gold mines. Now, my lords, the usage of these balls would make us use more than 1.4 kgs of balls, which would lead to an effect where, my lords, we will be consuming more number of balls, more electricity, and consequently there will be a loss to the PSU. So that's one suggestion, my lords, from the Hatti Gold Mines was that, my lords, there is a test by named marked ball test, my lords, which decides the wear weight. Now, my lords, that test, my lords, at the if the petitioners wants, they themselves can do it. It's a short test which can happen over the period of 24 to 48 hours. What happens is that, my lords, this sample of it is taken. We give the conditions, how our mill is working, how our mine is being operated. That is created in a lab. That is run. The balls are put through that pipes and it's drilled, my lords. And after 48 hours to 48 hours, my lords, we get certain calculations. That calculations, if multiplied, my lords, if it matches to 1.4 kg per ton, we can use it, my lords. This is the shortest solution which we can provide, my lords, in terms of usage.
My lords, if I may, my lords, it's one or the other rules with respect to conducting some form of retest, my lords. My lords, as per, please, I just want to make one submission. I'm just making one submission, my lords. Subsequent to my submission, any Revertal may be done, my lords. My lords, my only contention is this, my lords. As per the joint inspection that was directed by this honorable court on 9/9/2024, a retest was conducted. When I procured the material, my lords, I'm not a manufacturer, I'm a supplier. And I've, as per the tender document and as per the purchase order, they've asked me to specifically procure from a particular company, from a manufacturer. I've procured from that manufacturer and supplied to them. So, my lords, in essence, my lords, when I procured it, the test came in my favor. Subsequently, when the court directed for a retest, it came in my favor. My lords, the only intention here, my lords, is that they are not at loss, my lords, even for a minute, my lords, even if they use more than what is required.
Is there any material to show that it was procured as per their?
Please, my lords, I would just take my lords to that particular contention, my lords. My lords may just turn to page number 49, my lords, if you have the petition copy, my lords. Annexure B2, my lords.
Yes.
My lords, point number 4, my lords. My lords, the make is specifically confined. My lords,
In page number 49, is it?
49 is the purchase order, my lords, where it starts, my lords. If my lords may come to page number 50, my lords. At point number 4, my lords, which categorically states that make Oriental Castings and Forging Limited / KML Industries, China. My lords, basically, my lords, this condition imposes upon me that I have to procure these materials from only these two manufacturers as per their requirement. My lords, subsequently, my lords, if my lords may just please come to Annexure C, my lords, of the writ petition at page number 55. After the tender being issued to me, during the subsisting tender, they issue an amendment letter dated 24/11/2023 saying, now I would not accept anything from Oriental, I will only accept from KML Industries, China. My lords, if my lords may now come to Annexure E, my lords, which is at page 79, my lords. My lords, this is the test report, my lords, that was procured by me. Annexure E, my lords, page 79, my lords.
No. This 24/11/2023.
Please, my lords.
Was issued after you have procured, is it?
Yes.
After I've procured and supplied one lot, my lords. After I finished supplying one consignment, they come up with a fresh condition saying, no, I will not. The first consignment was supplied from Oriental. They had no issue with it. They utilized it. Payment was made. Subsequently, the second consignment, they say, before I supply the second consignment, they say, I won't take from Oriental anymore. I will only take from KML. I, in fact, had to go beyond and above to procure this only from KML. Subsequently, my lords, what they do is this. Look at the high-handedness of respondent number 1.
Procured from KMI only.
I procured from KML. As per the tender, as per their own amendment letter, I procured from KML.
Then show that they have.
My lords, let me just make my submission, my lords.
My lords had asked.
Let me just make my submission, my lords.
Let us see.
My lords,
You will also get an opportunity.
Yes,
my lords, they say only supply from KML. I supply from KML. My lords, to that extent, my lords, when I procured this material from KML, I've gotten a test done, my lords, which is at Annexure E. My lords, their only contention is a particular component of the supply that I've done is below a particular permissible limit, manganese limit. If my lords may please come to page 79, my lords, which is Annexure E. My lords may look at point number 2, my lords, under carbon, which is manganese, percentage 0.65. It is well within the prescribed limit when I procured it from.
Whoever participates in the bid.
Please, my lords.
Are given the same specification?
Same specifications, my lords, yes.
Those people also have to buy procure it from the same suppliers?
No, my lords, not necessarily. Few people manufacture on their own. Me as a supplier was procuring it from these two companies, my lords, as per the tender condition.
Then what is it that you pointed out from this page number 51?
My lords, that was a purchase order issued to me, my lords. By respondent number 1 issued to me after I succeeded in securing the tender. This is a purchase order issued by them to me, specifying from where I should procure this material.
So similar conditions will be imposed on the other
In the subsequent tender also, yes, my lord.
tenderers also.
Yes, yes, my lords.
So you are constrained to procure from the same entity
Please, my lords, absolutely, my lords.
in terms of their direction.
As per this purchase
You have
order,
procured it from them.
please, my lords. That is my contention. My lords, subsequently, my lords, at annexure E, my lords, you will see that the value of the manganese is as per prescribed limit, my lords. So even that, there was no issue, my lords. My lords, only after I supplied the second consignment from the entity that they asked me to procure, after, as per the purchase order, they have to make the payments within 30 days. I supplied to them on 10/2/2024. They had to pay me by 10/3/2024. My lords, without any prior notice, prior information, without any sort of indication, they suddenly tell me, without any testing, to show anything on record, my lords, they say, your material is subpar. My lords, in fact, I've produced a message, my lords, of the MD who says that my material is subpar and I don't want to take it. There is no rationale, no nexus, nothing, my lords. It is only arbitrary in nature. My lords, all of these facts apart, my lords, right now, my lords, even after a joint inspection and test was done, it is within the prescribed limit. There is no issue with 65 mm. 125 mm, I'm not even contending vehemently. All that I'm saying is let them use it and let them pay me only on pro rata. Their issue is that it will be consumed more. I'm saying, okay, if it consumes more, you show that to me, I will supply. I have more stock with me. They need it on an everyday basis. It's not that it's a one-off instance that they're procuring this. They need it on an everyday basis and they have to use it for separating or breaking down the gold ore. And my lords, this particular contention, my lords, or the manganese level, which in fact is under prescribed limit, does not affect their production of gold at any point decimal, my lords. My lords, in fact, my lords, if my lords may please come to the tender condition, my lords, which is annexure B, my lords. Just the last thing that I want to highlight to my lords is this, my lords. Lords, if my lords may please come to page annexure B. Annexure B, and annexure B starts 42, my lords, and at page 44, my lords. My lords, apologies, my lords. Page 39, my lords, can refer to. My lords, all the hue and cry about the tolerance level, my lords, in their own tender requirement document, they say tolerance level can be plus or minus 10%. They don't say it should specifically be within a particular amount. They say that, and then they say tolerance level can be plus or minus 10%. They might now come and say that it is based on the entire weight of the consignment that was sent and all of that, but nothing is mentioned here, my lords. Nothing for whatsoever, for sake of clarity, is not mentioned here, my lords. Even as per this criteria, my lords, not just my 65 mm, both by 125 and 65 mm will clear, my lords.
Where is that in page number 39?
Page number 39, my lords. If my lords may just look at description, under the description column, my lords, table, grind media ball 65 mm. The last line, my lords, report will be final, tolerance will be plus or minus 10%. My lords, right now the entire fight is about certain decimal points, my lords. With respect to the test that was done, my lords, the joint test report, which was filed on 30/10/2024, my lords. My 65 mm is well within the permissible limit. My 65 mm stock that I supplied is 0.796, which is much above the prescribed limit. My lords, my 125 mm, my lords, is at 0.5. Even as per their own contention, as per their own tender document, it is still permissible, my lords. And my lords, I am still here contending that you please utilize my material. You make payment on a pro rata basis. My lords, there is no reason for my rejection also, my lords. If my lords, one last thing that I wanted to showcase, just to highlight the high-handedness, my lords. My lords, they rejected my I also had participated in the subsequent tender. They reject my subsequent bid for the only reason that
In the previous, this is the rejection reason, my lord. In the previous tender, the bidder has supplied forged steel grinding media from Oriental Casting, China so-and-so, which is the chemical composition of the material was not as per HGML requirements. Since in the present tender, which is the subsequent tender, the bidder has mentioned that the supply will be from so-and-so vendor, and the chemical composition of the forged steel grinding media balls was not as per our requirement in the previous tender, hence the bidder is disqualified. The only reason why they disqualified me is because the prescribed limit was not satisfied by me. Now, as per the joint test, I have satisfied it. Okay, for that sake of argument, let us say 125 was disqualified. So this particular reason for disqualifying me in the subsequent tender is not valid. That is why even that is challenged. My lords, now they don't even budge, my lords, in so far as utilizing it. And now they come up with a fresh scheme, my lord, saying, let us do this new test. You only do it, then let us know. My lords, the issue is this, my lords. They are not at loss. I have procured the material as per their requirements. I have incurred capital payments of around 7 to 8 crores, my lords. I am not a big company. I am an MSME. My lords, I am struggling financially. I am not able to make payments, my lords. I have already paid payments to the manufacturer. I am only a supplier. I am a mere supplier. They only want it from them. So what is my fault, my lords, when in fact the goods are supplied is the prescribed limit as per the joint report? My lords, now there is no rationale for them to ask for a retest, my lords.
All right. Yes.
That's statement. I'll answer one. That's we didn't tell the source of procurement.
Everything is available here.
That's right.
On record.
That's
You
right.
cannot say so.
I'm saying that, my lords, what happens is, my lords, we come up with something called notice inviting tender. They come from the place of procurement. They give that. Once they tell we are procuring from ABCD place, here in case of Oriental Casting, that's once they succeed in the tender process, we enter into an agreement with them where we mention the place where they told they will procure it from. Number one, my lords. Number two, my lords, what is being shown as at page number 39 as an agreement, we never prescribed the place of procurement. It is them. For example, my lords, may take my lords to my statement of objection to page number 83 for a moment. There, in my statement of objection, it's where the second tender which they have gone ahead filing, my lords, they have mentioned where they are procuring it from. My lords, I cannot say, my lords, take it from ABC. In that case, my lords, I myself can procure it. That is my first contention. My answer to that statement, my lords. Second, my lords, in so far as the tolerance level of 10%, my lords may turn to that page, my lords, where my friend is referred to.
Yes, page number 39.
Yes, my lords. My lords, in the amended writ petition, my lords, I'm assuming that's page number 44, where the tabular column is there, my lords. The tabular column has got multiple components to it, my lords. May I request my lords to look at it? That, my lords, at the beginning, we say, my lords, size tolerance is 65 plus or minus 3 mm. Like that, my lords, wear tear 140 kg per ton. Forged steel media ball size 65 mm. Chemical composition, so carbon manganese. My lords, I would request my lords to look at manganese, my lords, 0.6 to 1.2. Chromium less than chromium less than 0.025. Silica sulfur again less than 0.04. Phosphorus less 0.04. Free from cracks, burn scales. Test report of grinding media balls will be done at our SA R&D lab. Test report will be final. Then, my lords, the tolerance level, which is plus or minus 10%. My lords, nobody, my lords, in terms of dealing with steel or forged media balls or cast iron, my lords, if I ask for 1000 kgs, my lords, nobody will be in a position to supply 1000 kgs dot, my lords. It will always be plus or minus to that effect. We had sought for 360,000 tons. My lords may look at it, unit. Next is quantity. So, my lords, the 10% argument which the petitioner is trying to lay by saying, even if my test is failed, I come within the 10% plus or minus is not applicable to the chemical composition, because, my lords, the tolerance level of plus or minus 10%, my lords, is the quantity and not the chemical composition.
Absolutely wrong.
Lords, and
you can't apply this theory for the quantity, sir.
Millards, then
What is this you are
we can't,
saying?
Millards, we
No,
can
no.
never get, Millards,
No.
third condition, Millards, third
Perfect.
argument, Millards, may request, whatever they're seeking
I will
today.
note down whatever are the submissions. I will give you one more opportunity. Please place it before the authorities and take proper instruction.
Let's be-
Otherwise, I'm going to be very, very strict in passing orders. Barkale.
They're just saying.
On the previous date of hearing, the learned senior counsel appearing for the respondent company was requested to secure instructions as to whether the whether a small quantity of the material supplied by the petitioner can be put to use to find out as to whether the same would work in terms of the requirement of the respondent company or not. Full stop. Today, it is submitted at the hands of the learned senior counsel appearing for the respondent company that the material supplied by the petitioner can be tested.
Marked ball test.
Once more,
different test. It's not a same test. It's a
different.
mark ball test. ಅಂತ ಅವರೇ ಮಾಡಿಸ್ಲಿ.
Bottom line is a test.
all right.
Mark ball test.
ಏನ್ ಹೇಳಿದೆ?
To check the wear rate.
The material supplied
Mark ball, MARK,
can be tested through
a test known as mark ball.
a test known as mark ball
test.
test.
MARK
To test
BALL.
To test the wear rate.
That will test the wear weight.
At any place where the petitioner would suggest. Full stop. Next para. However, learned counsel for petitioner submits that this is nothing but seeking a separate test or another test contrary to the reports secured by this court by directing that the test shall be conducted in a particular manner
On 9/9.
in a particular place.
That was composition test.
Full stop. The learned counsel would further draw the attention of this court to the purchase orders at annexures B series and points out that the purchase order specifies the make as inot commercially Oriental Casting and Forging Company Limited bar KML Industrial dash China close inot comma. Learned counsel submits that in terms of the said specification, the first consignment was procured by the petitioner from Oriental Casting and Forging Company Limited. Full stop. However, subsequently, the respondents issued an amendment letter on 24/11/2023 at Annexure C, directing that the purchase order in terms of the purchase order, the material should be procured only from KMI or KML.
L, my lord. L.
KML Industrial dash China. Full stop. Learned counsel submits that accordingly, the second consignment was procured from KML China in terms of the requirement of the respondent company. Full stop. Learned counsel submits that the petitioner is only a supplier and is not a manufacturer, and the procurement was obtained from the company and manufacturer prescribed by the respondent company.
In the PO.
And no fault can be found with the petitioner. Full stop. Even otherwise, comma, it is pointed out from Annexure E test report that the material supplied by the petitioner meets all the requirement of the respondent company. Full stop. Further, where is that tolerance level? Tolerance level? Tolerance level.
Well, tolerance level is the annexure B. Annexure E and N, my lords, at second box, my lords, manganese.
Page number?
Page number 79, the annex, 39, my lords.
39.
39 last line, my lords.
In the table.
In the table, my lords. Tolerance plus or minus 10%. 39, my lords, page 13.
Further, it is pointed out from Annexure B.
Annexure
B. Comma, the agreement signed between the parties that having regard to the description of the material, comma, and all other specifications, comma, it is clearly provided that test report of grinding media balls will be done at the assay ASSAY, A capital, R&D lab of the respondent company, and that test report will be final. Full stop. However, tolerance of plus bar minus 10% is what is
permissible.
Permissible, even according to the said agreement. Full stop. With this, comma, the learned counsel points out to the lab reports, furnished by the respondents, and the subsequent report
Joint inspection.
obtained in terms of the directions issued by this court that it would definitely meet the tolerance level of plus minus 10%. Full stop. Next para. The learned counsel would further add that if it is the contention of the respondent company that it will have to use more quantity of material supplied by the petitioner for extracting the requisite quantity of gold, comma, then the petitioner is also ready to supply more material in order to ensure that the requisite quality is obtained by the respondent company. Full stop. Next para. A copy of this order shall be furnished to the respondents. Full stop. The learned senior counsel representing the respondent company is requested to place this order before the managing director of the respondent company and secure instructions. Full stop. Release this matter on 5th of February.
Please may record our submissions also, my lords, because one is, my lords, please come to page.
Allah, whatever it is. Now, in terms of the submissions made by the learned counsel, he is saying whatever is the deficiency, even if it is found, I am prepared to ensure that no loss is caused to the respondents.
That's only for one consignment of 65. We have to make it very clear. It is only one consignment of 65 mm, which is lying within my yard, nothing more. What is keeping it in his godown, we are unable to take it, my lord.
No, Angalla.
Test agreed it one.
No. The thing is, his basic contention is that the manner of rejection of the material is contrary to the agreed conditions. Despite all that, since he is only a supplier and he has procured the consignment as per your directions.
We have not directed, my lord.
He has pointed out.
My lord, that is, my lord, I'll just submit this.
Yes.
Nobody manufactures that here. Everybody imports. So he only, my lords, when we put a tender, he says, I'll get it from this source.
Yes.
It is not that I say you get it from this source.
Yes.
That is one, my lords. That is how he gets. Now, if he gets it, if it does not meet our standard, merely because he has got it, I am not obliged to take it.
All right. We will consider.
Anyway, we'll consider.
We
My
will
lords, only
consider.
one submission I would request. Your lordship may also say, my lords, in that at page 44, your lordships refer to the test report. There is also a wear rate. That is important. That's what, Lord, page 44 al tav bandre. 44. 39. Same page. Your lordships are seeing.
Same page. 39.
Adralli, your lordship saw the last one, composition of 10% antala. Please see on that, my lords, size tolerance and wear rate antade, WEAR. That is again a test. That, my lords, has to pass. That is why we are saying, you get it done, because if I put it in my thing, I'll have to stop the entire production. Instead of that, there will be someone who will do the wear rate. They can do it. My lords, this is not even. 1 minute, let me just finish it. My lords, if your lordship sees.
These are the contentions of the learned counsel for petitioner. It has been recorded and it is now put to you.
Yes, my lord.
Please
But if
secure
we will
instructions
secure-
and then make submissions.
Because what happens is, my lords, when we put it to them, they'll say, you did not point out this. That's why I'm saying our contention briefly, your lordship may record. Tomorrow it should.
It's a matter of record, my lords.
It can be, then even his contentions are a matter of record, then why should that be recorded?
In
My
fact-
friend, I'm
in
only
fact-
saying, my lords, tomorrow when he goes before the MD, we will have to, my lords, we know how to put it across. We have understood this. But tomorrow he should not get into trouble that you did not point out this.
This court has only directed to place this before the respondent, managing director, secure instructions and make submissions. You please secure instructions and make submissions. We'll see.
Much obliged.
Yes.
Number 38. Janardana Ji, FEF, second time.
Appearing for petition, my lordship. 1 week time may be granted to file the necessary application, substitute service, my lordship, by way of affixture. 1 week time may be granted, my
Many times
lordship.
have you taken notice?
2 times, my lordship.
3 times you'll have to take.
Yes, my lordship.
A week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on respond number 5.
Much obliged.
Yes.
39. Harish MG, second time.
Appearing for the
R2 to
petitioner, my
five.
lord. My lord, day before yesterday, they have served the copy of bank accounts of statement, my lord. Statement of.
Please to respond number 2 to 5.
Yes, sir.
You are appearing?
Served, mine.
You are
Yes, sir.
appearing.
I'm appearing for the respondent number 2.
Response number? What do you file?
First respondent.
Only first respondent.
Respondent.
What about 2 to 5?
No, we are a petitioner, my lord. I'm petitioner, my lord.
You know?
I am petitioner, my lord.
Correct. You are required to take steps for service
Yes,
of notice
yes,
on
my lord.
response number 2
I
to
kindly
5.
pray for 2 weeks time, my lord, while you take.
No, why 2 weeks?
My lord, day before yesterday, they have served the copy, my lord.
ಏನಪ್ಪ ಸ್ಟೆಪ್ಸ್ ತಗೊಳಬೇಕಪ್ಪ ಪ್ರೋಸೆಸ್ ಫೀ ಕಟ್ಟಬೇಕು ನೋಟಿಸ್ಗೆ ಪ್ಲೀಸ್ ಡೂ ಇಟ್ ಟುಮಾರೋ ಇಟ್ ಸೆಲ್ಫ್
My lord, kindly see the order dated 9/11, on 20/11/2024, my lord.
ಸರ್ಫೇಸಿನ
Surface, yeah.
ಹಾ
The
9
20/11/2024. My lord, we have re-delivered the possession of the property and we received 30% of the total dues. And in that order.
ಒಂದ್ ನಿಮಿಷ ಹಾ ಓದಿ
meanwhile, the
Petitioner hands over two demand draft for sum of rupees 15 lakhs each.
that we have received.
Learned counsel for respondent acknowledges the respondent bank to redeliver physical possession of the mortgage property to the petitioner forthwith.
Yes,
In the
ma'am.
meanwhile, petitioner to file affidavit undertaking to pay the entire outstanding amount. You will not file the affidavit?
Cannot find.
Why?
We will file the necessary.
Again, two more adjournment they have taken.
Ah,
On that day itself, they have not filed a undertaking affidavit. My lord, we have redelivered, the honorable court has to only direct him to file an undertaking affidavit. Based on that.
Learned
only, my
counsel for the respondent bank points out to order dated 2011-2024, where this court has recorded the fact that on receipt of rupees 30 lakhs at the hands of the petitioner, the respondent bank has redelivered physical possession of the mortgaged property to the petitioner. Full stop. However, in spite of directions issued by this court that an affidavit undertaking to pay the entire outstanding amount due within a reasonable time has not been filed by the petitioner. Full stop. Next para. Release this matter on 6th of February 2025. Full stop. If no affidavit is filed by the petitioner by the next date of hearing, indicating the time schedule for repayment of the entire outstanding amount along with interest, the writ petition will be dismissed. Yes.
Number 40.
Hearing for the petitioner, my lords,
Krishna Reddy.
we filed an IA for early hearing, my lords. Subsequent to the interim order granted by this honorable court, my lords, we deposited the balance amount for the land allotted, my lords.
What early hearing? What? Huh?
My lords, we have filed the amended writ. My lords, amended writ petition has been filed, my lords, and been served on the. We'll do that during the amendment will be carried out now.
Huh? Ah. Elri amended petition. Huh? Allah amended petition ಹಾಕಿದೀವಿ ಅಂತ
Please,
ಹೇಳ್ತಾರಲ್ಲ.
my lords, we filed the
When?
petition. My lords, it has been filed on 27/6/2024, my lords.
27/6.
Please, my.
ನೋಡ್ರಿ. Yes, what is the matter about?
Please, my lords, land was allotted to the petitioner, my lords. Subsequently, without any notice or hearing, my lords, it has been re-allotted to respondent number 6, my lords. My lords, by way of interim order granted by this honorable court, we had deposited the balance amount for the land allotted, my lords, of rupees 9 crores and 46 lakhs. My lords, the amount has been deposited. It has been over 8 months, my lords, that the amount has been deposited. My lords, that's why.
Huh?
For a lot. Allotment did not take. For a- Man, no, no, no. They had not picked the allotment, but 5 years of delay.
Did you cancel the allotment? Cancel.
My. Well,
Huh? AG. AG. Oh, this is the matter concerning KADP. Then see, if the writ petition is not considered and disposed of, you will also suffer. This interim order is not going to get vacated now. The matter only has to be disposed of.
Well, as a matter may be fixed at 2:30, my lords, any convenient date to your lordships.
Learned counsel for the petitioner submits that during the process of this petition, the petitioner has deposited a sum of rupees
9 crores 20 lakhs 40,000 and 230 rupees, my lords.
with the respondent KADP.
No, my lords, before the Registrar General of the High.
Before the registry of this court. Full stop. There is also an interim direction to the respondent KADP. Yenanta?
My lords, to not precipitate the matter, my lords, in view
Not
of the
to
amount being.
precipitate the matter in respect of the reallotment in favor of
Respondent number 6.
respondent number 6. Full stop. In that view of the matter, application in IA number 1 of 2025 for early hearing has been filed. Full stop. Next para. Release this matter on 11th of February at 2:30 PM.
Grateful, man.
Yes.
41. Yes.
Appear on
Sridhar.
behalf of the petitioner. Lord, this is a matter where, Lord, for setting up of an ethanol plant, we had taken a loan of, my lord, a loan sanction of 83 crores. In that, my lord, the bank, Canara Bank, my lord, sanctioned 53 crores. They did not, my lord, sanction the balance. Then we said, please cap it at 53 crores and that be done, my lord, because they didn't do it quickly and we had to take from other banks. Then, my lord, that 53 crores, then we came to know, my lord, that these people, my lord, they're charging interest of 10.36%. And other banks, my lord, are charging interest at 8.75%. So, my lord, we then made a request to them that you please charge the same interest as others are charging and continue it. My lord, they don't respond to that. Then, my lord, we asked them to close it so that, my lord, we can go to the other bank. Now, for that, my lord, what happens is, they, in fact, earlier, we had, my lord, given our house property papers because, my lord, this was from the KIDB, the lease and sale, those documents were not there. Then subsequently, my lord, the industrial lands, papers, we gave it to them, requested them to give back our house papers, which again, there's no response. Then, my lord, what they do, if your lordship sees Annexure A at page 20, my lord. My lord, there, if your lordship sees, with regard to foreclosure, payment penalty, 2% of the prepaid amount loan prepaid from the own sources will not attract pre-closure charges. Recovery of concessional ROI in case where the account is taken over by the other bank's concession. So the applicable charges on the above conditions as follows. 2% payment on outstanding principal, 1 crore 5 lakhs so and so. Now I'll just pause here for a moment. This 1 crore, my lord, they immediately, without assigning anything, they debit this and they've taken this 1 crore. My lord. They've already taken. Now what they say is that you have to pay 3 crores on return on interest concession. My lord, no concession has been given. Now what they say, my lord, now these people, they're charging 10.36. Others are charging us 8.75. They say that, no, normally we would have charged 14% or 15%, but we have come down on for you as 10.36%, which, my lord, the other banks are giving it at a much lesser price. So for that, they are charging this. And, my lord, we have, when this, it was sanctioned, nowhere it was mentioned. And I must bring it to your lordship's notice, my lord, that when this amount, my lord, with regard to the loan which was taken, indisputably, my lord, not a single default from our side. It has been serviced. Everything has been paid on time. Not a single default on our part. It is only, my lord, we go to them and tell them that since others are charging at a lesser price.
What is the prayer in the writ petition?
My lord, the prayer, your lordships will get it at page 17. Page 17. My lord, to set aside the communication dated 24/5/24 at Annexure A. So, my lord, to this, my lord, the first one, my lord, they have taken 1 crore, my lord. That, my lord, we will not press, my lord. That they have taken it, my lord. Let them take that for court, my lord. But this another 3 crores, my lord, and for no reason, my lord, return on interest.
Consider all this in writ petition.
No, what happens is this: Canara Bank, my lord, again, my lord, there,
How
my lord,
can we
this was
consider
the
all
first
this?
question that, my lord, I was asking that, my lord, what happens is this, my lord, if it is said contractual or whatever, my lord, we should have been informed. My lord, there are judgments of this honorable court and apex court, my lord, where they have to follow the RBI guidelines, and even as a bank, they're supposed to act fairly, my lord. If they don't act fairly, my lord, then this court will have the jurisdiction.
To the ombudsman.
No, my lord, I don't.
Yes, there is a bank ombudsman. Go give a complaint. This is what they are doing.
No, what I'm submitting is this. Here, my lord, if we are able to
But
show.
how can this court go into all these aspects?
No, my lord, now.
Whether this was what was agreed, all that cannot be gone into a writ proceeding, sir.
My lord, my only request is this: if we are, my lord, able to show prima facie, my lord, that what they have done, my lord, is not correct, my lord, then to that extent, my lord, if it could be.
It's a question of contract, sir.
My lord, I do understand, my lord. Just my lord, I was saying about the same thing, my lord, that one is ombudsman and one is with regard to the, my lord. But here, my lord, my lord, there are judgments, my lord. If your lordship just gives us some time, my lord, we'll produce those judgments which to say that if, my lord, there is no fair play on their part. My lord, that's why I said, my lord, what I'm trying to say before your lordship says, our bona fides, my lord, is not in question. My lord, they cannot dispute that we have paid everything. My lord, they have recovered 1 crore and odd, my lord, for pre-closure, my lord, that is done. Now, this one, they're saying that it is return on interest, my lord, that concessional interest which we are giving. So, my lord, these letters are their concessional interest, my lord. In fact, they're charging more than the other banks. So, my lord, my lord, because in other matters, my lord, where the banks have not, my lord, this honorable court has taken a decision, my lord, they have passed a judgment that even with regard to OTS, one-time settlement, but I'm only trying to bring to your lordship's notice.
That will be in terms of the guidelines issued by the RBI.
Yes, ma'am.
They are all banks in the country, including private banks. They are all to follow the
RBI
guidelines.
Yes, ma'am.
And if are able to point out that this is the guidelines and they are acting contrary to that, we can interfere. Otherwise, no.
My lord, page 40. Their objections, page 14.
No, that should be found in your petition, the grounds that you have raised. Not by way of pointing out to some material placed by them.
My lord, your lordship may, my lord, just accommodate me for a short thing, my lord. Next week, your lordship may have it. Lord, I'll produce those judgments and I'll produce if there is something with regard to RBI guidelines which we can say. Only, my lord, if ultimately we are able to convince your lordship straight on the point, my lord, with regard to the interest and that they can't charge, if the RBI says that, or, my lord, it's an unfair trade practice which they are following, my lord, then we would persuade your lordships to interfere. Otherwise, we'll have to, my lord, go to the ombudsman.
At the request of the learned senior counsel appearing for the petitioner, release this matter on 5th of February.
Please. I apologize, my lord, I was not present in the other matter. I was held up in Court Hall 1.
Yes.
I apologize for that. My lord, interim order granted earlier may be continued.
Interim order granted earlier stands extended till the next date of the date.
Public.
42, Ravi SK, awaiting.
For petitioner, Your Honor, my lords. This is a pre-MI matter, lords. In the similar matter, stay has been granted in WP number 34540 of 24, dated 19th December.
Tripartite agreement, my lord, the parameters in that agreement is entirely different from this agreement. My lord, I was permitted to take my lot to supplementary agreement. My lord, in this case, my lord, they approached the bank to purchase the flat, stating that they entered into an agreement of sale with the respondent number 6 builder. My lord, based on the tripartite sale agreement, my lord, which is at Annexure F, page.
Which is that writ petition where interim orders are passed?
That is, my lord, not even a single bricks have been laid. That was their submission. My lord, the loan has been sanctioned. My lord, the bidder has not commenced the project. Not even a single bricks has been laid. That was their allegations. My lord, based on that, the interim stay has been granted. We appeared and we filed the written statement in this matter, my lord. My lord, we kindly see the photographs, my lord. The project has been completed. Everything has been completed. I am demonstrating before this honorable court officer. Photographs nodidre gottagutte.
So the sixth respondent has put up the construction.
ಎಲ್ಲ ಆಗೋಗಿದೆ. Photographs ಎಲ್ಲ ಆಗಿದೆ. My lord, your case ಏನು ಅಂದ್ರೆ 10/1/2019, my lord, there is a sale agreement. My lord, on the same day, my lord, 10/1/2019, there is a tripartite agreement between the bankers, the borrowers, and the developer, stipulating certain terms and conditions. On the same day, my lord, the 10/1/2019, I will take my lord to page number 108. This is very, very important, my lord. 108. They entered a supplementary agreement with the builder. My lord, this supplementary agreement, I am not a party. Even in the tripartite agreement, my lord, this supplementary agreement has not been.
No. What is the grievance?
Your grievances ಏನು ಅಂದ್ರೆ ನಾವು 9 lakhs rupees ಕೊಟ್ಟಿದ್ವಿ. The investment is for profit. The investment, my lord, what they have paid the money to the builder, that investment is for profit. It is not for purchase of the flat. My lord, against the 9 lakhs which they pay, the builder assured them to repay 19 lakhs. 19 lakhs ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವರೊಂದು ಚಾರ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಇವಾಗ 15 lakhs 54,000 the builder has to repay it ಅಂತ. My lord, my contract is entirely different. My contract is that.
Where is the tripartite agreement?
My lord, the tripartite agreement is in page number 110. 110, my lord, tripartite agreement.
110.
110. Page number 116, my lord. Annexure. Annexure. My lord, there, my lord, I will take my lord to page number 120. 120, my lord. In page number 120. My lord, the borrower has informed the scheme of arrangement between the borrower and builder in terms of where a builder hereby assumes the liability of the interest payment under the loan agreement as payable by the borrower, HDFC till 31/3/2020. But in any case, not beyond 31/3/2020, the period referred to as the liability period and the liability referred to be as the assumed liability, it is however agreed during the liability period, the repayment of liability is of the borrower. The assumption of interest servicing liability up to 31/3/2020 by the builder in no manner whatsoever releases, relinquishes or reduces the liability of the borrower, and the same shall not be affected in any manner on account of any differences or dispute between the borrower and the builder under the arrangement between them. After 31/3/2020, the liability to pay the interest on the loan amount shall be that of the borrower, notwithstanding any other terms of this agreement or any agreement that would have been executed between the borrower and the builder, including the agreement of sale, undivided interest, so on. So,
what is the prayer in the writ petition?
My lord, the prayer, my lord, the prayer is so staged, my lord. I will take my lord to the prayers, my lord.
Since
the borrower has submitted to default, my lord, we are intending to invoke the SARFAESI measures. My lord, in order to thwart the SARFAESI measures now, my lord, this writ petition has been filed. My lord, I have already demonstrated the supplementary agreement. I could read the supplementary one paragraph, supplementary agreement. Adu nodbitre your intention gottagudi in collusion with the.
We are not concerned with that.
Yes, my lord.
That is why I asked only about the tripartite agreement.
Tripartite agreement.
Avaru enana ಮಾಡ್ಕೊಂಡ್ರೆ we are not concerned.
The investment is for profit.
So in terms of the tripartite agreement, he is supposed to pay the EMIs.
He is supposed to pay the EMI after
the borrower.
He committed default after payment of certain EMIs. My lord, the nearly 1.5 years he did not pay the EMI. Now the account has been classified as NPA. Now when we are intending to initiate the measures under the provisions of the SARFAESI Act, my lord, he is before the court. My lord, apart from that, he approached the RERA. That has been suppressed. RERA case number 24 of 2025.
All right.
A complaint has been filed before the RERA. My lord, let RERA decides the matter.
Any interim order is passed?
No interim order has been passed in this matter, my lord.
2 weeks time is granted to the respondent bank to file statement of objections.
Much obliged.
Much obliged.
Yes. All other matters next week.
Lordship, 43, one request, Lordship, one date may be given, 43.
Serial number 43, Milords. I'm sorry, Milords. Milords.
Interim order may be extended.
If the matter is not reached, there is no need to extend.
Please.
Yes.
Lord, serial number 43, my lord, there is some urgency in the matter for this reason, my lords, if I were to make a request.
My lords, in 47, item number 47, date may be fixed, my lords.
Hey, or ಎದ್ದೋಗಾಯ್ತ್ರಿ.
What up, sir? Serial number 43 entry ಮಾಡಿ extend ಆಗ್ ಸಮೇತ. What up, sir?
Sir,
entry ಮಾಡಿ extension ಮಾಡ್ತಿರಲ್ಲ. What up? What up, sir? 43 entry ಮಾಡಿ extend ಆಗ್ ಸರ್.
57.
Reporting.
ಅಭಿಷೇಕ್ mention ಮಾಡಿ.
45.
What up, sir?
44, 44.
Sir, reporting
43.
Reporting settlement.
ನಾಳೆ ಕೊಡಿ.
What of, sir? Sir,
Entry ಮಾಡಿ extend ಆಗತ್ತಲ್ವಾ sir?
Sir, 64 date. 64, serial number 64.
What up, sir?
Sir, ಎಲ್ಲದಕ್ಕೂ entry ಮಾಡಿ ರಕ್ಷಣೆ ಆಗತ್ತೆ. No dates will be given.
What of, sir? What of 49? ಅದು ಫೈಲ್ ಕೊಟ್ಟು ನಾನು ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ ಸರ್.
ಸರ್,
ನೆಕ್ಸ್ಟ್ ಇದೆ
ಯಾವಾಗ? ನೆಕ್ಸ್ಟ್ ಬರುತ್ತಾ ಮತ್ತೆ ಮೆಮೊ ಕೊಡ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಬರುತ್ತಾ ಮತ್ತೆ
ಬರುತ್ತೆ ಸರ್, ಹೇಳಕ್ಕಾಗೋದಿಲ್ಲ. Will come.
Sir, court officer serial number 74.
It will be extended as it is will be there.
Sir, serial number court officer sir.
ಬರೋದಿಲ್ಲ ಮೇಡಮ್. 2 weeks ಕೊಡ್ತೀನಿ. ಇನ್ನೂ ಪರವಾಗಿಲ್ಲ.
Sir, court officer ಅವರೇ.
Court officer, interim order extended. Serial number 68.
ಇಲ್ಲ, ಅಲ್ಲಿ ಮಾಡಿ, ಇಲ್ಲಿ ಮಾಡಿ.
Court officer. Sir, court officer ಅವರೇ.
ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. ನಿಮ್ಗೆ ಆತರ ಇದ್ರೆ ಒಂದ್ ಮೆಮೋ ಅಲ್ಲಿ ನಿಮ್ಮ ಗ್ರೀವೆನ್ಸ್ ಏನಿದೆ ಬರ್ಬಿಟ್ಟು ಕೊಡಿ, ಅದನ್ನ ಅಷ್ಟೇ. ಅದ್ ಬಿಟ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ನಾವು ಡೇಟ್ ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಕೇಳ್ತಾ ಇರೋದು ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದು.
7. A date may be fixed.
47. serial number ಏನ್ ಸರ್? ಎಸ್ ಸರ್. ತನ್ವೀರ್ ಸರ್. ಹಾ,
Court master.
yes sir.
57, sir. 57. 57.
DB.
What is that? What is that?
ಮಾಡಿಲ್ಲ ಆಫೀಸರ್.
What is that?
ಬೇರೆ ಅದೇ ತರ ಇದೆ ಆರ್ಡರ್ಸ್. ಅದು ಬೇರೆ ಸೇಮ್ ಆರ್ಡರ್ ಡೈರೆಕ್ಟ್ ಕೊಡಿದೆ ಈ ತರನಿಂದ. ಆಯ್ತು ಮ್ಯಾಮ್. ನಾಳೆ ಒಂದು ಮೆಮೊ ಕೊಡಿ ವಿಡ್ರಾಲ್ ಅಂತ, ನಾನು ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕ್ಸ್ಕೊಡ್ತೀನಿ.
76.
ಸರ್, ಆನ್ ಲೈನ್ ಅಲ್ಲಿ ಯಾರು ಸರ್ ಅದು ಹೇಳಿ ಸರ್? ಇಬ್ರು ಇದ್ದೀರಾ, ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ ಯಾರು ಮಾತಾಡ್ತಾ ಇರೋದಂತ. ಒಬ್ರು ಮ್ಯೂಟ್ ಆಗ್ತಾ ಇದೆ, ಹಾ. ಎಸ್ ಸರ್, ಹೇಳಿ ಸರ್. ವಾಟ್ ಇಸ್ ಯುವರ್ ಗ್ರೌಂಡ್ಸ್? ಸರ್, ಕ್ಲಿಯರ್ ಇಲ್ಲ ಸರ್ ನಿಮ್ದು ವಾಯ್ಸ್ ಆ ಕಡೆಯಿಂದ. ಇವಾಗ ಡಿವಿಷನ್ ಬೆಂಚ್ ಸ್ಟಾರ್ಟ್ ಆಗತ್ತೆ ಸರ್. ಇವಾಗ
ಅದೇ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಮ್ಯಾಟ್ರ್
ಇದೆ ಸರ್. ಇವಾಗ ಬರ್ತಾರೆ ಸಾಹೇಬ್ರು ಬರ್ತಾರೆ.
ನನ್ನ ಹೆಸರು
ಹಾ, ಓಕೆ ಸರ್. ಇಲ್ಲಿ ಬರ್ತಾ ಇದೆ, ಡಿಸ್ಪ್ಲೇ ಆಗ್ತಾ ಇದೆ.
ಓಕೆ ಸರಿ.
ಶಾವುದ್ದೀನ್.
ಜಮಾದಾರ್ ಶಾಹುದ್ದೀನ್.
ರೈಟ್ ಸರ್, ಆಯ್ತು.
Court officer.
Interim orders extended.
Serial number 57.
ಸರ್, ಸೋಮನ್ ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್, ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಡೇಟ್
Court officer, sir.
ನಿಮ್ಗೆ ಯಾವ ತರ ಡೇಟ್ ಯಾವಾಗ ಬೇಕೋ ಅದೇ ಮೆಮೊ ಎಲ್ಲ ಕೊಡ್ತೇನೆ. ವಿಡ್ರಾಲ್ ಟುಮಾರೋ ಯು ಗಿವ್ ದ ಮೆಮೊ, ಇಟ್ ವಿಲ್ ಬಿ ಲಿಸ್ಟೆಡ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಗಿವ್
52 ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕಾಗಿತ್ತು. ಅದಕ್ಕೋಸ್ಕರ
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್.
ಅಲ್ಲ, ನನ್ಗೆ ಬೇಕು, ಐ ಹಾಕಿದ್ದೀನಿ.
ಹಾ,
ಅದಕ್ಕೆ ಡೇಟ್ ಬೇಕು. ಮುಂದಿನ
ಡೇಟ್ ನಾಳೆ ಒಂದು ಮೆಮೊ ಹಾಕಿ ಇನ್ನೊಂದು. ಆಯ್ತು.
Court officer. Serial number 60. Court officer.
ಮಾತ್ರ ಇದ್ದಾರೆ.
I'm in my office, but
Yes, sir.
Sir, serial number 60.
Sir, other
Court Master sir, item number 57.
ಇದ್ರದಲ್ಲ ಇಷ್ಟಿಂದಲ್ಲ ಸರ್ ನಾನು ಬೆಂಚ್ ರೆಡಿ ಮಾಡ್ಕೊಬೇಕು ಸರ್ ಒಂದೊಂದ್ಸಲಿ ಒಬ್ಬೊಬ್ರಿಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ ಈಗ ಬಂದ್ಬಿಟ್ರೆ ನಾನು ಹೇಳಿ ಜಜ್ಮೆಂಟ್ ಇಂದ ಹೇಳಿದ್ರೆ ಅದನ್ನ ಕೇಳೋಣ ಅಂತ
ಸರ್ 68 ಏನಾಯ್ತು ಸರ್?
So 57.
Court officer?
Court officer sir.
ಸರ್ ಹೇಳಿ ಸರ್.
So serial number 57. Date may be fixed, sir.
Adjourn to next week, sir. Matter.
Sir, any date? Sir, I am requesting for a date to be fixed.
You can move the memo. You have the provision to move the memo.
Sir, please, sir, it is very problematic to move the memo every time, sir. Please fix a date.
Court can't give the dates for all the cases, sir. Sorry. Division bench, you can come after division.
Sir, interim orders extend ಆಗುತ್ತೆ ಅಲ್ಲ?
Division bench, matters pertaining to Kalburgi bench. Serial number 1. Raja Venkatappa Nayak. Announcement of order on IA.
ಇಲ್ಲ ಪೆಟಿಷನರ್ ಯಾರು ಇಲ್ವಾ? You are appearing for the petitioner. Appellant. There is no one for the appellant.
My lord, the petition court is not present, my lord.
ಅಲ್ಲಪ್ಪ ಅಪೆಲೆಂಟ್ ಯಾರು ಇಲ್ವಾ?
ಇಲ್ಲ my lord, we have come.
ಬರೀ ಅಯ್ಯತ್ತಾನೆ.
Court officer? Court officer?
ಹೇಳಿ ಸರ್ ಕೇಳಿಸ್ತಿದೆ.
ಇದು ಏನಾಯ್ತು ಪೆಟಿಷನ್ ಏನಾಯ್ತು ಇದು ಗುಲ್ಬರ್ಗ ಬೆಂಚ್ ಇದು?
ಅಲ್ಲ IA for suspension of sentence and bail has been dismissed.
ಆಯ್ತು.
Court officer sir. Court officer sir. Sir, can you hear me?
Serial number?
Sir, serial number 57. Sir, I am appearing from Delhi. I request for a date to be fixed in my matter, sir.
Sir, I can listen you, sir, but in this court, date will not be provided. You have to move the memo. You have all provisions, privileges to move the memo. Whichever date you mention the date, on that day, memo will be, case will be listed. Thank you.
Sir, serial number 68 interim order extend ಆಗಿದೆನಾ?
ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ.
Excuse me. The interim order is also extended for adjourned matters.
Court officer? Serial number 68 interim order extend ಆಗಿದ್ನಾ?